ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಕೂಟಲಿ ಮಾಡ್ತಾ ಇಲ್ಲ ಕೂಟಲಿ ಮಾಡಕ್ಕೆ ಅದ್ಯಾವ ಇನ್ನೊಂದು ಫೋಟೋ ಮೂವ್ ಮಾಡಕ್ಕೆ ಎಲ್ಲೋ ಬೆಳಿಗ್ಗೆ ಒಂದೊಂದು ಅವರ್
ಕೇಳಿಸ್ತಿಲ್ಲ.
ಕೋಟಲ್ 13 ಇಂದ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಓಕೆ ಸರ್.
ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್.
ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಅಲ್ಲಿ ಇದ್ದೀರಾ? ಎಲ್ಲರೂ ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್.
ಹೌದು ಸರ್.
ರಿಜಿಸ್ಟರ್ ಜುಡಿಷಿಯಲ್ ಅವರು ಅರ್ಧ ದಿವಸ ರಜೆ, ನಿನ್ನೆ ಸಂಜೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿದ್ವಿ. ಇವತ್ತು ಒಂದು ದಿವಸ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ ಸಾಹೇಬ್ ಹೇಳಿ.
There's some problem. They will do it from tomorrow. What is that matter? Have you filed an application for posting? No, it is a fresh matter. Friday. Fresh matter. No, Mr. Counsel, fresh matter, not as posted before the court. Fresh. What is that urgency? Next week, next Monday. Yes. You have filed a memo for posting. No. Application for posting has to be filed. No, I think even advocates can file memo for posting. Application for posting. Affidavit enu beda. There is you have to, whatever that there is a format. You have to. Yes, you file it in that office. Wait. Yes, you ask that office what is the procedure. Within 3 days, it will be posted before the court. All pending matters, you have to file an application for posting. Fresh matters, actually, they have to post it 5 days before this court. If there is any urgency, I will take that. Yes. 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 Tomorrow. 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 No. No, pending matters. Have you filed an application for posting? You file it within 3 days, it will post it before the court. Yes. IFR what? You have to file an application for posting. It will be posted before the court within 3 days. Otherwise, I will give in a date in the March, which is better. Court decision. Monday. Monday. Yes. Even FIR filed also, then charge sheet has been filed. Even after charge sheet has been filed, they are filing the case before this. Now that you have to file an application for posting. When you have filed an IFR posting. Posting application has been filed. Verify number perfect. We'll verify if there is an application, then they will post. Yes. Friday. What is that matter? Monday. Friday. Yes.
Page wise adjournment, list number 1, page number 1, serial number 1 to 10.
Serial number 10, my lord.
The request of counsel for petitioner release this matter next week. 2 weeks. Yes, 2 weeks. Yes, 2 weeks. Yes.
Serial number 10. Serial
Yes.
number 10, my lord. I appear for the petitioner, my lord. Kindly 2 weeks time may be granted.
The request of counsel for the petitioner release this matter after 2 weeks.
Much obliged.
Page number 2, serial number 11 to 19. Page number 3, serial number 20 to 24. Page number 4, serial number 25 to 32.
My lord, serial number 29, my lord.
Yes.
I
20.
place 1 week. I place
My
1 week
lord.
time, my lord.
Week
Serial
time
number
is granted.
29.
Yes, comply the top subjects. Yes.
Mulad, serial number
20, my lord.
31, Mulad.
Serial number?
31, Mulad. Matter
Yes.
is covered by judgment, Mulad. Shuram is there, Mulad. I have served copy on him. Annexure D, similar order I have produced, Mulad. Order passed in similar matters. This
Serial
is
number?
acquisition for Lalitadri Nagar second stage, Mulad.
Yes.
After issuing preliminary notification, nothing is done.
Matter.
Mulad. Shuram is there,
Serial
Mulad.
number 20, my lord.
Serial number 20. Yes, madam. What is this?
Office objection by high 2, my lord. So for
Yes.
please granted 2 weeks time.
Yes, at the request of learned counsel for the petitioner, 2 weeks time is granted to do the needful.
My lord,
Yes.
serial number 29, my lord. Serial number
Yes.
29.
Yes.
I place 1 week time, my lord, to comply office objection.
Yes, 1 week.
Serial number 22, your lordship, 2 weeks time will be granted, your lordship.
22, at the request of counsel for the petitioner, 2 weeks time is granted to comply the top subject.
But 31 can be disposed, Mulad. Matter is covered by judgment, Mulad.
30, yes.
This is for Lalitadri Nagar second stage, Mulad. Yes, Mulad.
Serial number 31 time, mister.
Yes, Mulad.
Yes. Yes, weeks time is granted to do the needful. Yes,
Allah,
mister,
you-
31 is.
Allah, it can be disposed, Mulad. 31 can be disposed, Mulad.
Yes. What is this? Yes. ಯಾವುದೋ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇತ್ತಲ್ಲ. Yes, we'll do
Annexure
it when
D I have
matter-
produced, Mulad.
Yes.
Page number 5, serial number 33 to 38.
Yes, your name.
My lord, serial number 29, my lord.
20?
29, my lord.
Yes.
I prayed 1 week time, my lord. to
I the
comply
past
office subjection.
now you are asking third time. Yes.
How much
Page
now?
number 5, serial number 33 to 38.
Serial number 33, my lord. I am for the
Yes.
respondent, my lord.
Yes.
I have to file the objection. 2 weeks time may be granted.
33.
Please, my lord.
Yes, sir. The
Second,
request of,
IA for amendment, my lord. I have taken time earlier also. Please,
yes,
some,
at the request of council for the respondent number 5. Finally, 2 weeks time is granted.
please, my lord. They have not served the copy of the injunction IA number 1. I will take the copy, my lord, from them.
Yes.
Please.
Page number 6, serial number 39 to 42. Page number 7, serial number 43 to 48.
My lord, serial number 47, my lords.
Yes.
My lords, I'm for respondent number 3 and 4, my lords. I place for a week time, my lords, in this matter.
You are appearing for whom?
For respondent number 3 and 4, my lords.
Yes, there is an objection from the petitioner. Wait when the
My
matter
lords, my lords, actually, senior is not available today. That is the reason I'm asking for a time. Next week, maybe it may be taken up, my lords, any day.
Yes, you make this submission when the matter is called.
Please,
We'll
my lords.
make, give
Please,
accommodate.
please.
Page number 8, serial number 49 to 49 and 50.
Yes.
Page number 9, serial number 51 to 58.
53. Yes, madam.
My lord, 53, I appear for the petitioner.
Yes.
As informed, they're taking time. A date may be fixed, my lord, because the objections have still not been filed.
Yes. Yes, at the request of council for respondent. Release this matter on 2nd March. Yes.
Obliged.
My lord, serial number 37.
Serial number?
37, my lord.
Yes.
Appear for the respondent in this matter. My lord, for objection, 2 weeks may be granted, my lord.
37.
Yes, my lord.
Yes, at the request of council for respondent. 2 weeks time is granted to file an objection.
Much obliged.
55. Yes. Yes, at the request of council for, what is that, madam? You want to file an objection? Next week. Yes, the request of council for respondent number 2, release this matter on 2nd March. Yes.
Page number 10, serial number 59 to 62.
Copy is not served. Well, yes, Mr. Serve the copy to him. Yes. Yes. At the request of the parties, release this matter of 2 weeks. Yes.
Page number 11, serial number 63 and 64.
Yes. At the request of council for the petitioner, release this matter of 2 weeks. Yes. Yes.
Page number 12, serial number 65.
My lord, serial number 65 appears for petitioner, my lord.
Yes,
Lord, some inconvenience today, please for some time.
There is an application for vacating.
It is. Please, my lord, I appear for petitioner vacating in IA filed by the respondents, my lord.
Have you informed them?
Please, my lord.
Have you informed?
I have informed, my lord.
Yes, at the request of council for the petitioner, release this matter on 3rd March.
Obliged, my lord.
Yes.
Page number 1, fresh matter, serial number 1, Padmanabha R for petitioner.
My lord, I appear for petitioner, my lord. The petitioner made a representation, my lord, to the respondent. With request to settle the pensionary benefit, my lord. The similarly situated persons cases were considered. My representation is not been considered. Therefore, my lord, I am before this honorable court seeking direction, my lord, to consider our representation in accordance with law.
Yes.
Because of the same, my lord. Similar matters, my lord. Yes.
Yes.
In identical matter, by direction L, this honorable court, my lord, issued a direction to consider our representation. Annexure L, my lord, page 139.
Yes. Who is appearing for respondent in that case?
Only to consider my representation.
Yes, you take out notice, Mr. Yes. Government advocate is directed to take notice for respondent number 1 and 2. 1, 2, and 3. Who is appearing for 3, Mr. Padmanabh, in connected matter?
My lord, I have to ask. Connected matter. No, it was, these matters were disposed of, my lord, the stage of preliminary itself. As
You don't want, no, you have made that third respondent as a party. You don't want to serve.
No, I will serve.
Then I asking who is appearing for the respondent number 3.
I have to ascertain, my lord.
Yes, issue emergent notice to respondent number 3. Learned counsel for the petitioner is directed to serve 3 set of writ petition copy and government advocate. Yes. Yes, Mr. Yes. Yes. Is it not you have to go before the company court? I think now that NGF is wind up. But you have to go before that company court for all your benefit, is it not? Now, Mr. You verify whether you can approach this court or you have to, is that company matter is pending? Have you verified? NGF. No, that is what I am asking. If it is matter is pending before the company court for that, then all employees and that all stakeholders has to approach the company court, is it not? Who should? No, that is true, Mr. Have you verified that? You verify? Yes, I will have it on 28 to verify that. First, whether see if it is writ is maintainable, whether you have to go to that company court, then we can issue. Otherwise, why you have to issue? Verify that. Yes, 28. Yes.
Number 3, Prithvish MK for petitioner.
Yes. 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 What is that order they are implementing? Withholding of 4 annual increments if cumulative, and withholding of promotion for a period of 2 years, 4 years. Under the penalty, only one penalty can be imposed. Formula assuming one misconduct, there cannot be 2 penalties again. I'm relying upon the most yes. Categorical contention is taken that it is BBMP to the employer. Therefore, it can be the commissioner who can pass the order. The government there is no jurisdiction. Now that they are passing an order for recovery. So, which is the 37. No, where is that implementation of that order? It's not at you take out notice. See, it is 2020. Yes. 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 Yes.
Basic pay was 52,650.
Yes.
Page M1, page 71.
Yes.
This is the salary schedule for the month of January 2021.
Yes.
Where I was granted the benefit of annual increment.
Yes.
753,980. This annual increment was granted to me after the improved order.
Then now where is that recovery?
They told for the month of January 2022.
They have not paid that. Yes. That we'll see that who is appearing for.
Now, they cannot report and they cannot report my promotion since it is not in the jurisdiction.
Yes. Yes.
Taken up the contention. The contention was taken. It is only the government who can do it. Local came to a lot of different. Government cannot do it. It is only the commissioner.
Yes.
Accepting the contention. Court must that the government has
No. That is that for entrusting that inquiry.
Yes,
By the,
and in so far as the
Impos-
commissioner, latest recruitment.
yes. Is there any standing counsel?
BBMP, I am a dictator. TM notice.
Have you served that notice to anybody? No, now the rule is that you have to serve the copy advance. Yes, government advocate is directed to take notice for respondent number 1. Arbati is directed to take notice for respondent number 2. K.N. Puttegoda is directed to take notice for respondent number 3. Burnett counsel for the petitioner is directed to serve one set of copies on respective counsel. We'll issue this matter on 2nd. Now that immediate threat, see all that cases where that prosecution permission has been given, we have stayed because threat is that they are going to start for an inquiry. Here there is no immediate threat. Therefore, that's what that now you are asking from them. Therefore, I am posting this matter on 2nd. Let them say if there is any process for promotion, then we'll ask them to, without giving effect to that, consider your. Yes. That will see. That will see you are entitled for that relief for. No, see, Mr. Counsel, this impugn order has been passed in the year 2020. Therefore, I said that issue notice because it is already on 2 years is over. Yes. Now that, in view of that, if there is any immediate effect, that it can be stayed. Otherwise, matter has to be heard, and finally, if you succeed, you will succeed further. That's what that now we have posted for on to see that is there any promotion is to be going to give an effect. That's what. Yes. On 3rd, if that is the material, you place this material before the court. On 3rd also. Yes. 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 Post this matter on 2nd for consideration of interim pay. Yes.
Number 4, Ravindranath K.
Yes, Ravindranath K.
Lord, appear for petition in this case.
Yes.
Lord, your honor may kindly turn to page 14, my lord, annexure A.
Yes.
Lord, this is appointment order to the petitioner by the respondent, my lord, as a legal assistant on 3/8/2015.
Yes.
Lord, it is I sought for a mandamus in this case. Lord, yes. Kindly turn to page 15, my lord. Terms and condition part 2, my lord. Page 15. Terms and condition in the below, my lord. Second one.
Yes.
They shall be for 2 years from the date of the joining of the duty, and they should pass prescribed departmental examination within 2 years. So this all the formalities which has been prescribed in the Lord appointment order has been completed. Lord, yes. Till now, Lord, his service is not confirmed by the Lord by the board. Yes. Lord, he has given the representative as per annexure M, page 51, my lord.
Yes.
Page 51.
Yes.
request to declare my probationary period and fixation of pay regarding. Page number 51, Annexure M. Lord, now we are in 2022 because appointment is in the 2015. So as per their condition, 2 years is a probationary period. Lord, till now, because similarly situated employees who are appointed on the same Lord, they've already, as per the annexure K5K to K6, they've already appointed, Lord. Page number 25. 25 to Lord 30. Similarly, were all appointed on the same day. Lord, along with the petitioner, their service were confirmed.
Yes, issue emergent notice.
Lord, I may be permitted I may be permitted to take out the notice on the Lord, the board advocate, so Mr. Syed Imran.
Is there?
Yes, my Lord, he is a panel advocate. He
Is
is a panel advocate. He is a panel advocate. Panel advocate.
What is his name?
Syed Imran.
Syed Imran. Syed Imran is directed to take notice for responding. Learned counsel for the petitioner is directed
The
to
short
serve.
question is date.
Yes, you serve it and move.
No,
Yes.
I'll do it, my Lord. You are asking me to fix the date. I'll serve it definitely. Today itself, sir. Date may be fixed because mandamus.
2 weeks. Yes. Release this matter after 2 weeks. Yes.
Lord, date. Not date.
Birth. Yes.
Date, my Lord. Date.
On 15th March.
Much of it.
Yes. For what, mister? Now, how you can maintain a writ against that private company? Already, Jindal Aluminium is in a private company. How can you maintain the rate? No, whatever may be things. Jindal is a private company. It is not a state. How can you maintain the rate? No, how that writ is maintainable? If there is no, it is not in a state. How can that writ issue? No, for that purpose, notice cannot be issued, mister. Writ is not maintainable. Is it not in a private company? Then how can? That is true. Now, what you want? Whether you want to withdraw or you want to pass an order. No, before issuing the notice, you have to satisfy the court, is it not? Then, yes. No, even if it is bylaw is there, what will make a difference? ಅದಕ್ಕೋಸ್ಕರ writ ಆಗ್ತೀರಾ? No, that is different, mister. Jindal Aluminium Company is in a, then how can you maintain the writ? How can you maintain the writ, mister? Even if you have a bylaw, that will not make any difference. ಅದಕ್ಕೆ writ notice can be issued under which law? Now, to issue a notice, you have to make out a case, mister. How do you make it? How can we make, mister? Then if you want to withdraw or you want to pass an order. For what purpose, mister? Third. This writ petition. Yes. Learned counsel for the petitioner is seek leave of this court to withdraw this petition. Hence, dismissed as withdrawn. That is there. You go there. Yes. No, now this is a new trend. In respect of the private company, it has been filed for seeking for an appointment of compassionate. That is not the ground, mister. You can't make such a submission before the court. Yes.
Yeah, for petitioner, my lord. Yes. My lord, petitioner's lands were acquired for the formation of my lord veterinary medical college in Assam, my lord. My lord, they have consented for the above said acquisition proceedings, my lord.
Yes.
My lord, the consent award has been passed and amount has been paid, my lord. My lord, in respect of some other petitioners who have challenged the my lord, land acquisition of the land, my lord. Yes. The land acquisition court has been awarded more amount, my lord. Therefore, my lord, the petitioner submitted a representation under section 28A of the Land Acquisition Act, wide annexure D, page number 85, my lord. Annexure D, page number 85.
Have they passed any order?
No, my lord, they have not passed. They have stated, they straight away rejected my application, my lord.
When you have filed on a 28A?
28A, my lord, my lord, date 29/8/2019, my lord.
When is
Within
that
the
order
time.
of that?
Within the time, my lord, within the time only.
Yes, no
8th
order has
July
been passed.
2019.
What annexure H? ಭೂ ಸ್ವಾಧೀನ ಸಂಸ್ಥೆ 2 ಜಮೀನಿಗೆ ಅದರಂತೆ
HSD, my lord, endorsement.
ಈ ಕಡೆ ನಿಮ್ಮ ಅರ್ಜಿಯನ್ನು ಪರಿಗಣಿಸಿ ಸಾಧ್ಯವಿಲ್ಲವೆಂದು. Yes, Mr. They have passed an order.
Yes, my lord. Annexure H, J and K, my lord.
Now, if order is passed under 28A, then you have to go to that civil court. That is what the judgment of this court, Mr.
My lord,
It is not maintainable.
my lord, now on merits it was not rejected, my lord.
That is what that. This is what any order is passed. This is a determination of the compensation.
Yes, my lord.
You have to approach that civil court, land acquisition court for that enhancement. That is what the judgment of this court.
But my lord, under the Land Acquisition Act, my lord, no appeal is provided.
Not
Expressly,
appeal,
no appeal is provided, my lord.
It is like an 18 reference. All procedure under 18 has to be followed. After that, 28A is rejected.
If such is the case, my lord, with such liberty, my lord, I may be permitted to, my lord, prosecute.
Yes, learned counsel for.
My lord, if the judgment is there, my lord, I will go through the judgment and.
You have to verify and make it, Mr. Is it that court has to assist? What is this, Mr.? Want to verify and see? I will grant time till Monday.
Yes. Monday ತನಕ ಕೊಡಿ. I will.
At the request of counsel for the petitioner, release this matter on Tuesday. Yes.
Matter serial number 7, Srikanth BS for petitioner.
You search Mr. Justice Abdul Nazir's judgment is there. In 28A, if the order is passed, then they have to go to that. Yes. You have to place that judgment. It is not the court has to make. Yes. Yes. Serial number
7, sir.
Yes. Srikanth BS. None appear for the petitioner. Release this matter of 2 weeks.
Serial number 8, serial number 9, Telecast R for petitioner. Serial number 9.
Yes, Jai Prakash. None appear for the petitioner. Even on last occasion is also none appear. Release this matter of 4 weeks.
Serial number 10 again. Serial number 11.
Yes. One time. Yes. At the request of counsel for the petitioner, release this matter next week. Yes, next week. Shivaraju MK. Yes, Mr. Yes. Yeah. Yeah.
Again, continuously, this happened in 86 filing also.
Developed land.
BDN 2018. What responsibility? Nothing is happening. I'm going back to the meeting application.
Yes, issue notice. Government advocate is directed to take notice for 1 and 2. 3 and 4. Who is their BD? K. Krishna. K. Krishna is directed to take notice for respondent number 3 and 4. Learned counsel for the petitioner is directed to serve 2 sets of writ petition copy and government advocate, 2 sets and K. Krishna. Yes, Mr. Hasan, it is verified. You have taken his land and nothing else. We will have it on 14th March. Yes. This matter on 14th March.
13, Suman K for petitioner.
Yes. 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 Okay. Now, page number 16. Answer B. Now, which is that column you are reading? Yes. 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 Issue notice. Government advocate is directed to take notice for respondent number 1. Issue emergent notice to 2 and 3. Now 3 is also state. No, respondent number 1 and 2 is state representing. State, that's what I am asking. Yes. Government advocate is directed to take notice for respondent number 1 and 3. Issue emergent notice to respondent number 2. Learned counsel for the petitioner is directed to serve 2 sets of writ petition copy and government advocate. Yes.
For petitioner.
Yes. Yes. For what amount? Yes. Yes. Mm. Yes. Yes. Mm. Yes. 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 Mm. Yes. Interest is not this one. Yes. Yes. Who is there? You notice. Anybody is there? BDM, junior. Yes, what is your name? Yes. HT Basuraj is directed to take notice for respondent number 1 and 2. Learned counsel for the petitioner is directed to serve 2 sets of copies on. You verify, mister. There is already an order to pay with that interest. You get copy kodi avri. 2 weeks. Real estate matter of 2 weeks. Yes, sir. Copy, Basuraj.
For petitioner.
Yes. 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 Hmm. Yes. Ink page 25. Hmm. Yes. Hmm. They have approved for suspension. Which order? Annexure B Allah. After that approval of that commissioner, they have been communicated to you. That's what that. Order ne approve anta bariyadilla. Anumodane alla. Anumodane mandiside. Then he has signed. That means to say it has approved anta. Hmm. No, that after that they have placed that before the committee commissioner. Yes. Who is there for BBMP? Any council? Let us see that. Yes. Is there any council for BBMP? Yes. Check out Putagoda. Yes. Issue notice. Ken Putagoda. Ken Putagoda is directed to take notice for respondent number 1 and 2. Learned counsel for the petitioner is directed to serve 2 sets of copies on Ken Putagoda. Release this matter on 3rd. Yes. Let us see whether it is approved or not. We'll let them produce that.
Serial number 16, searching PS for petitioner. Serial number 16.
Yes. Yes, at the request of counsel for the petitioner, release this matter of 2 weeks. No, you do it in the office. Yes. I have granted time.
17, Sampath A for petitioner.
On submission, my lord.
Yes.
My lord, in this case, I have filed a wakalat for 3rd respondent, my lord. My name has not been shown, my lord.
Yes, yes, we'll consider. Yes. No. Yes. Annexure? Yes. $44. Yes. 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 Oh, you are Radhakrishna. You have been. Now, where you are working? Bangalore, BIAL, Begur. Begur. Yes. 45. 23rd, 12, 2021. Yes. Actually, yes. 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 That, yes. Page. Page. Yes. 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 Okay. Yes. 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 Page. Yes. 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 Yes, Mr.
Lord, but firstly, my lord, the order dated 23/12/2021, my lord, was never implemented.
Yes.
Therefore, it was been modified, my lord.
That cannot be.
My lord, since it is not been implemented.
Not implemented alive. That order has been passed and signature has been made that this is a transfer order.
Lord, yes, my lord, but there is a judgment, my lord, where it says when the order is not implemented, it is subject to modification, my lord. There is a judgment, my lord. I'll furnish that judgment.
No.
If the order is not implemented,
Yes,
if the order is not implemented, then, my lord, it can be subject to modification, my lord. That is one thing, my lord. Secondly, my lord, by an order dated 9/7/2013, my lord, the order of government order dated 7/6/2013 has been modified, my lord, giving relaxation to the transfers of the office bearers of the association, my lord.
Yes.
The third respondent falls under the office bearer, my lord. He is elected treasurer of the association, my lord. On that ground, my lord, the order has been modified.
Yes. Third.
My lord, third, he has not made the person who has passed the order as party to the proceedings, my lord. We kindly see page 13, my lord.
Yes.
Director of Admin and HR, my lord, is the competent authority. He has not been made as a party to the proceedings, my lord. Page 13, my lord. Page 13.
Yes. Who has
The order impugned. The
Yes.
order is passed by Director, Admin and HR of KPTCL, my lord. He is not a party to the proceedings, my lord.
Why, Mr. You are not letting me? Yes. No, you don't rely on that others this thing, Mr. Who is that person who has passed an order? He should be made as. Okay. You are taking notice. Yes. Yes. What's your name? Huh? Yes. Sri Vijay Kumar, Learned Council, is undertaken to appear for respondent number 3. So and so is undertaken to appear for respondent number 1 and 2. Bangalore Electricity Supply, who is appearing? Well, yes. Oh, respondent number 1. Issue emerald notice to respondent number 2. Who is there for response? Huh? Chandruchud. Yes. Chandruchud. Yes. Chandruchud is directed to take notice for respondent number 2. Learned Council for the petitioner submit that by order dated 23/12/2021, petitioner has been transferred to petitioner has been transferred from BIAL Begur Center to which place? Subdivision S10 subdivision Hulimau, subdivision Hulimau. Thereafter, the petitioner has requested the respondent to issue a movement order to take in charge. Instead of issuing that movement order, they issued an impugn annexure A and withdraw the transfer order. In support of his contention, he has relied on judgment of this court in identical circumstances. This court has passed that similar order passed by the respondent. In view of the above, the impugn order annexure A dated 21 January 2022, writ petition number 8952 of 2021 disposed of on 10th November 2021. In view of the above, the impugn order annexure A is stayed in respect of the petitioner till next date of hearing. When do you want me time, Mr. Rayu?
Lord, next Monday, my lord, I'll file my objections.
Yes, release this. Yes, sir. Yes, respondents has pressed 2 weeks time to file an objection. Release this matter on 2nd.
Please.
Yes. Don't take charge. They will pay the salary. Even after this order, they have not given a movement order. You are entitled for salary.
Number 18, Vijay Kumar.
Lord, I am for the petitioner, my lord.
2nd March. Yes. They want to file an objection. We'll consider the finally on that.
I am for the petitioner, my lord.
Yes, serial number?
Serial number 18, my lord.
Yes, yes. Yes, Mr.
Lord, petitioner is in the cadre of executive engineer, my lord, by an order dated 10/1/22, my lord, page 33.
Yes.
Lord, he was posted to work as deputy general manager, my lord, energy audit, my lord, by an order dated 10/1/22.
What is your name?
My lord, my name is Basavaraj BHB. Serial number 1.
Yes.
My lord, page 35, my lord, I took charge on the same day, on 12th January 22.
Yes.
My lord, now by the implemented order, my lord, I have been transferred to Hubballi, my lord, within a span of 1 month, my lord.
Yes. Where is that order of transfer?
Order is at page 38, my lord.
Yes. 38.
Serial number 4, my lord.
4. Then now you have been transferred to
Hubballi, my lord.
Yes. Shri. Notice.
It's a premature transfer.
Issue emergent notice to. Is there any council? Karnataka Power Trans KPTCL. Yes. Chandrachud is directed to take all that Bangalore Electricity Supply Company and all. Yes. He is directed to take notice for respondent number 1 to 4. Issue emergent notice to respondent number 5. Then a council for the petitioner has submitted that. By order dated 11/2/2022 by Annexure J, the petitioner has been transferred. Now, which is that first order?
Lord, first order is 10/1/22. That is at page F,
Yes,
my lord,
10/1.
33.
On 10/1/22, by Annexure F, the petitioner has been transferred to, which is that place?
Lord, to Deputy General Manager, Energy Audit, Bescom, Bangalore, my lord.
Bescom, Bangalore. Operation Company Karyalaya has been transferred as a Deputy General Manager.
Yes, my lord.
Deputy General Manager, Bescom, Bangalore. After short span of time, he has been again transferred from Bangalore to Hubli by impugn order, Annexure J, dated 11/2/2022.
My lord.
Yes.
Kindly see page 39, my lord. Now, after I having been transferred, my lord, the 5th respondent is being posted by another order, my lord. This order also needs to be stayed, my lord.
Oh, he has been transferred to which place? Your
To
place.
my place, my lord.
Yes, yes. A petitioner by a order, he has been transferred to Hubli by 11/2/2022. And 4th respondent has been transferred.
5th respondent
has been transferred to petitioner place, that is Bangalore, wide Annexure K. Hence, he sought for stay of Annexure J and K in respect of petitioner and 5th respondent is concerned. In view of the above, there should be an ad interim order, stay of Annexure J and K in respect of petitioner and 5th respondent till next date of hearing. Yes. Every day, minimum 3 to 4 cases in respect of KPTCL. Where is that? No council is there.
Order serial number 19, Ranganatha advised for petitioner, Chandrakant Nargode.
Lord, I appear for the petitioner. This matter was specifically fixed for today, my lord.
Yes.
That is covered by decision. State the facts.
I appear for respondent, my lord.
Yes, Mr.
My lord, kindly see.
Yes.
My lord, Annexure A.
Yes.
Page number 11, my lord.
So that is a
appointment order. Yes, yes, exactly.
Yes.
I will state within 5 minutes. I will state the fact.
Yes,
as per
yes.
Annexure A, on 23/4/2010, the applicant was a petitioner was appointed.
Yes.
My lord, as the assistant professor, serial number 2, Dr. Naveen KH, my lord.
Yes.
He was put on probation for a period of 2 years. First condition will be on probation for 2 years, my lord.
Yes.
Then until confirmation, so on. Then, my lord, the annexure B on 17/10/2012.
Yes.
The probationary period was declared as successful, my lord.
Yes.
Serial number 2.
Yes.
ಕಾಯಂಪುರ ಸೇವೆಯನ್ನು ತೃಪ್ತಿಕರವಾಗಿ ಪೂರೈಸಿರುವ ದಿನಾಂಕ 37/12.
Yes.
Then, my lord, the period of probation was also declared, my lord. And kindly see, earlier, my lord, about 80 days, it was alleged that he was absent. That period has been regulated. Kindly note below, my lord, note below. ವಿಶೇಷ ಸೂಚನೆ ಕ್ರಮ ಸಂಖ್ಯೆ 2 ಡಾಕ್ಟರ್ ನವೀನ್ ಸಹಾಯಕ ಪ್ರಾಧ್ಯಾಪಕರು ಸೋನ್ಸೋ ವಿಭಾಗ 18/10 5/1/11 80 ದಿನ ಗೈರು ಹಾಜರಾಗುವುದು 11/5/12 ಘೋಷಿಸಬೇಕಾದ ಕಾಯಂ ಪೂರ್ವ ಅವಧಿಯನ್ನು 80 ದಿನಗಳ ಮುಂದೂಡಿ 30ಕ್ಕೆ ಘೋಷಿಸಲಾಗಿದೆ. During that period, the period was actually it should have been declared from 12/5/2012, but it was postponed to 30th July 2012.
Yes.
So the fact is that from 30th July 2012, my probation has been declared as successful.
Yes.
In the meanwhile, there was a notification calling for posts in the assistant professor in All India Institute of Medical Sciences, Jodhpur, Mela.
Yes.
For which I submitted a representation as per Annexure C to the present management.
Annexure?
Director, Annexure C, page number 13.
Yes.
On 9/2/2016, requesting that I have to submit the application, so give the experience certificate so that I can apply for the post in the other institution, which is All India Institution Medical Sciences at Jodhpur. I would like to attend the interview for the above mentioned post at All India Institute of Medical Sciences, Jodhpur on 16/2/2000. I request you to kindly issue no objection certificate for the same. Then, my lord, Annexure D, the college issued the no objection certificate on 11/2/2016.
Yes.
This is certified that Dr. K.H. Naveen, assistant professor working in the Department of Community Medicine, so-and-so, has attended the interview so-and-so to be held on so-and-so. Then, my lord, an order of appointment, I have attended the interview. Appointment order was issued from the Jodhpur on 21/4/2016, Annexure E. Annexure E dated 21/4/2016 is the appointment order issued by the All India Institute of Medical Science.
Yes.
Page number 15, Annexure E.
Yes.
According, before that, I have to resign the post in the present institution, namely medical institution. Page
Yes.
number 21, Annexure E.
Yes.
Dr. Naveen so-and-so to the director and dean so-and-so. Resignation to the post of assistant professor, issue of receiving order and experience certificate for character. With reference to the above subject, earlier I had submitted application on 17/6/2002 because of some personal reasons. It was withheld. Now I have been given extension to join for the post of assistant professor, Jodhpur. Hence, I request your kind self to relieve me on the afternoon on 19/5/2000. I have to report at 22/8/2000. Kindly oblige.
Yes.
So, on the left side,
Yes, Mr. Mute ಆಗಿದೆ ಅಲ್ರಿ?
ಸರ್ ಮೈಕ್ ಮ್ಯೂಟ್ ಆಗಿದೆ.
Yes. Your voice is
am I
not
audible, my lord?
Now
Am I
it's
audible, my lord?
Yes, yes.
It's ಸ್ವಲ್ಪ mute ಆಗಿ. My lord,
Yes.
kindly see Annexure G. I was relieved on 19/8/2016, my lord.
You
Page
read
number
Annexure
20. ಯಾವುದು?
You read Annexure G. Yes.
Yes, with reference to the above subject, Dr. K.H. Naveen, Assistant Professor Community Medicine so-and-so, has submitted his resignation on personal ground. He is relieved from the duties on the 19/8. My representation is 19/8, my lord. Kindly note the representation 19/8. That 19/8 is Annexure F, which just now I read, saying that I want to join the duty at Jodhpur where I have been selected. So relieve me here. This is my request for which he has been relieved.
Yes.
Then, my lord, I reported at All India Institute of Medical Sciences, Annexure H.
Yes.
That is on 2/9. Dr. Naveen K. appointed as assistant professor in the Department of Community Medicine, so Jodhpur, with effect from 4 noon 29/8/2016. I will be on probation. So in that institution, I was put on probation because I reported on 29/8/2016. Then, my lord, your lordship, on 16/9, Annexure J, within a short period, I reported at Jodhpur on 29/8/2016. And from thereafter, for some reasons, on 16/9 itself, Annexure J, page number 25, I made one more representation saying that I went to Jodhpur, but I want to come back because certain atmosphere there, he did not, was keen, and his family, his wife was here. And for those reasons, he wanted to rejoin the duty at Bangalore only, Mysore only. So he made a representation on 16/9/2016, Annexure J.
16/9/2016. It is a short of 1 month.
Last one short, 1 month ginta kadmene vapas bandu. Requisition for withdrawal of resignation to the post of assistant professor in department so and so. With respect to above subject earlier, I had submitted my resignation letter to the post of assistant professor on the Department of Community, letter dated 19/8. Due to unavoidable circumstances in the family, and I would like to withdraw my resignation. Hence, I request you kindly to do the needful to withdraw my resignation, and I permit me to rejoin my duty in the department at the earliest in the same position. I will not repeat this in future. I will carry on my duties to the best of my knowledge, so and so, because the institution has been put to hardship because of his going. So he made this representation. Then, my lord, one more representation made on 26/10, my lord, Annexure R. Annexure K.
Yes.
ಸಹಾಯಕ ಪ್ರಾಧ್ಯಾಪಕರ ಹುದ್ದೆಗೆ ಇದನ್ನ ಗವರ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ because the Department of Medical Education at the government level is the head of under which the institution functions. Therefore, he also gave a letter to the government secretary, page number 27, Annexure R, K. ಈ ಸಹಾಯಕ ಪ್ರಾಧ್ಯಾಪಕರ ಹುದ್ದೆಗೆ ನೀಡಿದ್ದ ರಾಜೀನಾಮೆಯನ್ನು ಹಿಂಪಡೆದು ಕರ್ತವ್ಯಕ್ಕೆ ಪುನಃ ಹಾಜರಾಗಲು ಅನುಮತಿ ಕೋರಿ ಪತ್ರ. ನಾನು MICRPI ಕಮ್ಯುನಿಟಿ ಮೆಡಿಸಿನ್ ವಿಭಾಗದಲ್ಲಿ ಸಹಾಯಕ ಪ್ರಾಧ್ಯಾಪಕರಾಗಿ ಮೇ 2010ರಿಂದ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತೇನೆ. 2016ರಲ್ಲಿ ವಿವಾಹವಾಗಿರುತ್ತೇನೆ. ನಂತರ ನನಗೆ ಅಖಿಲ ಭಾರತೀಯ ಆರ್ಯ ವಿಜ್ಞಾನ ಜೋಧಪುರ್ ರಾಜಸ್ಥಾನ್ ಸಹಾಯಕ ಕೆಲಸ ಸಿಕ್ಕಿತ್ತು. ಮನೆಯ ಕೆಲವೊಂದು ಪರಿಸ್ಥಿತಿಗಳಿಂದ ಮತ್ತು ಹೊಸದಾಗಿ ವಿವಾಹವಾದರೆ ಸರಿಯಾದ ನಿರ್ಧಾರ ತೆಗೆದುಕೊಳ್ಳಲಾಗದೆ ಗೊಂದಲದಲ್ಲಿ ಇದ್ದೇನೆ. 2 ಬಾರಿ ರಾಜೀನಾಮೆ ಅರ್ಜಿಯನ್ನು ಕೊಟ್ಟು ಹಿಂಪಡೆದಿದ್ದೇನೆ. ನಂತರ ಯಾವುದೋ ಒಂದು ಅನಿರೀಕ್ಷಿತ ಸಮಯದಲ್ಲಿ ಮತ್ತೆ ರಾಜೀನಾಮೆಯನ್ನು 19/8/16ರಂದು ರಿಲೀವ್ ಮಾಡಿಕೊಂಡು ಏಮ್ಸ್ ಜಾಧ್ಪುರ್ ಹೋಗಿ ಕೆಲಸಕ್ಕೆ ವರದಿ ಮಾಡಿಕೊಂಡಿದ್ದೇನೆ. ಆದರೆ ಜೋಧ್ಪುರದಲ್ಲಿ ನಾನು ಶ್ರೀಮತಿಯವರ ವಾತಾವರಣ ಸರಿ ಹೊಂದದೆ ಆರೋಗ್ಯದ ಮೇಲೆ ಪರಿಣಾಮ ಬೀರಿತು. ನಂತರ ನಾನು ವಾಪಸ್ ಬಂದು ಮಾನ್ಯ
Yes, it is again muted, Mr.
16/9/2000 I have reported. ಆದರೆ ಇದುವರೆಗೂ ಮಾನ್ಯ ನಿರ್ದೇಶಕರಿಂದ ಯಾವುದೇ ರೀತಿಯ ಲಿಖಿತ ಪ್ರತ್ಯುತ್ತರ ಬಂದಿರುವುದಿಲ್ಲ. ಯಾವುದೋ ಒಂದು ಅಹಿತ ಗಳಿಗೆಯಲ್ಲಿ ನನ್ನ ಈ ನಿರ್ಧಾರದಿಂದ ತುಂಬಾ ತೊಂದರೆ. After that, my lord, they did not accept my duty report. I made repeated representation when endorsement was issued, Annexure L, page number 31.
Read that.
ಹಿಂಬರಹ ಡಾಕ್ಟರ್ KH ನವೀನ್ ಹಿಂದಿನ ಸಹಾಯಕ ಪ್ರಾಧ್ಯಾಪಕರು PSM ವಿಭಾಗ ಅವರ ರಾಜೀನಾಮೆ ಅಂಗೀಕರಿಸಿದ ಬಗ್ಗೆ ವೈದ್ಯರ ಮನವಿ 19/8. ನೆಕ್ಸ್ಟ್ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ 19/8 ಮನವಿ ಯಾವುದು ಅಂದ್ರೆ ನನ್ಗೆ ಜೋಧ್ಪುರ್ ರಿಪೋರ್ಟ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳೋದು. 24/8 ಯಾವುದು ನಮ್ಮನ್ನು ರಿಲೀವ್ ಮಾಡಿದ್ದು ಅಕ್ಸೆಪ್ಟಿಂಗ್ ಅಂಡ್ ಸದರಿ ಹಿಂಪಡೆದಿದ್ದು 19. ದೀಸ್ ಆರ್ ದಿ 3 ಸೀರೀಸ್ ಆಫ್ ಇವೆಂಟ್ಸ್. ಈ ಸಂಸ್ಥೆಯ P&SM ವಿಭಾಗದಲ್ಲಿ ಡಾಕ್ಟರ್ KH ನವೀನ್ ಹಿಂದಿನ ಸಹಾಯಕ ಪ್ರಾಧ್ಯಾಪಕರು ಸ್ವಂತಾದ 19/8/16ರಂದು ಸ್ವಂತ ಕಾರಣದ ಮೇಲೆ ರಾಜೀನಾಮೆಯನ್ನು ಅಂಗೀಕರಿಸಲು ಕೋರಿರುತ್ತೀರಿ. ಆದ್ದರಿಂದ 19/8/16ರಿಂದ ಅನ್ವಯವಾಗಿರುವಂತೆ ಈ ಸಂಸ್ಥೆಯಿಂದ ಬಿಡುಗಡೆ ಮಾಡಲಾಗುತ್ತೆ. ಉಲ್ಲೇಖ 3ರಲ್ಲಿ ರಾಜೀನಾಮೆಯನ್ನು ಹಿಂಪಡೆದು ಕರ್ತವ್ಯಕ್ಕೆ ಪುನರ್ ನೇಮಕ ಕೋರುತ್ತೀರಿ. ಆದರೆ ನಿಮ್ಮ ಮನವಿ ಮೇಲ್ಕಂಡ ರಾಜೀನಾಮೆಯನ್ನು ಅಂಗೀಕರಿಸಿದ ಕರ್ತವ್ಯ because your resignation is accepted, it can't be accepted. Then, my lord, that is why matter was taken to the government. Now, kindly, correspondence went on between the government and the institution. Kindly see the government letter, Annexure P, page number 36.
Yes.
What government said in respect of this, page number 36, Annexure P.
Yes.
ಡಾಕ್ಟರ್ ನವೀನ್ ಸಂಸ್ಥೆಯ ಸಹಾಯಕ ಪ್ರಾಧ್ಯಾಪಕರ ಹುದ್ದೆಗೆ ನೀಡಿದ ರಾಜನ ಹಿಂಪಡೆದು ಕರ್ತವ್ಯಕ್ಕೆ ಪುನಃ ಹಾಜರಾಗಲು ಅನುಮತಿ ಕೋರಿರುವುದು. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಉಲ್ಲೇಖ ಪತ್ರ ಹಾಗೂ ಅದರೊಂದಿಗೆ ಅಡಿಗಳನ್ನು ಇದರೊಂದಿಗೆ ಲಗತ್ತಿಸಿದೆ. ಸದರಿ ಪತ್ರವು ಸ್ವಯಂ ವೇದ್ಯವಾಗಿದ್ದು, ನವೀನ್ ಅವರು ಈ ಹಿಂದೆ ಮೈಸೂರು ವೈದ್ಯಕೀಯ ಕಾಲೇಜಿನ ಸಹಾಯಕ ಪ್ರಾಧ್ಯಾಪಕರ ಪುನಃ ಹುದ್ದೆಗೆ ರಾಜೀನಾಮೆಯನ್ನು ನೀಡಿದ್ದು, ಸದರಿ ರಾಜೀನಾಮೆಯನ್ನು ಹಿಂಪಡೆದು ಕರ್ತವ್ಯಕ್ಕೆ ಪುನಃ ಹಾಜರಾಗಲು ಕೋರಿದ್ದಾರೆ. ಈ ವಿಷಯದಲ್ಲಿ ಸಂಸ್ಥೆಯ ಬಯಲಾದನ್ವಯ ಹಾಗೂ KCSR ನಿಯಮ 252B ಅನ್ವಯ ಸ್ಪಷ್ಟ ಅಭಿಪ್ರಾಯ ಮಾಹಿತಿಯನ್ನು ಸರ್ಕಾರಕ್ಕೆ ಸಲ್ಲಿಸುವಂತೆ ಕೋರಿರುತ್ತೇವೆ. So government wanted details as to under Rule 252B. The other day I read the 252B case. For 1 minute, your lordship, kindly take the KCSR 252B. That day I read it, but I cast up reputation. Let me be on that.
Yes.
250T relates to resignation, but 252B is an exception saying that under certain circumstances, the resignation cannot be construed as a resignation disentitling the discontinuation of service. Kindly see B, my lord, 252B.
Yes.
Resignation of an appointment. Yes, my lord. Small b, 252 small
Yes,
b. Resignation of an appointment to take up with proper permission another appointment, whether permanent or temporary service, in which counts in full and not a resignation of public service. So you examine under this rule 252 and take a decision. That's what the government said, my lord. And the matter was sent to the government, page number 37. Page number 37 of the repeated papers.
Yes.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಡಾಕ್ಟರ್ ನವೀನ್ KH ಅವರ ಮನೆ ಸಂದರ್ಭ ಸದರಿ ಹಿಂದೆ ಮೈಸೂರು ವಿದ್ಯಾಸಂಸ್ಥೆಯಲ್ಲಿ ಸಹಾಯಕ ಕರ್ತವ್ಯ ತಮ್ಮ ಹುದ್ದೆಗೆ ರಾಜೀನಾಮೆಯನ್ನು ಪಡೆದು ಸದರಿ ರಾಜನ ಹಿಂಪಡೆದು ಕರ್ತವ್ಯಕ್ಕೆ ಪುನಃ ಹಾಜರಾಗಲು ಕೇಳ್ತಾರೆ. ಈ ವಿಷಯವನ್ನು ಬಯಲಾದ ತಿಳಿಸಲಾಗಿದೆ. ಡಾಕ್ಟರ್ ನವೀನ್ KH ಸಹಾಯಕ ರಾಜನ ಹಿಂಪಡೆದು ಪುನಃ ಹಾಜರಾಗಲು 250 ಸ್ಪಷ್ಟವಾದ ವಿವರಣೆ ಇದ್ದು, ಅದರಂತೆ ಪರಿಶೀಲಿಸಿ ತಮ್ಮ ಅಂತರದಲ್ಲಿ ತಗೊಳ್ಳಿ. ಅಂದ್ರೆ ಗವರ್ಮೆಂಟ್ ಸೈಡ್ 252 ಒಳಗೆ ಪ್ರಾವಿಷನ್ ಇದೆ, ಅದ್ರ ಪ್ರಕಾರ ತಮ್ಮ ಹಂತದಲ್ಲೇ ಡಿಸಿಷನ್ ತಗೊಳ್ಳಿ ಅಂತ ಹೇಳಿದ್ರು. ಆದ್ರೂ ಇನ್ನೂ ಅದುವರೆಗೂ ತಗೊಳ್ಳಿಲ್ಲ. Then my lord, kindly see, now come to the legal position on this. The officer went, resigned, and thereafter took up an appointment. A memo filed on 30th June 2021, my lord, along with the judgment.
Yes.
In the case of Dr. Arundhati, my lord, that day I was reading this, my lord. Kindly come to page number 3 of the said judgment, para 4.
Wait. Yes, mister.
My lord, page number 3 of the Arundhati case judgment, para 4, my lord.
Yes.
Para 3, I will read from para. Petitioner state that on 15/3/2019, the AIMS Mangalagiri issued a notification inviting application from eligible candidates for appointment to the post of assistant professor, associate professor. Petitioner was eligible to apply for the appointment to the post of so on. And petitioner, after obtaining a no objection certificate from respondent to identical case, petitioner was issued with an appointment letter on 19/7/2000 by the AIMS Mangalagiri, appointing her as an associate professor in the Department of Pathology. Pursuant to the resignation letter tendered by the petitioner on 16/7/2019, she was relieved of her duty on 27 by respondent institution. There also, as in the present case, there was a resignation. It was accepted. She was relieved. Then, petitioner stated that on 21/9/2000, he represented the second respondent to maintain a lien to the post of assistant professor in the Department of Pathology as per Rule 252B of the KCSR. However, second respondent issued an endorsement refusing to maintain a lien on her post on the ground that there is no provision in the C&R rules of the institution to maintain a lien to the post of assistant professor. Being agreed by the same, petitioner filed this petition. Learned counsel for petitioner submit refusal to maintain a lien in the original post of assistant professor in which she was working is contrary to Rule 19, 20, and 252B of the KCSR. We further submit that the respondent 2 and 3 institution has adopted KCS rules and to termination and resignation as such, respondent 2 and 3 institution was not justified in rejecting the request of the petitioner for maintaining the lien on her post of assistant professor. In support of her submission, he has relied on so and so. Learned counsel for the petitioner further submitted. Petitioner's acceptance of resignation of the petitioner has not been approved by the governing council as required under clause so and so of the rules of the respondent institution. Hence, he submits that there is no valid. Well, at this point, I have also urged, because in this case also, when I requested for the resignation at the first stage, it was not put before the governing council. That point also I have urged. In that case also, what has happened when it was originally resignation was submitted, it was not approved by the governing council. That is incidentally that point. Then, para 8. Learned senior counsel to the respondent 2 and 3 institution submit that KCS rules are not applicable to the employees of the respondent 2 and 3 institution. Hence, the petitioner cannot maintain the lien on the post held by her as provided in Rule 19 and 20 and 252B. Alternately, also that at the time of being relieved, petitioner did not seek permission to maintain a lien on the post of assistant professor. In the absence of such permission, she cannot claim that she had a lien over the post by pressing into service note 4 of the Rule 20 of the KCSR. In support of his submission, he placed reliance on the decision of the division bench of the so-and-so by Registrar L.R. Patil. He further submitted that the resignation of the petitioner was approved by the Board of Appointment and acceptance of resignation petitioner in accordance with rule. Hence, he submit petitioner on acceptance for resignation ceases to be have a lien or any right over the original appointment. Well, it was the contention that she has not given any, in the resignation letter, she has not requested that you should maintain the lien. That was one of the arguments of the respondent. It need not be mentioned in the order because rule itself provides that a lien should be maintained until she is confirmed in the another post. I will come to the conclusions arrived at by the court. Para 10. I have considered the submission made by the learned counsel for the petitioner and the senior counsel for respondent and the learned assistant government for respondent. The submission of the learned counsel for petitioner that there was no valid acceptance of the resignation of the petitioner since the resignation was not approved by the board of governing council is factually incorrect. The result of the original file produced by the board indicates that the government council has approved. In that particular case, governing council had given sanction. The contention was taken, but the respondents proved that it was there. That to show that resignation was proper. In my case, I have taken that contention, but in the reply or anywhere it is not stated that it is approved by the governing council. That is one aspect. But apart from that itself, on the main ground that under Rule 252B, next melody, on para 12, on Rule 411 of the C&R rules of the institution provides adopting the rules and orders applicable to the state government employees to the employees of the institution. And with regard to matters not specifically dealt with C&R rules, which it has done. In respect of any particular respect of the following matters not specifically dealt under the rules and orders applicable to state government shall apply to the employees of the institute, subject to such modification as may be made by the government council, so on. So all the rules have been adopted. A reading of Rule 4.1 would indicate that respondent institution has adopted KCSR in the matter of recruitment, pay and allowances, termination, etc. Hence, the submission of the senior counsel that institution that KCSR are not applicable to the employees of the institution, but only to a person serving in connection with the affairs of the state is not acceptable. Respondent institution adopted KCSR with regard to the matters not specifically dealt with under the C&R rules. The right of an employee of the respondent towards the institution to retain the lien is not specifically dealt with under the C&R rules of the institution, but the matter relating to recruitment, termination, etc. are not specifically dealt with under C&R rules. Hence, the KCS rules are adopted. The person working in a permanent post in the institution can retain his lien in the terms of the KCSR. Once the probationer is declared in the earlier parent department, I am entitled to continue the lien in the post for a period until I am confirmed in the other post in the other. The issue involved in this petition is whether petitioner can retain the lien over the original appointment after she resigns from the post and secures another appointment. Before answering this issue, it is necessary to reproduce the relevant provisions of 826 KCSR lien means a title of a government servant to hold the termination of service and resignation either immediately or on termination of period for a period of absence, permanent post, including the tenure. Government may permit the government servant to retain a lien on a temporary appointment in special case, such as absence of duties on. So then, my lord, the general rules have been stated. Now come to page number para 16. Man.
Yes.
Lien cannot. The civil right of a government servant to hold the post to which he is appointed substantively. A reading of note 4 of 20 would indicate government servant shall continue to maintain his lien on the original appointment, provided he has already been confirmed in the post till he is permanently absorbed in the other department or cadre in which he is newly appointed. So if I am a probationer in the parent department, I may not be eligible. But if I am a confirmed official, if I am a person whose probation has been declared in the parent department, then, my lord, I am entitled to retain the lien until my services are confirmed or absorbed in the other department. Indicate that government lien on the post cannot be terminated even with his own consent under any circumstances. A government servant lien on a post stands terminated only on his acquiring a lien on a permanent post outside the cadre under which is born. 252B of the case. Now they come to the question of resignation. Rule 252B of the case has stipulated that resignation to an appointment is not a resignation of public office when a government servant takes up another appointment with prior permission. In the case on hand, admittedly, petitioner was working in a permanent post in the respondent to institution. Appointment was in accordance with law. After obtaining no objection certificate from the institution, petitioner submitted an application for considering her appointment to the post of Associate Professor Ames Mangalagiri. The application of petitioner was considered and she was appointed as Assistant Professor. Thereafter, she tendered resignation to the post of Assistant Professor and so on so to enable to report duty as Assistant. Hence, the petitioner has taken another appointment after tendering resignation with proper permission as required under Rule 252 of this. The next question for consideration is whether petitioner was required to maintain his lien over her original appointment at the time of tendering resignation. That is, whether it is required that under the resignation letter, you should state that I maintain the lien anta helbeka bedva. Then senior counsel for respondent has relied upon decision of division bench so wherein it was held that petitioner therein having not sought for permission to retain the lien over the post cannot contend that he had lien over the earlier post by pressing service on. So Apex Court in the case of State of Rajasthan, while interpreting the Rule 18, held that in a government servant lien on a post stands terminated only on his acquiring a lien on the permanent post outside the cadre on which he is born, and it will not be terminated even with his consent under any circumstance. The decision rendered by the division bench without reference 20G of the case is not applicable to the case on hand. Hence, it is held that petitioner was not required to seek permission to retain his lien over the post, held that respondent 213 at the time of rendering her resignation. A reading of 250 clearly indicates a resignation tendered with the proper permission to take up another appointment does not amount to resignation. The petitioner in her resignation letter sought permission to resign from the earlier post so as to enable her to report for duty Ames at Mangalore. None case only I have said Ames Jodhpur. That is the only difference. Hence, the resignation of the petitioner to the post of assistant professor is not a resignation, and petitioner continues to maintain a lien over the said post till she is permanently absorbed in the associate professor of Ames at Mangalore. The submission of the senior counsel, respondent so and so, are applicable to deals with only matters relating to pay and allowances and not with appointment is not acceptable. Rules so and so are not applicable to lien on appointments clearly stated in so and so. For the aforesaid discussion, I am of considered view that Rule 18, 19, 20, and Rule 50 of cases are applicable to the employees of respondent 2 and 3 institution. Refusal to maintain a lien in favor of petitioner for the earlier post held by her is contrary to service rules and regulation. And for the respondent 2 and 3 institution, it is further held that petitioner continues to retain her lien over the earlier post in the respondent 2 and 3 institution till she acquires a lien on the permanent post in the zone. I pass the following order. Writ petition is allowed, endorsement is quashed, direction is issued to the second respondent to permit the petitioner to rejoin the post of so and so and her service assistant professor. The petitioner entered. And one last point, one last submission I want to make. When the matter was sent to the government by the director of medical thing, then my lord, your lordship may kindly what was observed by the government is your lordship may kindly see. Page number 45. Page number 45. Government office file note, my lord. Government file note when the matter went to the government under Rule 252B. Page number 45 of the writ petition. This is the extract of the file under Right of Information Act. Your lordship got 45.
No, this is a file from government.
Government Right of Information ತಗೊಂಡ್ಬಿಟ್ಟು extract ಹಾಕಿರೋದು.
Yes.
Item number 42 ಮೇಲೆ ಕರ್ನಾಟಕ ನಾಗರಿಕ ಸೇವಾ ನಿಯಮಗಳು 252B ಈ ಕೆಳಕಂಡಂತಿದೆ. ಸದರಿ 20 ಅದು
Item 22.
ಅದು ರೂಲ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ 23 ಒಳಗೆ ಹೌ ಇಟ್ ಶುಡ್ ಬಿ. ಆದರೆ ಸದರಿಯವರು ಕರ್ನಾಟಕ ರಾಜ್ಯದ ಸ್ವಾಯತ್ತ ಸಂಸ್ಥೆಯಾದ ರಾಜಸ್ಥಾನ್ ರಾಜ್ಯ ಏಮ್ಸ್ ಸಂಸ್ಥೆಯ ಕರ್ತವ್ಯಕ್ಕೆ ವರದಿ ಮಾಡಿಕೊಳ್ಳಲು ರಾಜೀನಾಮೆ ನೀಡಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ KCS ನಿಯಮ 252B ಅನ್ನುವ ಕುರಿತು ಸ್ಪಷ್ಟೀಕರಣ ಇರುವುದಿಲ್ಲ. ಪೂರ್ವ ಖಂಡಿಕೆ 20F ರಲ್ಲಿರುವ ಅವಕಾಶಗಳು ಅನ್ವಯ ಆಗಿರುವ ತಿಳಿಸಿರುತ್ತಾರೆ. ಸದರಿ ನಿಯಮವನ್ನು ಪುಟ 32 ಪ್ರಸ್ತುತ ಚಾಲ್ತಿಯಲ್ಲಿರುವ ವೈದ್ಯಕೀಯ ಶಿಕ್ಷಣ ಇಲಾಖೆಯ ಸ್ವಾಯತ್ತ ಸಂಸ್ಥೆಯ ಬೈಲಾದನ್ವಯ ಸರ್ಕಾರಿ ಮುಖ್ಯ ಕಾರ್ಯದರ್ಶಿ ಆಡಳಿತದ ಪರಿಷತ್ ಅಧ್ಯಕ್ಷರಾಗಿದ್ದು ಸಹಾಯಕ ಪ್ರಾಧ್ಯಾಪಕರಿಗೆ ಸಂಬಂಧಿಸಿದ ನೇಮಕಾತಿ ಪ್ರಾಧಿಕಾರವು ಆಡಳಿತ ಪರಿಷತ್ ಉಪಾಧ್ಯಕ್ಷರಾಗಿರುವ. This I am reading to show that while accepting the resignation also the matter should have been posted before the council. On that what the government says I am just reading, my lord. ಸಹಾಯಕ ಪ್ರಾಧ್ಯಾಪಕ ಸಂಬಂಧಿಸಿದ ನೇಮಕಾತಿ ಪ್ರಾಧಿಕಾರವು ಆಡಳಿತ ಪರಿಷತ್ನಲ್ಲಿ ಉಪಾಧ್ಯಕ್ಷರಾಗಿರುತ್ತಾರೆ. ಆದ್ರಿಂದ ಶಿಸ್ತು ಪ್ರಾಧಿಕಾರವು ಸಹ ಆಡಳಿತ ಮಂಡಳಿಯ ಉಪಾಧ್ಯಕ್ಷರೇ ಆಗಿರುತ್ತದೆ. ನಿರ್ದೇಶಕರು ಮತ್ತು ಡೀನ್ ಮೈಸೂರು ವಿದ್ಯಾಲಯ ಕಾಲಕ ಇವರ ಅಧಿಕೃತ KH ನವೀನ್ ಅವರ ರಾಜೀನಾಮೆ ಅಂಗೀಕರಿಸಿ ಸದರಿಯವರ ದಿನಾಂಕಕ್ಕೆ ಬಿಡುಗಡೆ ಮಾಡುತ್ತಾರೆ. ಸದರಿ ಅಧಿಕೃತ ಜಾಪದ ನವೀನ್ 19 ನೀಡಿರುವ ವರದಿಯನ್ನು ಉಲ್ಲೇಖಿಸುತ್ತಾರೆ. 19/16 ಮನವಿಯಲ್ಲಿ ಪ್ರಸ್ತಾಪಿತ ವೈದ್ಯರು ತಾವು ಜೋಧ್ಪುರ್ ಏಮ್ಸ್ ಸಂಸ್ಥೆಗೆ ಆಯ್ಕೆಯಾಗಿರುವುದರಿಂದ ಅಲ್ಲಿ ಕರ್ತವ್ಯಕ್ಕೆ ವರದಿ ಮಾಡಿಕೊಳ್ಳಲು MCR ಬಿಡುಗಡೆ ಮಾಡುವಂತೆ ಕೋರಿರುತ್ತಾರೆ. Kindly note this point that my specific request was that I am appointed there to enable to report. Please accept my resignation. Para 25. ಪ್ರಸ್ತಾಪಿತ ವೈದ್ಯರ ರಾಜೀನಾಮೆಯನ್ನು ಅಂಗೀಕರಿಸುವ ಕುರಿತು ವಿಷಯವನ್ನು ಸಂಸ್ಥೆಯ ಆಡಳಿತ ಪರಿಷತ್ತಿನಲ್ಲಿ ಮಂಡಿಸಿರುವುದಿಲ್ಲ. Kindly note. ಬದಲಾಗಿ ಸಂಸ್ಥೆಯ ನಿರ್ದೇಶಕರೇ ರಾಜೀನಾಮೆಯನ್ನು ಅಂಗೀಕರಿಸುತ್ತಾರೆ. ಶಿಸ್ತು ಪ್ರಾಧಿಕಾರವು ಆಡಳಿತ ಪರಿಷತ್ನ ಉಪಾಧ್ಯಕ್ಷರಾಗಿರುವುದರಿಂದ ಈ ಕುರಿತು ಉಪಾಧ್ಯಕ್ಷರಿಂದಲೂ ಸಹಮತ ಪಡೆದಿರುವುದಿಲ್ಲ. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ AMCRA ಸಂಸ್ಥೆಯ ಹುದ್ದೆಯಲ್ಲಿ ಖಾಲಿ ಇದ್ದ ಡಾಕ್ಟರ್ ನವೀನ್ ಇವರನ್ನು ನಿಯಮಗಳೇ ಮರು ನೇಮಕಾತಿ ಮಾಡಿಕೊಳ್ಳುವ ಕುರಿತು ಸರ್ಕಾರದ ನಿರ್ದೇಶನ ಕೋರಲಾಗಿದೆ. On this, my lord, matter stopped at that.
ಇವರನ್ನು ನಿಯಮಗಳಿಗೆ ಅನುಗುಣವಾಗಿ ಮರು ನೇಮಕ ಮಾಡಿಕೊಳ್ಳುವ ಕುರಿತು
ಅಪರ ಕಾರ್ಯದರ್ಶಿ ನಿರ್ದೇಶನ ಕೋರಬಹುದಾಗಿದೆ. ಅಂದ್ರೆ ಮ್ಯಾಟರ್ ವೆಂಟ್ ಆನ್ ಗೋಯಿಂಗ್ ಲೈಕ್ ದಟ್. ದಿ ಫ್ಯಾಕ್ಟ್ಸ್ ವರ್ ಕ್ಲಿಯರ್ that the matter was never placed before the governing council. The fact was clear that I had resigned only to take up the appointment at James Jodhpur. Therefore, 252B, read with Rule 20 of the case, squarely applied to my case. The judgment rendered also squarely applied to my case. I was entitled. Well, this is my petition and my ground. Now, kindly come to my lord, after this, kindly see annexation. Yes, my lord, page number 48.
Yes.
ಅದರೊಳಗೆ ಗೌರ್ಮೆಂಟ್ ರಿಜೆಕ್ಟ್ಸ್ ವಿತೌಟ್ ಗಿವಿಂಗ್ ಎನಿ ರೀಸನ್ಸ್. ಗವರ್ಮೆಂಟ್ ಈತ ಹೇಳ್ತಾ ಪೇಜ್ ನಂಬರ್ 48 ಅಲ್ಲಿ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖಿತ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಸರ್ಕಾರದಲ್ಲಿ ಪರಿಶೀಲಿಸಲಾಗಿ ಜೋಧ್ಪುರ್ 2 ಸ್ವಾಯತ್ತ ಸಂಸ್ಥೆಗಳಾಗಿದ್ದು ಪ್ರಸ್ತಾಪಿತ MICR ಸಹಾಯಕ ಪ್ರಾಧ್ಯಾಪಕ ಹುದ್ದೆಗೆ ಈ ಹಿಂದೆಯೇ ರಾಜೀನಾಮೆಯನ್ನು ನೀಡಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸದರಿಯವರಿಗೆ ಮರು ನೇಮಕಾತಿ ನೀಡಲು ನಿಯಮಗಳಲ್ಲಿ ಅವಕಾಶವಿರುವುದಿಲ್ಲ. ಸಂಸ್ಥೆಯಲ್ಲಿ ಸದರಿ ಹುದ್ದೆಗೆ ನೇಮಕಾತಿ ಪ್ರಕ್ರಿಯೆಯನ್ನು ಪ್ರಾರಂಭಿಸಿದ ಯು ಅಪ್ಲೈ ಫಾರ್ ಡೈರೆಕ್ಟ್ ರಿಕ್ರೂಟ್ಮೆಂಟ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಬೈ ಎ ಕ್ರಿಪ್ಟಿಕ್ ಆರ್ಡರ್ ದೇ ರಿಜೆಕ್ಟ್ ಮೈ ರಿಕ್ವೆಸ್ಟ್ ಫಾರ್ ಟೇಕಿಂಗ್ ಬ್ಯಾಕ್. ಇಟ್ ಇಸ್ ನಾಟ್ ಮರು ನೇಮಕಾತಿ. ವಾಟ್ ಐ ಹ್ಯಾಡ್ ಸಾಟ್ ಫಾರ್ ಈಸ್ ಟು ಟೇಕ್ ಮೀ ಬ್ಯಾಕ್ ಟು ಡ್ಯೂಟಿ ಇನ್ ವ್ಯೂ ಆಫ್ ಮೈ ಲೀನ್ ಹ್ಯಾವಿಂಗ್ ಬೀನ್ retained here, and the original acceptance of resignation itself not being proper by the please take me back. So I have challenged this order of the government rejecting the request, and also the management order which rejected my request. These are the orders challenged. Now come to the reply statement filed by them.
Yes.
Para 6, my lord, para 6 of the reply. It is borne out on record that resignation was accepted before submission of the withdrawal letter, and therefore considering rejoining was not permissible. It is on record the petitioner is in the habit of submitting resignation.
Wait. Para 6.
Para 6.
It is a matter of records.
It is borne out from record that resignation was accepted before submission of the withdrawal letter, and therefore consider. Yes.
It is starting that it is a matter of records. You are saying that it is born of record.
This reply statement filed by third respondent.
When?
Third respondent, that is medical council.
Yes, third respondent only.
It is
page 4, para 6.
Page 4 ತಾವು ನೋಡ್ತಾ ಇದ್ದೀರಾ?
Para 6.
Para 6 ಅಲ್ಲಿ ನಂದು page 3 ಅಂತ ಇದೆ, borne out on records ಅಂತ. ಆಮೇಲೆ ರೂಲ್ 252B ಎಕ್ಸ್ಟ್ರಾಕ್ಷನ್ ಪ್ಯಾರಾ 7 ನಲ್ಲಿ ರೂಲ್ 52 ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿದಾರಲ್ಲ.
No, it is not there.
Oh, I don't know. This is a reply statement served to me. I will come to that. What your lordship has, I will come to that, my lord. I will come to that.
Wait. One more is.
I will come to that. Lordship may take that, my lord. Para 6, I will come to that, my lord. Para 6.
Yes.
ಎರಡು ರಿಪ್ಲೈ ಇದೆ, ಮೊದಲೊಂದು ಆಮೇಲೆ.
Which one, mister?
ಆಯ್ತು, ಇವಾಗ ಯಾವ್ದು ತಗೊಂಡಿದ್ರು ತಾವು ಅದೇ ತಗೊಳ್ಳಿ, ಪರವಾಗಿಲ್ಲ. ಬಿಕಾಸ್ ದಟ್ ವಾಸ್ ದಿ ಲೇಟೆಸ್ಟ್. My learned friend filed a detail, earlier filed one reply, but thereafter filed a second reply. I don't mind the second reply. ಇವಾಗ ತಾವು ಯಾವ್ದು ತಗೊಂಡಿದ್ರು, page number 4, para 6.
Yes.
It is a matter of record that the petitioner has been relieved from his duties on 24/8/2016. Resignation submitted by him has been accepted, followed by the relieving order. The petitioner therefore cannot seek withdrawal of the resignation. Resignation having been accepted and he being relieved of relations of master and servant and so on to exist. Under these circumstances, he cannot be faulted. Therefore, accept of resignation of relieving so and so, and having accepted the offer appointment well before the followed subsequent order of appointment, petitioner could not be entitled. The first contention is that they are treating it as a normal resignation and acceptance. They are treating it as a normal resignation acceptance, where 252B is not applicable. That is correct. If a person resigns and does not take up a new appointment and normal order of resignation, the principles fairly apply, agree. But these principles, there is an exception, and 252B is the exception. Now, my lord, 252B ಅವರು ಎಲ್ಲಿ ಡೀಲ್ ಮಾಡ್ತಾರೆ ಅಂತ ನೋಡೋಣ. Next, para 7, my lord. Provisions of Rule 252B should be understood to have been applicable only to the appointment within the state and our explanation. However, both Mysore and Rajasthan being independent autonomous bodies, petitioner having already been relieved of his duties by acceptance of the resignation and having joined the said post, having completed his probationary period of 2 years and having become permanent, at this juncture to extend to Rule 52, allowing to join duties at Mysore would have serious legal complication. Though rule does not create any complication, they said it will create complication. 252 clearly applies. Just because he went out of the state, they say that it is not applicable. Then, my lord, he has also not made any reference to 252B. Petitioner cannot be permitted to improve his case by making amendments to his application. He has not mentioned 15 is first application. There, this contention is what they are saying is in the resignation letter. You have not mentioned Rule 252B. You have not retained your leave. Just the same argument which was addressed in the Dr. Arundasi's case, that you have not retained your lien in the letter of resignation. Therefore, you have no right. That is not required. That is a statutory protection. It need not be mentioned. As long as my appointment resignation was to take up a new appointment, it is a resignation under Rule 252. I need not mention. So this is the other contention of the respondent.
Yes.
Then, para 9, page number 6. The post held by the petitioner has been filled up by the post of assistant professor in response. Therefore, there is no vacant post. That is, they refer to subsequent. When it was filled up and all those details are not there. The day when I had given the letter for withdrawal of resignation within 1 month from the date I went there. If they can show that this is happened, this is also not correct, because as on the date, even when I filed the writ petition, the post had not been filled up or no person has been appointed. This is only to avoid the relief being granted, they have stated so, without giving any details. Then, my lord, para 10. Petitioner is in the habit of repeating filing application after application seeking resignation. Now, this is the main ground on which my learned friend wants to argue that earlier I had submitted certain on many occasions resignations, and therefore you are in the habit of submitting resignation. That is what they are saying. For that, let me know what are the facts and what period it relates to. Kindly see. Petitioner is in the habit of repeatedly filing application after application seeking resignation on personal grounds. Copy of the letter dated 29/2010. Kindly note this point, and all the documents R1, R2, R3 up to R3 are the orders dated 2010. 2010 ಆದ್ಮೇಲೆ 2012 ಅಲ್ಲಿ ನಾನು ಪ್ರೊಬೇಷನ್ ಡಿಕ್ಲೇರ್ ಮಾಡಿರೋ ಸ್ವಾಮಿ. Therefore, the facts relating from 2012 up to the earlier resignation R3 is irrelevant for the present purpose. One point. Next, Melot, come to the next point. On 17/6/2016, petitioner has submitted a letter of resignation on personal reasons duly acknowledged on 26/2000 with a request to relieve him from the duties on the afternoon. Repeated request, that is, these documents 17/6/26, these are all the documents requesting that I have got in Jodhpur, therefore relieve me. Adakke resignation kottirodu. Then ultimately, what is the resignation that was accepted? Then come to para 11. Petitioner has further made one more representation on 19 to relieve him from the services on the afternoon of 19/8 is evident from Annexure R8. Annexure R8 is nothing but 19/8. That is exactly the letter I am referring to, Annexure F. Yes. Annexure R8 is Annexure F. Your Lordship may kindly, for ready reference, note it well. Yes. He was accordingly relieved. This is very, very important. What is the letter on the basis of which I was relieved? Even according to them, para 11, petitioner submitted representation to relieve him from the service on 19/8 as evident. He was accordingly relieved on 24/8. So 24/8 also Annexure G. Annexure R9 is Annexure G. Annexure G. So ultimately, I am relieved of my duties in pursuance of my representation dated 19/8 and relieving order issued on 24/8. And that specifically refers to the letter of 19/8, wherein I have stated that I have to report for duty at Jodhpur. Please relieve me. Therefore, my acceptance of resignation is to take up an appointment in Jodhpur has to be necessarily read as the one given under Rule 252B. And since I have come back and reported within a short time of 1 month, a resignation should be treated as no resignation in the eye of law. And applying the principles laid down in the case of Arundhati's case, the matter has to be, writ petition has to be allowed. That's all.
Yes, Mr. Gaud.
Yes, my lord. At the outset, my lord, your lordship kindly see, my lord, the facts of the case.
Yes.
Each case, my lord, has to be read within its own facts with reference to, my lord, the service condition of the person concerned. Now, your lordship kindly, my lord, permit me to, I will not take your lordships to other documents which may not be necessary. But at the outset, my lord, your lordship kindly see, my lord, Annexure R1, which I have produced along with my statement of objections. Yes. Annexure R1, my lord, is page 11, my lord, of the statement of objections filed on 3/7/21.
Yes.
Annexure R1. That is, my lord, on 17/6/2016.
Wait. Yes. So not produce straight copy. Page 11.
Page 11 ನಲ್ಲಿ 17/6/2016 ನಲ್ಲಿ he makes a request for resignation.
Yes.
Resignation to the post of assistant professor. Requisition for issue of relieving order and experience certificate. I so and so resigning to the post of assistant professor because of by some personal reasons. Hence, I request your kind self to accept my resignation and relieve me from my duties on the afternoon of so and so. This is not, my lord, with reference to 252B. He wants to resign, let him, he is to resign. Now, this is followed by subsequent resignation letter, my lord, on 5/7, that is next month. Personal reasons, my lordship kindly note. Personal reasons antare avaru. This cannot be just brushed aside, my lord, so as to seek relief in the writ petition. Subject to R2 may kindly be seen, my lord, 5/7/2016.
Yes.
This again, my lord, is in the nature of a resignation to the post of assistant professor. I so and so, because of some personal reasons. Hence, I request your kind self to accept my resignation and relieve me from the duties on the afternoon of 11/7/2016. And he has specifically mentioned the date as 11/7/2016. This is not because he got an appointment at Jodhpur, nor that he wants to go and join them.
Yes.
This is followed by, my lord, another resignation letter, annexure R3, page 15. This is in the nature of withdrawal of the resignation. Above mentioned post due to some unfavorable circumstances in the family, I would like to withdraw my resignation. Hence, I request your kind self to do the needful to withdraw my resignation. This is on 8/7. Now 8/7/2016, page 15. Annexure R3, my lord.
R3. 8/7.
He wants to withdraw the writ petition, withdraw the resignation. Now, annexure R4 may kindly be seen, that is on 19/8/2016. 19/8. Annexure R4, page 17.
Yes.
Here he says the above subject earlier I had submitted application on 17/6/2016. Because of some personal reasons, it was withheld. Now I have been given extension to join for the post of assistant professor at AIMS, Jodhpur. Hence, I request your kind self to relieve me on afternoon of 19/8/2016 and I have to report on 12/8/2016. This document, my lord, though says that he has to join the post, but the same thing is not indicated earlier. And secondly, this is not a letter of resignation. This is a request for relieving. Is a request for relieving. Now, my lord, having sought for withdrawal of his resignation in the previous document.
Yes.
Now he says, please relieve me. Yes. Accordingly, my lord, we have relieved him. Annexure R9, page 19. This, my lord, is very important because we have accepted his resignation to have been given on personal grounds. If he has got any issue on this, my lord, he should have complained then and there. He has not done it. With reference to the above subject, Dr. Ravin, Assistant Professor, Community Medicine, so has submitted his resignation on personal grounds. He is relieved from the duties of this afternoon on 19/8/2016.
Which is that annexure?
Annexure R.
Why you have not marked the annexure?
Annexure R5, my lord. I'm sorry, annexure R5, page 19, my lord.
No annexure has been marked.
I'm sorry, my lord. 24/8/2016, my lord.
Yes.
This is the document where the director, my lord, has issued a official memorandum with reference to the above subject. Dr. So and so, Assistant Professor Community Medicine, Mysore, has submitted his resignation on personal grounds. He is relieved from the duties of this institution on the afternoon of 19/8/2016. Now, he has no issue regarding acceptance of his resignation on personal grounds. He is seeking an appointment at Jodhpur. He got an order of appointment. He was not. He did not go and report. but however, extension of time was given, therefore he sought for relieving. Now your lordship kindly go to the letter, my lord, which petitioner himself has produced at annexure N, my lord, 5/12/2016, subsequent again, page 34 of the writ petition.
Yes.
He has written to the state government. Nanna Manavi Patra, page 34, my lord, annexure N.
Yes.
5/12/2016. This is very important, my lord, in my defense. Nanna Manavi Patra official memorandum ಮತ್ತು ಹಿಂಬರಗಳ ಪತ್ರಗಳನ್ನು ಮರುಪರಿಶೀಲಿಸಿ ನನ್ನ ಹಿಂದಿನ ಹುದ್ದೆಗೆ ಮರುಕರ್ತವ್ಯಕ್ಕೆ ಹಾಜರಾಗಲು MMCRI ಮೈಸೂರು ನಿರ್ದೇಶಕರಿಗೆ ಸೂಕ್ತ ನಿರ್ದೇಶ ನೀಡಲು ಕೋರಿರುವ ಪತ್ರ. ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ನಾನು ನನ್ನ ಹಿಂದಿನ ಹುದ್ದೆಗೆ ಹಾಜರಾಗಲು ಅನುಮತಿ ಕೋರಿ ನಿರ್ದೇಶಕರು MMCRI ಮೈಸೂರಿಯವರಿಗೆ 16/9/2016 ಮನವಿ ಪತ್ರ ಸಲ್ಲಿಸಿದ್ದೆನೋ. ಇದೇ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ತಮ್ಮಲ್ಲಿ 26/10/2016 ಮನವಿ ಪತ್ರ ಸಲ್ಲಿಸಿದ್ದೆನು. ನಂತರ ನಿರ್ದೇಶಕರು MMCRI ಮೈಸೂರಿಯವರು 7/11/2016 ಹಿಂಬರ ನೀಡಿದ್ದು, ಅದರಲ್ಲಿ ಸ್ವಂತ ಕಾರಣದ ಮೇಲೆ ರಾಜೀನಾಮೆಯನ್ನು ಅಂಗೀಕರಿಸಲು ಕೋರಿದ ಕಾರಣ ನನ್ನನ್ನು ಕರ್ತವ್ಯಕ್ಕೆ ಪುನರ್ ನೇಮಿಸಲು ಅವಕಾಶವಿರುವುದಿല്ലെಂದು ಉಲ್ಲೇಖಿಸಿರುತ್ತಾರೆ. ಈ ಸಂಬಂಧದಲ್ಲಿ ತಮ್ಮ ಗಮನಕ್ಕೆ ತರಬಯಸುವುದೇನೆಂದರೆ, MMCRI ದಿನಾಂಕ 24/8/2016 ಕಚೇರಿ ಜ್ಞಾಪಕ ಸಂಖ್ಯೆ 7/11/2016 ಹಿಂಬರದಲ್ಲಿ ಪ್ರಮುಖವಾಗಿ ನಾನು ಸಲ್ಲಿಸಿರುವ ದಿನಾಂಕ 19/8/2016 ಮನವಿಯನ್ನು ಉಲ್ಲೇಖಿಸಲಾಗಿದೆ. ನಾನು ವೈಯಕ್ತಿಕ ಕಾರಣಗಳಿಂದ ರಾಜೀನಾಮೆ ಸಲ್ಲಿಸಿದ್ದೇನೆ ಎಂದು ಹೇಳಲಾಗಿದೆ. ಆದರೆ ವಾಸ್ತವವಾಗಿ 19/8/2016 ನನ್ನ ಮನವಿಯಲ್ಲಿ ನಾನು MMCRI ಜೋಧ್ಪುರದಲ್ಲಿ ಸಹಾಯಕ ಪ್ರಾಧ್ಯಾಪಕರ ಹುದ್ದೆಗೆ ಹಾಜರಾಗಲು ಅನುಕೂಲವಾಗುವಂತೆ ಬಿಡುಗಡೆ ಮಾಡಿಕೊಂಡಿದ್ದು ಕೋರುತ್ತೇನೆ. ಬಹುಶಃ ಕಣ್ತಪ್ಪಿನಿಂದ, ದಿಸ್ ಇಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ಮೇಲೋ, ಬಹುಶಃ ಕಣ್ತಪ್ಪಿದ್ದ ರೆಸಿಗ್ನೇಷನ್ ಆನ್ ಪರ್ಸನಲ್ ಗ್ರೌಂಡ್ಸ್ ಎಂದು ನಮೂದಾದಂತೆ ಕಂಡು ಬರುತ್ತಿದೆ. ನಾನು ಹೊಸ ಜಾಗಕ್ಕೆ ಹೋಗಬೇಕಾದ ಒತ್ತಡ ಮತ್ತು ಸಮಯಾವಕಾಶ ಗೊಂದಲದಲ್ಲಿ ಈ ತಪ್ಪನ್ನು ಗಮನಿಸಿರುವುದಿಲ್ಲ. ನಾನು ಸಂಸ್ಥೆಯ ಅನುಮತಿಯೊಂದಿಗೆ ಹೊಸ ಹುದ್ದೆಯ ಸಂದರ್ಶನಕ್ಕೆ ಹಾಜರಾಗಿದ್ದು, ಇದರ ಪೂರ್ವದಲ್ಲಿ ನಾನು ಜೋಧ್ಪುರದಲ್ಲ ಸಂದರ್ಶನಕ್ಕೆ ಹೋಗುವ ಮುನ್ನ MMCR ಕಚೇರಿಯಿಂದ 11/2/2016 NOCಯನ್ನು ಸಹ ಪಡೆದಿರುತ್ತೇನೆ. ಈ ಹುದ್ದೆಗೆ ಆಯ್ಕೆಗೊಂಡ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಬಿಡುಗಡೆ ಬಯಸಿ ಮನವಿ ಸಲ್ಲಿಸಿದ್ದೇನೆ. ಈ ವಾಸ್ತವಾಂಶಗಳನ್ನು ಗಮನಿಸಿ ನನ್ನ ಬಿಡುಗಡೆಯನ್ನು ಹೊಸ ಹುದ್ದೆಗೆ ಅನುಮತಿಯೊಂದಿಗೆ ಹಾಜರಾದ ಪ್ರಕರಣವೆಂದು ಪರಿಗಣಿಸಿ he wants his request to be considered in the manner the resignation having been submitted on the ground that he has sought for appointment, he has got appointment, and therefore he should be relieved. Now, my lord, after this, your lordship kindly see, my lord, that he goes to and reports himself to duty. Now, my lord, having I'll come to the other documents later, my lord. Your lordship can annex it. Yes, my lord, I don't have in my petition, but anyway, my lord, that is the order of rejection by the state government. The state government, my lord, order, if it is to be set aside, the defense of the state government also has to be heard. They have to file objections, my lord, and I will leave it to the court, my lord, in respect of that aspect of the matter, because your lordship kindly see, my lord, at this juncture it is necessary to submit that the petitioner, this respondent institution is an autonomous institution. I think I am audible, my lord. My lord, I am audible.
Yes, now you will repeat.
I'm sorry, my lord. This respondent institution, my lord, is one among, my lord, 8 institutions in this state. That is, my lord, autonomous institution. We have got our own bylaws. However, yes, the Honorable Minister for Education, my lord, is the chairman of the committee of each of the institutions. That is board committee, my lord, that is headed by the Honorable Minister for Education. Yes. Here, my lord, what is my learner friend read, page 45, may kindly be seen, my lord. If we are to abide by any direction of the state government, or that is one aspect of the matter. If we are to take a decision, my lord, there is second aspect of the matter. Now, my lord, as read by my learned friend at page 45, my lord, page 45, item number 25. ಪ್ರಸ್ತಾವಿತ ವೈದ್ಯರ ರಾಜೀನಾಮೆಯನ್ನು ಅಂಗೀಕರಿಸುವ ಕುರಿತು ವಿಷಯವನ್ನು ಸಂಸ್ಥೆಯ ಆಡಳಿತ ಪರಿಷತ್ತಿನಲ್ಲಿ ಮಂಡಿಸಿರುವುದಿಲ್ಲ. ಬದಲಾಗಿ ಸಂಸ್ಥೆಯ ನಿರ್ದೇಶಕರೇ ರಾಜೀನಾಮೆಯನ್ನು ಅಂಗೀಕರಿಸಿರುತ್ತಾರೆ. ಶಿಸ್ತು ಪ್ರಾಧಿಕಾರವು ಆಡಳಿತ ಪರಿಷತ್ತಿನ ಉಪಾಧ್ಯಕ್ಷರಾಗಿರುವುದರಿಂದ ಈ ಕುರಿತು ಉಪಾಧ್ಯಕ್ಷರಿಂದಲೂ ಸಹ ಸಹಮತಿ ಪಡೆದಿರುವುದಿಲ್ಲ. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಎಂಎಂಸಿಆರ್ಐ ಸಂಸ್ಥೆಯಲ್ಲಿ ಹುದ್ದೆಯು ಖಾಲಿ ಇದ್ದಲ್ಲಿ ನಂಬರ್ 1 ಸೋ ಅಂಡ್ ಸೋ ನವೀನ್ ಕಮ್ಯುನಿಟಿ ಮೆಡಿಸಿನ್ ಸಹಾಯಕ ಇವರನ್ನು ನಿಯಮಗಳಿಗೆ ಅನುಗುಣವಾಗಿ ಮರು ನೇಮಕಾತಿ ಮಾಡಿಕೊಳ್ಳುವ ಕುರಿತು ಸರ್ಕಾರದ ಅವರ ಉಪ ಮುಖ್ಯ ಕಾರ್ಯದರ್ಶಿ ನಿರ್ದೇಶನ ಕೋರಬಹುದಾಗಿದೆ ಆದೇಶಕ್ಕಾಗಿ. What happened before the government thereafter, we are not aware of it. If the government were to take a decision that irrespective of any of these facts and circumstances, he should be taken back to duty, then the ball, my lord, comes back to us so as to decide as to whether it should be continued or any other decision to be taken.
Yes.
The state government, my lord, if has taken a decision to reject his request, it is one of for the state government to defend itself. Now, my lord, having submitted the resignation on personal grounds, the question of, my lord, reverting back to make a request so as to attract 252B does not arise. Because 252B specifically says.
Now, Mr. Gowli.
Yes, my lord.
Your contention is that since it is for a personal reason he has resigned,
yes,
he cannot be taken back. Now,
true, my lord, true.
A subsequent development in the government saying that his case can be considered.
ಅಲ್ಲ, ಇವಾಗ ಎರಡು ಪ್ರಶ್ನೆ ಆಗುತ್ತೆ. Whether we are bound by the directions, my lord, that you will also kindly decide, because we are unable to know as to whether we can act our own or depend upon the state government decision. If the state government were to take a decision, my lord, our role, my lord, becomes redundant. Practically, my lord, with the powers. Now, assuming for a moment, my lord, state government has taken a decision.
Yes.
These are only notes, my lord, put up by the concerned authority. No decision has been taken on this. In which event, my lord, necessarily the government has to defend its decision. Either way, what are the facts before the court? What are the facts before?
Mr. Gowli, that's why I have shortcut your argument.
Yes.
Now that your contention is that since he has resigned on the basis of the personal reason,
yes,
that provision cannot be made applicable to his case.
Perfectly right.
Yes, if at all his request for reappointment,
yes,
there is also a filed move for consideration of reappointment that is government has to answer.
Government has to answer. Definitely, my lord. Definitely, your lordships are perfectly right there. Now, your lordship can say, my lord, one important aspect. What we have said is on 24/8/2016, my lord, we have accepted his resignation.
Yes.
On personal grounds. Now, your lordship kindly see, my lord. Subsequently, my lord, he makes a request. Subsequently, he makes a request for permitting to resign. For subsequent again, that, my lord, I have given the dates and events, my lord, in my first statement of objections.
Yes. Yes.
2/9/2016 ಗೆ
yes,
ಅವ್ರಿಗೆ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಗುತ್ತೆ. ಅವ್ರಿಗೆ ಅದ್ರ ಮುನ್ನ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಗಿರಲ್ಲ. ಆ ಕನೆಕ್ಟೆಡ್ ಡಿಸಿಷನ್ ವೇರ್ ಮೈ ಲರ್ನೆಡ್ ಫ್ರೆಂಡ್ ರೆಡ್, ಮೈ ಲಾರ್ಡ್, ಇಟ್ ವಾಸ್ ಎ ಕೇಸ್ ವೇರ್ ದೇ ರಿಸೈನ್ಡ್ so as to report to the duty in the other department or this thing. They wanted to go and join there by maintaining a lien in the department. That's how, my lord, the facts of those cases are laid. Here, my lord, it's
Mr. Gowli,
yes,
regarding that is concerned.
Yes.
256B will not make any such difference. Till he has to confirm, he can come back and
true, my lord. I'm not saying that, my lord. He can come. Definitely, he can come. But provided his going is acceptance. Now, my lord, if my acceptance or resignation is according to them, it is found to be bad, then he could not have gone and joined the post at Jodhpur.
That is there. Your case
That is yes.
His resignation has been accepted for his personal reason.
Yes.
Therefore, the 256B is not applicable.
252B, my lord. I'm sorry. 252B, my lord, would not be acceptable. If not, and just like in the other case, my lord, he had made a request. We have permitted him. He goes there, joins there. He is not confirmed there. He wants to come back. We have not permitted him. Well, we all the facts of the case, my lord, will fit into the judgment. But that is not the case in this writ petition. Because subsequently, my lord, he makes a repeated request to the state government, to us, that please accept my resignation. I would like to go and join there. It is only thereafter, my lord, appointment order is issued 2/9/2016. After all this, and he makes a government representation to state government on 26/10/2016, 10 October nalli, seeking permission to join.
Yes. Now I will hear that government.
Yes, my lord.
They have to defend. Yes. What is this, madam? Last 1 hour I am hearing it. It is an important government has to answer. It is not that institution. Then your colleague is not there. She don't know what they have argued. How she will answer? This is how it's assisting the court, madam. It's very sorry. She don't know what they are argued. That then how can she will assist the court? Yes, madam. What you say that? What is the stand of the government? It is you have to answer. It is not that institution. It is your order which has been challenged. Yes. 2:30.
Akbar.
Yes.
Number 20 adjourned. Number 21.
Appear for the petitioners, my lord.
Yes.
I'll file my counter to the vacating application. 2 weeks time may be granted.
Yes. 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 Where is your application for vacating? It is not posted. It is there.
It is there. It is there. It has some office objection. It is there. It is posted. It is listed. I am for the appellant.
Yes,
I request for 2 weeks time to file my counter.
Why there is an office?
There is a status quo interim order is there. Next week also it's okay, right? I can file my objection.
No, this is application for vacating is there, mister. It is not that they are seeking for a final disposal. There are an application for vacating. You argue on that application.
I'll file a formal. Weeks time be granted. I'll file a formal. In fact, the petition, my lords could even hear the petition itself. In fact, short point for consideration.
No, have they filed an objection for your application? Yes, they have served. When you have served, where this land has been acquired for?
It's in Udupi, near Udupi.
Yes.
Next week itself, I will file my counter. In fact, my lords even could hear and dispose of the petition itself. Petition itself, my lords could hear.
Now they are insisting for a vacating interim order. If you want to file an objection, you file it. Otherwise, we will consider for an application for vacating interim order.
Anytime, my lords direct, I'll submit my.
On 28. Yes. Finally, he is asked 2 weeks. I will say that yes, 2 weeks and it will come. Yes, Mr. 28 is that.
Grateful.
Yes, on that day.
Yes. Ahead of that, I'll serve the copies and then.
In the connected matter.
28 you take. 24th we have some other matters have been fixed. Service matter.
There's an interim order in the connected matter also.
Matter. No question of hearing on that application. If interim order is vacated, yes, that's what we'll hear on merit.
My lords could hear on the merits. That would be the most appropriate.
Wait, mister. Wait, mister. If you are not ready, just wait. Yes. No, they are challenging that acquisition itself. Yes.
There was so many deviations, my lord. I appear in the connected matter.
Yes.
Could it be we taken a week after next, my lord? I am in the connected matter, my lord. I am Acharya, my lord, in the connected matter.
Yes, Mr. Acharya. What is this?
Well, it is the acquisition project with regard to highway, my lord. There are so many acquisition process has been taken and then they have dropped it. My lord, there are so many deviations. My lord, there are the records are needed, my lord. You lost my have it out a week after next.
On that day, no, in second matter, you take that. It's the same this thing. You don't want to vacating in the second matter.
Well, there the interim.
That is that symbol. Yes. Yes.
Well,
Second
order
matter.
may be extended, my lord.
Government advocate is directed to take notice for. Second matter, who are there?
That is National Highway Authority. National Highway Authority.
Then why it is connected if it is not same thing?
Well, that is, my lord, the deviation is different, my lord. That they have to file the objections, my lord. They have not filed the objections.
Verify if you want file is vacating in this also. Yes, both is government only. Yes, government advocate is directed to take notice for respondent number 1 and 2. You serve 2 sets of copy, Mr. Acharya. Yes.
Please, my lord. Please, my lord. 2 weeks, my lord.
Yes, petitioner is directed to serve 2 sets of copies on government advocate. On 28th, on the understanding that for final hearing,
yes.
you secure that original record.
Interim order may kindly be extended.
Request of respondent, a petitioner, release this matter.
First week of March, 28th, bada. The first week of March, man.
First week March 28th is same 1 day difference. That's all.
3rd or 4th, Swami. 3rd or 4th. 28th is something.
2nd March.
Please.
Yes, 28th. Let us see.
Well, 2nd March,
yes,
2nd March, 2nd March.
2nd March. Yes.
Interim state to continue.
Convenience. Then I will dealing this matter.
It's on the same notification, but different line of deviation. So what has happened is
my matter may be dealing. My matter may be dealing.
They have stopped their work. I think it is in a curve. You want.
My lord, firstly, they have taken first deviation. Then after considering the objection, they have dropped it, my lord. Then taken a different deviation.
Yes. Learned government advocate submitted that. Petition 3779 of 2021 may be dealing with 6862 of 2021. 3779 2021 is dealing from so and so.
Please.
Learned counsel for the petitioner is directed to serve 2 sets of petition copy and government advocate. Interim order granted earlier is extended next date of hearing. Call after 2 weeks.
Please.
This matter I will fix the date. 20. This will fix 20. This you want some personal, but this is not. There is no any such urgency. Yes, that they will give. I have directed to
same
give.
Notification, different places. That's all. Different kilometer.
Post this matter on 28. Yes, for consideration of IA 1 of 22 for vacating the stay. Yes.
Right.
Number 22 objects, number 23 Mahantesh was not for petitioner.
Yes. What is that office objection? Petitioner age proof, better copy of the annexure to be furnished. Oh, yes, what is this matter? Yes. 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 No order has been passed on 28A. Yes, Mr. Verify. If it is 28, no. they have to verify. If it is there is an order on 28A, then writ is not maintainable. You have to go before. Yes, you get that info. Verify. If it is pending, then I will. No, are you sure? Then I will direct them to consider. No, no, madam, there is. No, they have produced that 28A application itself. No, what is your case? Have you not yet decided? Then I will dispose of. I will dispose of them. Yes. Because once it is decided, then writ is not maintainable. Yes. In this writ petition. Yes. This writ petition, the petitioner has sought. Government advocate is directed to take notice for only a state. Special land acquisition officer came out to the commissioner office. Who is that? You are taking notice. You will take, yes. Yes, government advocate is directed to take notice for respondent number 1 and 2. Then a counsel for the petitioner is directed to serve one set of copies on government advocate. This petition, the petitioner has sought following relief. The case of the petitioner that petitioner number 1 is the owner of land bearing survey number 23/3 measuring 0.4 guntas. Petitioner number 2 is owner. Paragraph first extent. Then it has been acquired, Mr. The land has been acquired by respondent by issuing a preliminary notification dated 2/2/1989. What purpose it has been acquired? For construction of Hemavati left bank channel project. Thereafter, final notification issue madam. Final notification bakery, other important. Are they referred in that? Huh? 15, huh? Yes. The final notification has been issued on 12/10/1993. Thereafter, the land acquisition officer has passed an award. Being agreed by the same, some of the land loser has approached the civil judge JMFC Nagmangla for enhancement of compensation. Thereafter, some of the landowner has seek for a reference under section 18 of the Land Acquisition Act. The civil judge JMFC Nalmangla in LAC number 51 of 2007 on order dated 26 June 2008 has enhanced the compensation in related to the same notification. Is it, Mr.? Yes, since petitioner has a benefit under section 28A of the Act, they have filed an application by annexure P. Since their application has not yet been considered by the land acquisition officer, the petitioner is before this court. At outside, so and so, government advocate appearing for respondent has submitted that if this court grants some reasonable time, the application filed by the petitioner under section 28A of Land Acquisition Act will be considered in accordance with law. In view of the above, without expressing any opinion on merit of the case, has to decide, madam. The first respondent is directed to consider that application submitted by the petitioner under section 28A of the Act within 3 months from date of receipt of copy of this order. Without observation, the above writ petition is disposed of.
Number 24, Manjunath SC for petitioner, P. Vachan.
Yes, Vacha. Manjunath SV.
Number 24,
Yes, 2 weeks time is granted to do the needful.
number 25, Kallegowda SK for petitioner.
Yes, Kalagat. Weeks time is granted to comply with that.
Number 26, Vannappa S.
For the petitioner, a week's time is granted will also comply. A week's time will be
Yes.
granted to comply the
Weeks time is granted to comply that option.
Number 27, Kallegowda.
Week time is granted to comply that option.
Number 28, Shilpa Ghanshyam.
Milord, I appear for the petitioner in this matter.
Yes, madam.
I'm not sure about like an objection, Milord, but we had filed 2 petitions arising from common.
Madam,
yes,
there are 9 objections.
We'll comply with Milord.
Yes, week's time is granted.
2 petitions filed arising from one common order. One petition was listed on 9th August 2021 and notice was issued in that matter. So I was.
No, but here the office objection is there.
We will comply with office objection.
Yes, yes.
Number 30, adjuncts. Number 31, Mahesha Upping for petitioner.
Yes, Mr. So which is that? How they produce that judgment? Around Madidwala. Yes. B. Government advocate is directed to take notice for respondent number 1. Shivram H is directed to take notice for respondent number 2 and 3. Petitioners are claimed to be a owner of land bearing survey number 155/4, measuring 35 guntas, out of which 1 acre 6 guntas situated at Bogadi village, Mysore Taluk, Mysore district, was acquired by the second respondent for formation of Lalitadri Nagar second stage layout. First petitioner is the owner of the land bearing survey number 155/4, measuring 35 guntas, out of which 1 acre 6 guntas situated in so and so is acquired for so and so. In respect of the respondent number 2, 3, and petitioner number 2, 3, and 4 are owner of 30 guntas of the land. The owner of 1 acre 30 guntas of the land in survey number 155/1 situated in same village, out of which 30 guntas of the land has been acquired for the above said purpose. The preliminary notification has been issued on 13/12/2006. The same has been published in the official gazette on 21/12/2006. Okay. They are the owner of the land, so on, some actually. Second, notification was sought for acquiring of the formation of the layout known as Lalitadripuram second stage, including the lands of the petitioner. On account of said scheme, under which land of the petitioner was proposed to be acquired, having not been executed within a period of 5 years, petitioner before this court contending that within 5 years from the date of the publication of notification in the official gazette under section 19(1) of 1 having not been issued even after lapse of 10 years, the interim notification dated 13/12/2006 published in the official gazette on 21/12/2006 insofar as the petitioner's land measuring so and so is liable to be cost. So and so learned counsel appearing for the petitioner has relied upon the judgment of this court rendered in WP number 3776 of 2018, disposed of on 6/2/2018, whereunder coordinate bench has referred to the order passed in WP number 55088-55089 of 2016, dated 3/11/2016, to pass the notification therein. In similar circumstances, this court has already taken note of the fact that acquisition has lapsed and as such had passed the notification insofar as the petitioner therein are concerned. Similar benefit deserve to be extended to the petitioner herein by allowing their writ petition. 3. H.C. Shriram learned counsel appearing for the respondent. Two and three, and so, or government advocate. So government advocate appearing for respondent number 1 could not dispute the above factual position and submitted that present writ petition could also be disposed of in terms of the earlier order passed by this court. In the opposite circumstances, and the order passed by the coordinate bench referred to herein supra being squarely applicable to the case on hand, the petitioner in being entitled to the relief sought for preliminary notification dated 13/12/2006 is hereby quashed so far as the land belongs to the petitioners are concerned, namely so and so. Accordingly, the writ petitions are disposed of.
Number 32, Nagarjuna Pawan for petitioner.
Yes. 2 weeks time is granted to comply the top subject.
Application matters. Number 33 adjourned. Number 34, for petitioner. Murugesh Reddy.
Yes. Learned counsel for the petitioner pays weeks time to file. Yes, press weeks time. Release this matter of 2 weeks. Press 2 weeks time. Release this matter. Yes.
35, Shivaprasad for petitioner. Prakash Angadi JV.
Yes, Mr.
35, my lord, I appeal for the petition, my lord.
Yes, what is this IF for vacating interim order?
My lord, I have filed an application for direction. The matter is quite simple, my lord. The petitioner's land was acquired by the respondent for widening of road purpose. The notification said, my lord, the loss will be of 106 square meters.
Yes.
Now, my lord, subsequent to their request, my lord, we have already relinquished an area of 126 square meters. Now, my lord, they want to go ahead and demolish the building without even acquisition proceedings. Now, my lord, I have filed an IF for direction to conducting a spot inspection, my lord. And also, my lord, there is a direction by this honorable court that they'll be filing an affidavit. That also they have not done so. On the previous occasion, my lord, they said that they'll be filing objections to my IA for direction, my lord, on which, my lord, adjournment was granted. My lord, all I'm seeking for, my lord, is
time to file an, as per the order taken note for also 6 time to file an there will time to be granted to file an objection. Interim order. Yes, Mr. Have you filed an? No, Mr. Counsel. No, there is already an order from the earlier. Have you complied that? That is that issue. Yeah. Yes. Yes. No, Mr. Counsel, we'll see on that merit. There is a direction from this court in earlier order. Have you complied that, Tanta? That is what first you have to file, then you make a submission for that. Yes. Learned counsel for respondent submits that. The affidavit is ready. The same will be filed in the counter. Release this matter next week. The interim order granted earlier is extended next date of the week. You could have filed it to today itself on 2nd March. Yes, release this matter on 25th. Yes. Interim order granted earlier is next date of hearing. Yes.
Yes.
36, Siddhartha Suman for petitioner, Madanand Pillai, Prakash Angadi, Kavita.
For impleading respondent number 4, Your Lordship. Kindly grant us a week's time to get instructions and file objections.
You are appearing for?
Impleading respondent number 4.
I appear for the first respondent, my lord, Union of India.
What is this, man? Yes. 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 Which petition? Filed for what purpose? Yes. You are appearing for whom? Yes. Yes. Learned counsel appearing for respondent number 2. Submits that. This petition may be called along with that. Yes. Office is directed to post this matter along with the stones. Yes. Yes, yes. Yes. Is there an interim order? Yes. Release this matter on 2nd. That means interim order granted earlier, if any, is extended till next date of hearing. Yes.
Number 37 adjourned, seal number 38, Saramana is for Commissioner, Indian Krishnan M.
Yes.
Surendra, Police.
Yes. Yes. Yes, this is what that there were. Yes. 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 Yeah.
Where this unified plans will have to be looked into once again on high court.
Yes.
Betterment taxes are collected under Section 20 of the Act with respect to property which are mostly under the scheme and
Yes.
subsequently not utilized by the video. As a result of which, the value of the property has gone up. And then, my lord,
This is also one of the denotified land petitioners.
because there the notification, final notification, then subsequently, my lord,
No, that Justice Arvind Kumar's judgment, where it is directed all denotified cases has to be relooked.
in fact, I should not be saying this, my lord, they came to heavily upon the BDA. There is, my lord, the honorable Lord Justice felt that the directions of the Supreme Court were being misused and recklessly lands were being removed.
Yes.
I know that judgment cannot have produced that parent copy. Only
No, it is there. Yes.
last
Paragraph you want to find out.
many paragraphs is said, but I only take my lord last operative part, not at the judgment page number 152. KL
52. Yes.
before that, page 720, sorry, 720, page number 720.
7. Yes. Yes. No, you are relying on that internal page or ink page 7?
Judgment page.
Judgment page 720. No. Where you are reading from that?
From starting.
720 start from past denotified certain lines.
The fact remains that
Yeah.
details are related from a position of post-advisor actors, which was subject matter of final notification, photograph, etc. In the circumstances in which lands have been denotified cannot be beyond the parameters fixed by the division bench as well as by honorable FX court in Gondur Ramaswamy case.
Yeah.
However, on perusal of records made under BDA based court, it will disclose that in several cases where special land acquisition officers are maintaining the excess of the thing court along with revenue inspectors as recommended for denotifying the land and BDA on the ground that there is inconsistency between the said report as well as report of customs commissioner has not accepted the report of special land acquisition officer and thereby has not deleted or denotified the land. However, in previous circumstances, this case to unfold is the fact that large tracts of land, though vacant, not developed, and not falling within the parameters fixed by the regional bench and the honorable ethics court has also been deleted or denotified. It is in this background excise so obtained by BDA requires to be scrutinized at micro level.
Yes.
Then my lord, the committee was of this thing, and they have now this committee has started its sitting, headed by his lordship.
Now that committee has been directed to look into that all denotified land also.
In fact, they say after all this.
No, that have you challenged that all denotification before this learned single judge? That is the issue before this.
Initial representations were challenged by persons who had lost their revenue initially, because BDA just went on farming land, etc. Then, my lord, the number of matters kept on increasing. Then people who were initially allotted sites and the lands were denotified, so they lost the BDA. They also. Then, my lord, some people challenge the acquisition also. So all kinds of mix and match.
No, this petitioner in this case is also petition.
This petitioner had not challenged any of the acquisition, but he had not the benefit under the Honorable Supreme Court order.
Yes.
What happened was, initially it was notified.
No, his land has been notified.
Then final notification was there. Then, my lord, the batch of petitions challenged those notifications.
Yes.
It was not there.
Yes.
But however, he benefit, what happened was, the Honorable Supreme Court saying, there's some criteria, identity, the land should be left, etc. So many criteria.
No, on that basis, he has filed an application. You denotified. Yes.
The guys of the
No. Yes, yes. That is what that has happened in that all cases. Now that in view of this judgment, that committee has to look into that matter also.
Whether even this land also, whether we have committed illegal.
Then the committee has given power to submit a report or say that it is
given all powers to submit its report and final report the action to
government. Now, suppose committee tomorrow held that these lands are all denotified contrary to that law, then is it a power for the government to relook and do it?
No such powers are reserved, my lords, by the division bench. Justice Arvind Kumar has never indicated that this has to be again inculcated as a part of the scheme.
What will be that happen?
Unfortunately, this issue was not envisaged when the matter was taken. Probably this is just a small number of applicants. This probably did not go before the court. So it's a gray area. I think I cannot say much.
Yes.
Lords, may I make this submission, my lords?
Yes,
Lords,
yes, you have completed. Let him finish.
Please.
Then, if you want any reply.
Very well, my lords, very well.
I'm not saying that we have no power, etc. I only want to bring
No,
the
we are not considering this matter in this case. Just I have generally asked, what will be that effect?
I fear that supposing if it is held, if not this party, some other.
No, generally, if that's
generally that all these savings are done, etc. Then there may be another round of litigation.
Now that committee report, if it is accepted, then you have to denotify all that land. Then they will challenge that whether you find out your power and all. Yes.
If it is not in conformity with the order passed by the judge, affirmed and clarified and enforced. So what they
No, any of that we are not on that issue. Just
we are
I.
not on that issue.
Yes.
But this is unfortunately that land which is deleted after the Supreme Court. So it is now going to be examined whether if it is as per the conditions, then that's all I want to bring to this court.
Yes. Yes, Mr. Ravishankar. That's all.
That's it. The VDA cannot have a dualistic stand. Lords, in respect of all other properties, whatever they have extended, they don't want to extend in my favor is what I can submit.
Oh, yeah, but here, what is that order which you have challenged? Annexure G.
Lords, please, my lords. There,
What is that
Lords, Annexure G is merely a demand notice for the purpose of payment of the betterment taxes. Lords, what we have stated is because of the.
Yes, we'll consider. Yes.
Please, my lords. That's all.
Government Council for petitioner and the respondent. Serial number is
28.
On IA 1 of 2022 filed by the petitioner for direction. 3. Ravishankar, learned senior counsel appearing for the petitioner, has submitted that the petitioner has challenged the demand notice issued by the BDA for payment of betterment charges. This code by order dated betterment tax. Yes, betterment tax. Betterment tax. This code by order dated 22/12/2021 has stated that impugn demand notice for payment of betterment tax annexure G and also made observe that interim order will not come in the way of the BDA to consider the request of the petitioner for issuance of work order. Pursuant to that, we have issued an work order. No, now he is seeking for modification. Pursuant to that, the BDA has issued an work order.
Work order has been issued earlier itself, my lords, on 4/7/2018. Now, the BDA has made it a practice because of the order passed by Justice Krishna Kumar. The BDA says that we will issue a work order only if you give an indemnity. But when we approached, they said that you don't have an order to this effect. Therefore, we were compelled to come before your lordships to say that let them issue a fresh work order by incorporating that indemnity clause.
An interim order. This interim order will not come in the way of BDA to issue a work order. Thereafter, the petitioner has approached BDA to issue modified work order after collecting the indemnity bond for betterment charges. He contended that in this court, in identical circumstances, in writ petition number 5346 of 2021, has granted a similar relief, directing the BDA to issue a modified work order after obtaining indemnity bond for a payment of betterment charges. Hence, he sought for similar relief.
BDA has acted on this interim order and issued a modified work order, page number 10.
Yes, pursuant to that order in that writ petition, the BDA has issued a modified work order in respect of the petitioner therein. Hence, he sought for allowing his application. IA 1 of 22. 3. Unni Krishna, learned counsel appearing for when that division bench has passed an order. That Justice Arvind Kumar 27/9/2021. After that, you have issued. In other cases, that cannot be a ground. Now it is issued on 30/9/2021. Annexure 10, page 10. Contended that in respect of acquisition of the land related to what is that what Arkavati layer. Arkavati layer. Is it a single judge or a division bench? Single judge. Yes. This court in WP number 42063 of 2012 and connected matter on 27 September 2029 has constituted the committee of Justice, Honorable Justice A.V. Chandrasekhar Keshavan. What is that full name? Keshav. It's KN. Yes, Justice K.N. Keshav Narayan, and directed to consider all matters related to the denotification made by the state government in respect of Akavati Layer, since the matter is now pending before the committee. The petitioner request cannot be considered. Heard the learned counsel for the parties. IA. This court heard on IA. The Bangalore, the BDA has already issued work order in favor of the petitioner on 4/7/2018. Thereafter, they have issued an impugned notice demanding betterment charges that has been challenged before this court in the above writ petition. This court has granted an interim order, say that Annexure G, and it's also made clear that this order will not come in the way of the BDA to consider the request of the petitioner for issuance of work order. This court in identical matter in WP number 5346 of 2021 has directed the BDA to issue a modified work order after obtaining necessary indemnity bond in favor of the BDA in respect of betterment charges. Pursuant to that order passed by this court in WP number 5346 of 2021, the BDA has issued modified work order in favor of the petitioner therein on 30/9/2021. In view of the above, the application filed by the petitioner is allowed. The BDA is directed allowed. The petitioner is permitted to execute the necessary appropriate indemnity bond in favor of the BDA
within 1 week. I'll file it.
Yes.
I'll file it within 1 week.
Yes. BDA in the appropriate format within period of 2 weeks from the date of the receipt of the copy of this order. In respect of betterment charges demanded by the BDA. If such indemnity bond is executed, the BDA is directed to issue modified work order in favor of the petitioner. This is subject to result of this petition.
That your lordship may fix a time, your lords. Within 2 weeks, let them issue the work order, modified work order.
The BDA is directed to issue work order within 4 weeks from the date of petitioner executing the indemnity bond in favor of the BDA.
Grateful.
Yes. This is subject to the result of the petition. Yes.
Number 39, Vikas M. for petitioner.
Yes. 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 Who? Yes. Yes. Yes.
in this state, no housing board has allotted to any site, and hence we have allotted a site. This person has already been allotted a site. Suppressing the fact that already been allotted a site, is obtained a site here also. Principal, I made a representation stating that this matter is referred for central committee, just to select committee member. The committee itself is one for this purpose member. Many persons in my
Now, who are you?
and the petitioner who has also been allotted a site. Same site. It has
Yep.
been allotted to us.
No, that site which has been allotted to you. When?
Now, one site, two sites, madam. Those sites have been executed by the
No, that's what that. When that site has been allotted to you.
I guess that it is allotted or not. Yeah, it is allotted, subsequently allotted to madam.
First, it has been allotted to that. Yes.
No, allotment must be madam.
That's what I am asking.
It has been executed first to madam.
You give me the date.
To 2019 madam.
12 to?
2019.
Yes. When it is allotted to that respondent number 5, 3. And then how can you make such an casual approach to that court? You don't know when it is allotted to, whether it is allotted to third respondent earlier than your allotment or not. Nothing is forthcoming.
The reason I have amended for the entire case changes, madam. Under Justice Committee was formed, madam, to scrutinize all sites which has been allotted to G category.
No, that's no. See, Mr. It is a dispute between you two. First, you have to make out a case, your rights on that property. Otherwise, it has to go before the public interest litigation. Since it is in a writ petition before me, because your right is affected, then you have to make out in a case how it is affected, whether you are granted earlier or that respondent is granted earlier. Is it not? Otherwise, you can straight away file an application in the PAL saying that I'm a citizen of this country, this site has been allotted contrary to that BDA regulation, then court will refer to that. But it is the case here, your case is that the very same has been allotted to you. Whether it is allotted to you first or in third respondent has to be seen before considering to refer to that committee. Is it not? Your right has to be established. Where is that? You get that information when it is allotted to him, whether it is who is appearing for respondent. PDS heard, Deputy Secretary, amendment filed by the petitioner. Yes. Respondent number 1 is served. 1 and 2 is served. Gopal Bilmane is directed to take notice for respondent number 1 and 2. What about 3? 3 again notice and ಇಲ್ಲಿ ತೋರಿಸಿಲ್ಲ 3 served. Respondent number 3 is served. 1 and 2. No, BDA. Let the BDA comes, then we'll consider your district. I will direct it to take notice. Yes. Release this matter of 2 weeks.
Number 40, Sharath Road of petitioner, PV Chandrasekhar.
My lord, I am for the second respondent.
Yes.
My lord, IA number 1 of 21 is filed by me.
Yes.
My lord, on behalf of Nandi Economic Corridor, my lord, which is the project company.
Yes.
My lord, the petition, prayer in the petition is to allot incentive sites in terms of the incentive scheme to the petitioner. I am not disputing.
My lord, I have to petition, my lord. My lord, we have no objection in including the.
Yes, Mr. Nitin.
Yes, sir.
What has happened to that all this nice matter has to be constituted by the division bench pursuant to the direction?
My lord, that is an order, my lord, dated 18th of January 2011.
Yes.
Passed by the Honorable Supreme Court, my lord, at that time, only relating to matters which were pending as on that day, my lord, not all matters subsequently.
Where is that thing? Huh? Beneficial. That is in. No, is it that Supreme Court said only in related to that acquisition? You have that copy of the. You've furnished that copy to that court officer.
because
number of matters is coming before me. First, I have to see whether I have any jurisdiction to decide or not. Tomorrow, otherwise, after.
My lord, that one of the matters where Mr. S.V. Bhatt made that submission, that your lordship has posted tomorrow, my lord. That is there. Yes, my lord. My lord, what they only said was, my lord, they requested the Honorable Chief Justice to constitute a bench because the state government made a submission before the Supreme Court that there are several litigations pending and the project is not able to be proceeded with. So as on that day, they made that submission. They made that order, not going forward. We'll produce it.
Yes. IA 1 of 21 is filed for impleading by proposed respondent. Learned counsel for heard the learned counsel for the petitioner and counsel for proposed respondent. Learned counsel for the petitioner has submitted that he has no objection to allow that application. There is that affidavit filed. There is that affidavit filed along with that application. Be satisfied with clause 1 in that affidavit. IA 1 of 2000. IA 1 of 2022 is allowed. What is that IA 1?
My lord, 1 of 21 is filed.
Now, IA 1 of 22, again that impleading, who has filed that?
Petitioner has filed. To implead the planning authority, my lord, who has given me the permission to develop this layout to distribute incentive sites, but they have not, my lord, released the balance land to me to be able to finish the layout. They are necessary parties, my lord, in this.
And then notice has to go for them.
Yes. Yeah, Mr. Yogesh Naik may be directed to take notice.
Yes, yes. IA 1 of 2022 is your IA, Mr.
Petitioner's IA.
1 of 22 is filed by the petitioner. Which is your IA, Mr.?
IA 1 of 21.
Yes. IA 1 of 21 is allowed. The proposed respondent is permitted to come on record
as respondent number 5.
Respondent number 5. Learned counsel for the petitioner is directed to amend the cost title. Issue notice on IA 1 of 2022. No, that before notice has to go. It is not that they have been a respondent directed to take notice. Is it not? They have not yet been made as in a party. Yes. Issue notice on IA 1 of 2022. Yogesh Naika.
Also.
Yes. The petitioner is permitted to serve IA copy on Yogesh Naik. Yogesh Naik, who is panel counsel for impleading respondent. Yes.
Great.
Yes, Venugopal. What is? Yes.
IP for the petitioner lordship.
Yes.
Serial number 41 and 42.
Yes, Mr. Yes, Venugopal.
I may be permitted to take back the petitioner lordship because we have been permitted to go before the committee. We'll go before the committee because other matters have been dismissed.
Yes. How you want? Which committee?
Justice Chandrasekhar committee, Your Lordship.
Oh, yeah, which one? That is Shuram Karan.
Yes, Your Lordship.
Learned counsel. Yes. Learned counsel appearing for petitioner through VC has submitted that. As submitted, he may be permitted to withdraw the writ petition. Submission of learned counsel for the petitioner is taken on record. The above writ petition is dismissed as withdrawn. Yes. What about 42, Mr.
Both.
42.
Yes,
you take notice. You take notice. 42 alilla. 42, same matter.
Same place, Lordship.
Then
Same.
we will take-
Both is the same.
Yes, K. Krishna, government advocate is directed to take notice for respondent number 1. K. Krishna is directed to take notice for 2 and 3. Same submission. 42 is also same.
Please, Your Lordship. Please, Your Lordship.
43 also same, sir. Oh, but different. Yes. Yes, you are appearing for 43, Mr. Yes. Yes. What do you want? You want to withdraw? You are before the committee. You can't prosecute the case here. Either has to challenge. If you want to go before the committee, then we will decide on the basis of that covered judgment. Yes, who is appearing? Who is not? No, it is covered. Either you have to choose to go before that committee or that there is a division bench. Yes. Now, who is that? Shankar Narayan. Shankar Narayan, tomorrow. Tomorrow. No. If it is covered, why? What is it? Mister, I will grant that. No, I will see. You are an instructing council, is it not? You cannot be say that you are in a limited this thing. You are in a proxy. Then we'll have it. Yes. No, Mister. If it is covered, what is the purpose in dragging the matter? Otherwise, I will grant time in all cases. There is no dispute. Therefore, I will grant time, not 2 weeks. Yes. Wait. Wait. Yes. Oh, if they say if they are not, then we'll decide on terms of the. Yes, Tuesday. Monday. Yes, Monday. Yes. Yaar appear kare. No, you say that advocate's name, sir. What is the wakala? ಏನು ಅವ್ರ ಹೆಸರು ಏನಪ್ಪ? ಅಡ್ವೊಕೇಟ್ ಹೆಸರು ಹೇಳಪ್ಪ. Swami Shiv Prakash. Office is directed to delete the name of V.V. Shankarnan Rao, counsel for the petitioner. Show the name of Swami Shiva Prakash as a petitioner in the cost list. Yes, release this matter on Monday. Yes, third Monday. All that on Monday. Monday list. In view of that, IA will not survive that consideration. Yes, Mister. Yes. 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 Yeah. Yes. No, now that Manish, what he wants. No, is there any interim order in you? You have sought? Yes, we will have it on 2nd March. On 28th March. 28th, yes. At the request of counsel for the respondent, release this matter on 28th. 28th February. Yes. 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 Why today you have income? Yes, release this next week at the request of counsel for the petitioner. Release this matter next week. Yes.
ನಿಮಿಷ ಇರುವಂತೆ ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸ್ ಸರ್
ಕೋರ್ಟ್ ಆಫ್ ಸರ್
ಹೇಳಿ ಸರ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 44.
ಸೀರಿಯಲ್ ನಂಬರ್ 62 ಯಾರು ಅರ್ಜೆಂಟ್ ತಗೊಂಡಿಲ್ಲ ಅಲ್ಲ 62
ಯಾವುದು 62
60 ಹಾ ಸರ್
ಯಾವುದು ತಗೊಂಡಿಲ್ಲ.
44 44 ಏನಾಯ್ತು?
ಹೇಳಿ ಸರ್. ನೆಕ್ಸ್ಟ್
54 ಸರ್.
44 ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಆಯ್ತು. ನೆಕ್ಸ್ಟ್ ವೀಕ್
ಸರ್ 54
54 ಇದೆ.
ಥ್ಯಾಂಕ್ ಯು.
50 50
50 ಇದೆ.
ಹಾ ಓಕೆ.
ಬನ್ನಿ ಬೆರಡೆ ಪಕ್ಕದ ರೋಡ್ ಇದೆಯಲ್ಲ ಆ ರೋಡಿಗೆ ಬನ್ನಿ ರೈಟ್ ಸೈಡ್ ಮೂರೇ ಬೆಳಿಗ್ಗೆ
What we asked for request for 4 o'clock, it was 3 o'clock. Request for 4 o'clock.
My lord, I pay for the.
This is for that purpose only. Where she is set up? 230 she said you should. Where is she set up? In which cap? About that matter. Yes. Password.
Matter, cell number 44 adjourned, cell number 45, you can be resolve your petitioner, matter, those are the example.
Serial number 45, I'm appearing.
Yes.
In both these matters, my lord, recall the question is only about the application of section 34 of the Land Acquisition Act, my lord. The lands
Yes.
have been acquired, but no compensation has been paid to date.
Yes.
Government advocate had said. Swami, ಕೇಳಿಸ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ.
Yes. 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 No, that what you are saying, that compensation. Now they are saying that they are not on that acquisition.
Yes, my lord. We only want compensation, my lord. From
It will
2000.
be recorded that you are. Yes. No, that you will live up, madam. Unless you said that yes, you are granting that land. No, order it is there. Subject to you say yes. No. Tomorrow your authority says that no, you cannot be. Then he is giving up this prayer. No, you take it that he is not pressing that prayer. Subject to you are considering his case. No. Order cannot be passed, madam. Only seeing that yes, if you say that yes, we are ready to that considering his case for a second prayer, that will give up.
Please, my lord. We are asking for compensation, my lord.
Compensation are they ready to give? No, order from the court giving up, it is there. He is making a submission before the court. It has to be done at a time. You have to say that yes, you are giving another, then I will record his submission and pass an order, final order at a time. It cannot be two order today and tomorrow.
And under section 34, my lord.
No, you are ready. Now that Mr. Clifton, you are saying that if they given a compensation under the alternative land, you are ready to give.
My lord, we are only claiming compensation along with interest under section 34, my lord. Every other claim we are giving up. Under section 31,
what is this? ನಮ್ಮ ಸಮಸ್ಯೆಗೆ ಮಂಜೂರು ಮಾಡುವಂತೆ ತಮ್ಮಲ್ಲಿ ವಿನಂತಿಸಿದರು. ಸದರಿ ಮಂಜೂರಾತಿ ಸಂಬಂಧ ಸರ್ಕಾರದ ಸಂಬಂಧಿತ ಎಲ್ಲಾ ಶರ್ತುಗಳನ್ನು ಪೂರೈಸಿ ನಿಮ್ಮ ವಿದ್ಯಾಸಂಸ್ಥೆಯ ಹಿತದೃಷ್ಟಿಯಿಂದ ಅತಿ ಶೀಘ್ರವಾಗಿ ಮೇಲಿನ ದಿನಗಳಲ್ಲಿ ಮಂಜೂರು ಮಾಡಲು ಸೂಕ್ತ ಆದೇಶ. Now what has happened? If they are giving up that land acquisition, are you ready to what is this order? ಮೇಲೆ ವಿವರಿಸಿದ ಅಂಶಗಳ ದಕ್ಷಿಣ ಕನ್ನಡ ಜಿಲ್ಲೆ ತಾಲೂಕು ಶ್ರೀ ಮಂಗಳೂರು ಇವರಿಗೆ ಕರ್ನಾಟಕ ಭೂ ಮಂಜೂರಾತಿ ನಿಯಮ ಮಂಜೂರು ಮಾಡಲು ಸರ್ಕಾರ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಸಲ್ಲಿಸಬಹುದು ಎಂದು ಅಭಿಪ್ರಾಯಕ್ಕೆ ಸಂಪೂರ್ಣ ಕಡಿತವನ್ನು ಲಗತ್ತಿಸಿದೆ. Then what has happened later? Yes. Yes. Now that you are seeking for an compensation or that land, Mr.
my lord, the relief that I had sought for in this petition was for lapse. In light of
Yes.
the Constitution Bench judgment, my lord, Honorable Justice Arun Mishra in the Indore Municipal Corporation case, lapse doesn't exist now. I'm praying, my lord, that I should be paid compensation along with interest under section 34. That is all I'm praying for, my lord. I'm not asking for anything else.
Yes, where is that? No, I will dispose of in terms of that.
Please, my lord. Section 34 may please be seen, my lord, where when compensation is not paid.
Yes.
Land Acquisition Act, my lord.
Yes.
Section 31 may please be seen first. This was acquisition, my lord, under section 4 read with section 17, the urgency clause. Section 31
Yes.
is payment of compensation. Can I please read?
Wait. Yes.
Section 31, please. On making an award under section 11, the collector shall tender payment of the compensation awarded by him to the persons interested entitled thereto according to the award, and shall pay it to them unless prevented by someone or more of the contingencies mentioned in this next subsection.
Yes.
If they shall not consent to receive it, or if there is no person competent to alienate the land, or if there be any dispute as to the title to receive the compensation or as to the apportionment of it, the collector shall deposit the amount of compensation in the court to which a reference under section 18 would be submitted. So, my lord, when my land is acquired, there are only two options. You either pay me the compensation or you deposit it in the court. I already pointed out to the right information, my lord. They are not deposited in the court. My lord may please see page 35 of my writ petition. Neither they have paid me. Page 35, please.
Yes.
Point number 4. ಧನ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಠೇವಣಿ ಇಟ್ಟಿರುವ ಬಗ್ಗೆ ಮಾಹಿತಿ. ಭೂ ಪರಿಹಾರ ಧನ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಠೇವಣಿ ಇಟ್ಟಿರುವುದಿಲ್ಲವೆಂದು ಮಾಹಿತಿ ನೀಡಿದೆ. So admittedly, they have not paid me. They have not deposited. My lord may please see the consequence of that. Section 34. Yes. Section 34, my lord. When the amount of such compensation is not paid or deposited, or on being taken on or before taking possession of the land, the collector shall pay the amount awarded with interest thereon at the rate of 9% per annum from the time of so taking possession until it shall have been paid or deposited, provided that if such compensation or any part thereto is not paid or deposited within a period of 1 year from the date on which possession is taken, interest at the rate of 15% per annum shall be payable from the expiry of the said period of 1 year on the amount of compensation or part thereof which has not been paid or deposited before the date of such expiry. So my humble submission is, my lord, my lands, the award was passed on 15/5/2007. Possession has been taken. I have not been given any compensation. Neither the compensation has been deposited in the court. By virtue of the operation of section 34, I am entitled to that compensation with the payment of interest as per section 34, my lord. That is my very humble submission.
Yes, ma'am. Yes. Now that I will dispose of saying that he is not pressing that prayer for challenging the acquisition on the ground of lakhs. His only relief is sought for payment of compensation. In view of that, you pay that compensation with interest.
Please,
Yes.
my lord.
Is it, Mr.?
Yes, my lord. Absolutely, my lord. That's my only prayer.
Yes. No, if you pay that compensation, he is not entitled for the land.
Please, my lord. That goes without saying.
Yeah, without say. Yes. This petition. Petitioner called in question acquisition of land by state government and Land Acquisition Act. He is called in question notification issued by the government under section 4(1) of the Land Acquisition Act dated 17/7/2006 and notification issued under section 6(1) dated 31/1/2007 on the ground that acquisition is lapsed in terms of section 24(2) of the Act 2013 Act full act. And he further new act. When the matter is taken for hearing today, the Senate Council appearing for the petitioner outside submitted that if the respondent is ready to pay the compensation.
It is respondent number 1 and 2, man.
Respondent number 1 and 2 pay the compensation to the petitioner in terms of Land Acquisition Act. He will not press for challenging the acquisition.
Along with interest, my lord, under section 30.
No, I said in terms of Land Acquisition Act, it covers everything.
Please, my lord.
Yes. Government advocate appearing for the respondent has submitted that. On instruction has submitted that.
No, it's a respondent number 1 and 2, man.
Yes. Government advocate is appearing for 1 and 2 only.
Yes, madam.
1 and 2.
Yes. Yes, 1 and 2 on instruction submit that. Since the petitioner land has been acquired under the said notification, the petitioner case for and award is also passed as per annexure.
See, my lord.
Award is also passed by the authority. Since the position is already taken, petitioner request for payment of compensation will be considered in accordance with law. It is not in dispute. Petitioner is a owner of property bearing survey number 111/2 measuring 3.75 acres and survey number 114/2 measuring 2.04 acres situated in Malur village, Mangalore Taluk, Dakshina Kannada district. The same has been acquired by state under Land Acquisition Act by issuing a preliminary notification on 10/8/2006 by invoking section 17, emergency clause.
Please, my lord, section
By
17.
invoking section 17 of Land Acquisition Act, the final notification has been issued on 15/2/2007 under section 6 of Land Acquisition Act. Since they have invoked the emergency clause, it is also not in dispute. The respondent has taken a position of the property of the petitioner. Thereafter, the award has been passed since
15/5/2007, my lord.
15/5/2007 as per Annexure C. Since the award amount has not been paid to the petitioner, section 34, as per section 34 of the Act, the respondent has to pay interest at a rate of 9% per annum from the date of taking a position till amount has to be paid. If the compensation amount has not been paid within a period of 1 year from the date of taking a position, they have to pay the interest at a rate of 15%. In view of the above, the respondent is directed to pay that interest, pay that compensation amount with interest as per section 34 of the Act to the petitioner in respect of their land which has been acquired pursuant to the above said notification within 3 months from date of receipt of copy of this order. Accordingly, the writ petition is disposed of.
Grateful, my lord.
But it should be direction should be on response number 1 and 2, my lords.
You have proposed for that. Now you are paying that, you drop that for allotment of the land. You can't do both. Yes, that's what. You pay with that. He himself was saying that it can be paid with that interest. Yes, what about that next matter?
The direction is to response number 1 and 2, my lords.
Yes, yes, 1 and 2 only. Direction. Respondent number 1 only. Yes.
Connected
What
matter
about this connected matter?
Same, my lord, same. The second piece of land, survey number 98/11, measuring 0.16 acres, and survey number 98/12, measuring 50.5 acres, 98.
Notification is
Same, my lord.
yes. Idrali land bearing survey number 98/1, measuring 0.16 acres, 98/12, measuring 0.50 acres, 98/13, measuring 0.20 acres, and 185/1, measuring 1.53 acres, situated in Kejara village, Mangalore Taluk, Dakshina Kannada district.
My
All
lord,
other things are
preliminary
same.
notification date is 12/10/2006.
Yes, same notification, is it not?
Well, it's for the same project as another notification parallelly issued. It's all this was for the Mangalore airport, my lord. This acquisition. The preliminary notice.
This land has been acquired under preliminary notification dated on 12/10/2006.
Please, my lord. Final
Yes, and final notice 3/2/2007.
Award is 7/5/2007.
Award is 7/5. Award is same time.
Yes, ma'am.
Award is 7/5/2007. Yes.
Grateful, my lord.
Yes, government will fit some.
Third respondent appearance may be in marked minutes.
Yes, yes, your presence is there. Yes, your name has been shown.
Yes, ma'am.
Yes.
After matter, serial number 90, Karnataka Joyce Commissioner,
Yes, madam, ready. Yes. Yes. Now, what you say about that proposal which has been sent by the government? No. Yes. Material. Yes. N. Yes. Yes, that is that issued by that director. No. No. See, that has been addressed by that Gauli. Now, your case is, you see that resolution passed by that government. After that, he has requested for the government.
No, government
also,
resolution has to be passed by the medical council, not by government. The resolution has to be passed by the.
You have mixed up your case. After that, you yourself has given a representation to the government saying that I can be considered for a reappointment. For that, there is a decision of the government. I am asking the government advocate, what has happened to that?
Page 48, my lord. That also
Page 45. Page 45. After rejection, he has given a representation. Government has taken a proceedings saying that his case can be considered for as a fresh appointment. You see that page 45. Para 25. Hmm. 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 That's what that even that Gauli is saying. For that government, that's why I'm asking what you have done for that. Suppose if he has ready to consider for his case, he has no objection because he has not worked, only he has worked 2 years. He himself has given a request to the government, I may be considered as a first appointee. Now he is giving up that all his.
No, my lord, I'm sorry. I'm sorry,
Therefore,
my
you
lord.
have
Page 48, my lord, annexure, yes. Annexure, yes. Government decision has taken after the recommendation. Government took the decision. Page 48, annexure, yes.
ರಾಜೀನಾಮೆ ನೀಡಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸದರಿ ಅವರಿಗೆ ಮರು ನೇಮಕಾತಿ ನೀಡಲು ನಿಯಮಗಳಲ್ಲಿ ಅವಕಾಶವಿರುವುದಿಲ್ಲ. ಸದರಿ ಸಮಸ್ಯೆ ಸದರಿ ಹುದ್ದೆಯ ನೇಮಕಾತಿ ಪರಿಸ್ಥಿತಿ ಪುಸ್ತಕದಲ್ಲಿ ಭಾಗವಹಿಸಬಹುದು. Yes. ಜೋಸೆಫ್ ಅವರು ಈ ಎರಡು ಸಮಸ್ಯೆಗಳು ಸ್ವಯಂಕ ಸಮಸ್ಯೆಗಳಿಂದ ಪ್ರಸ್ತಾಪಿಸಿರುವ NPR ಸಹಾಯಕ ಅಧ್ಯಾಪಕರ ಹುದ್ದೆಗೆ ಈ ಹಿಂದೆಯೇ ರಾಜೀನಾಮೆ ನೀಡಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಮರು ನೇಮಕಾತಿ ನೀಡಲು ನಿಯಮಗಳಿಗೆ ಅವಕಾಶ ಇರುವುದಿಲ್ಲ. ಆದರೆ the consideration ಅಧ್ಯಾಪಕರು ರಾಜೀನಾಮೆಯನ್ನು ನೀಡಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ this is wrong. This is what is canvassing. Under 252, it is not that resignation that you have to be considered. He has retained the lien. Then he has that is yes. 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 Now that he has made out, he need not say that I have a lien. It is law itself is provided. Not 252. This court has considered the word lien. You read the judgment of this court. Yes. Once he has confirmed in this court, his lien is there. That is what the finding of this court. You read that para 16. The post cannot be terminated even in his own consent under any of the circumstances. Yes. Yes. Hmm. Hmm. Yes. Now you come to that conclusion. That is not that provision has been extracted. Yes.
No, what are you attempting?
Unless she has obtained a permanent post where she has applied, lien will be there. Yes. 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 Yes, yes. Hmm. No. That is secondary. First, his case is he has taken a permission, resignation. After taking a permission, he has attended that interview. He has selected. Then he has resigned. There may be a other resignation earlier, but resignation with specifically where they have been considered, that is where he has said that since I have taken that post, I am resigning. See, now you are taking that earlier resignation where personal, for the personal problem I have resigned. Now that board saying that since you have resigned for a personal problem, lien cannot be maintained. That is not the case. You see that entire case, it is not the personal. Yes, that I will consider. Yes. 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 No, that is not the 252B. Wait. Resignation of an appointment to take up with a prior permission another appointment, whether permanent or temporary, service in which he is not fitting under A, his case is under B. Yes, you read it. Yes. Yes, yes. Yes. No, you both are banking on that. His resignation is for a personal reason, therefore it is not for an, that we'll consider. Yes.
Lord,
Yes,
I
that's
have
all.
got a submission. I have got a submission
Yes,
to make,
yes.
my lord. I should not be misunderstood. I have to say that if the government takes a decision, I have no objection. No, my lord. I am appearing for the institution, my lord. I oppose the returning back of the petitioner, my lord, to our institution for the reason, my lord, that he has resigned from the post on personal grounds. I have pointed out the, I have referred to the, one submission, my lord, one submission. I have referred, my lord, to the, to his letters seeking resignation on personal grounds. You lordship kindly appreciate that aspect of the matter. Before proceeding further, my lord, what I am trying to say is that we are not under the control of the government. Though, however, any decision taken by the government, my lord, we are bound by that. But the government has not taken a decision. Except annexure, yes. Except annexure, yes, my lord, is the decision taken by the government.
Yes.
Page 48.
How that, whether the decision has been taken by applying that mind.
Then
Government
they
has
should
taken
be
the
asked to
decision.
reconsider, my lord. In that event,
this finding of the government is not correct. It is contrary to that material.
in that event, my lord, in that event, government has to be redirected, directed back to reconsider the same. I have no objection for that.
Yes.
Because what happens is now, my lord, someone else is working in our in that post. It's almost 6 to 7 years now. And we don't know what are the consequences of his coming back to our institution. And your lordship kindly appreciate, my lord. Your lordship kindly appreciate the objections, my lord, which I have filed by producing the documents only to show that his intention, my lord, is not to come back. His intention is to go back. At the outset, my lord, he doesn't even express his intention to go to Jodhpur, my lord, on his appointment. No. Your lordship kindly see the documents which I have produced. No, his intention, my lord, is to get himself relieved after we accepting his resignation. And he makes a representation to the state government to accept my resignation. I have given the dates and events, my lord. I have given.
Yes. 16/9/2016. Where is that?
Annexure R1 dalli, let us be clear on facts, my lord. Annexure R1 dalli, he makes a representation on 17/6/2016. Annexure R1, page 11, my lord, in the statement of objections filed by me on 3/7/2011 to 2021. In that, my lord, Annexure R1 is a document where now the petition is attempting to twist his stand. That is not permissible, my lord, is my submission on behalf of the institution. R1 may kindly be seen, my lord. R1 of the statement of objections which I have filed on 3/7/21.
Yes.
ಇದು ಆ ಜಜ್ಮೆಂಟ್ ಗೆ ಇದಕ್ಕೂ ಬರೋದು ಆ ಜಜ್ಮೆಂಟ್ ಬೇರೆ ಈ ಫ್ಯಾಕ್ಟ್ಸ್ ಬೇರೆ ಆ ಫ್ಯಾಕ್ಟ್ಸ್ ಬೇರೆ ಈ ಫ್ಯಾಕ್ಟ್ಸ್ ಬೇರೆ R1 may kindly be seen, my lord, page 11.
I will answer.
If the ಅಲ್ಲಲ್ಲ ಈ ಸಬ್ಮಿಷನ್ ನಂದು ಸ್ವಲ್ಪ ರಿಟೇಟ್ ಮಾಡ್ತೀನಿ ಸಬ್ಮಿಷನ್ಸ್ thereafter you can I have no objection, madam, if the government is directed to reconsider the matter. I have no objection. But to grant him a positive relief, my lord, I am seriously opposing. R1 may kindly be seen, my lord, page 11. I understand, my lord, from the beginning, if we had an intention to secure an alternative appointment. Alternative appointment is secured our whole. Now we are not coming in this way of seeking alternative appointment. Now your lordship kindly say, my lord, on 17/6/2016, he himself writes, my lord, saying that assistant professor, because of some personnel, to accept my resignation and relieve me from the duties on the afternoon of so. He indicates the.
Mr. Gowdy,
yes, ma'am.
You have not acted on that earlier request made by the petitioner. Subsequently, our request, your permission is, where is that? Which is that permission, Mr.?
Permission, my lord, is at annexure R.
Annexure G, page number 23. Your lordship had asked the relevant question because he wants to avoid that, but kindly see annexure G 23. What is accepted? What is accepted is my representation dated 19/8/2016. Annexure G refers to my representation of 19/8/2016. That 19/8 representation is annexure F, my lord, page number 21. 21 to take up the page number 21, my lord. Kindly see. What is accepted ultimately is page number 21, my lord. Page number 21. Resignation to the post of assistant professor, relieving order and certificate. With respect to the
made your case.
One nimsha.
Wait,
R4. Your lordship kindly see, my lord. The letter addressed by him on 19/8/2016.
Mr. Gowdy.
Yes,
Mr. Gowdy, you have argued on that point. Understood that your case is that throughout her career she used to give a representation seeking for an.
Astella. Yakendre, I am not speaking about his old this thing. No. I am speaking out of the present representation made in respect of his prospective appointment in Jodhpur. That's what I am referring. I am not referring to 2010. 2010, I brought to the notice of the court only to see that, only to make out a point that he is in the habit of resigning, withdrawing, resigning, withdrawing. No, definitely not. Your lordship kindly see, my lord. What I am saying is that on 19/8/2016, which is accepted by us, 19/8/2016, I have produced, my lord. He also produced, I have also produced annexure R4. R4 may kindly be seen, my lord. He has admitted the fact of his submission of resignation on 17/6/2016. Yes, madam.
Wait, Mr. You have, first of all, you have not made that annexure. You started reading. Which is the page?
R4. I'm sorry, my lord. R4 I have myself produced along with my statement of objections. 3/7.
Without making annexure.
I'm sorry, my lord. I have already produced it annexure R4 at in the statement of objections, my lord, filed on 3/7/21. Document.
No, you say that which is the page, Mr. It is not marked
page 17, my lord. 1/7.
Angry official annexure mark. Yes, page 17. Now I have to make a marking.
I'm sorry, my lord.
Annexure?
Annexure R4.
Yes. What is this?
This is a letter addressed by him, my lord, to the institution, saying that the above subject earlier, I had submitted application on 17/6/2016 because of some my personal reasons. This is very important. It was withheld.
To read further, Mr.
Now I have been given extension to join for the post of assistant professor at AIMS, Jodhpur. Under extension of time, there are two things, my lord. Under 252B, my lord, he has to seek necessary permission, my lord, by resigning, saying that. So, lien available, I am not speaking about all that. He should indicate his intention to get himself relieved or acceptance and resignation, so as to seek alternative appointment. Now here, my lord, he says extension of time ಕೊಟ್ಟಿದ್ದಾರೆ join ಆಗೋದಕ್ಕೆ ಅದಕ್ಕೆ ನಾನು ಲೋಕ್ join ಆಗ್ತೀನಿ ಅಂತ ಅವ್ರಿಗೆ ಹೇಳಬೇಕಾಗಿದೆ. ಅದಕ್ಕೆ ನಂಗೆ ಅವರು ರಿಸೈನ್ ಅಲ್ಲ, ಇದು ರಿಲೀವ್ ಮಾಡಿ ಅಂತ ಇದ್ದಾರೆ. Because your lordship in the previous document, my lord, on 8/7/2016,
Yes.
he wants to withdraw the resignation. Previous document to page 15, annexure R3.
Yes.
He wants to withdraw. He has already given his resignation. Page 15, my lord, page 15. Resignation to the above mentioned. I had earlier applied for resignation to the above mentioned post due to some unfavorable circumstances in the family. I would like to withdraw my family. ಅಲ್ಲೂ ಕೂಡ ನಾನು ಹೇಳಲ್ಲ, ಅವ್ರಿಗೆ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಗಿದೆ, ನಾನು ಹೋಗ್ಬೇಕು, ಅದಕ್ಕೋಸ್ಕರ ನಾನು ಹೋಗ್ತಾ ಇದ್ದೀನಿ ಅಂತ ಇಲ್ಲ. Hence, I request your kindness to do the needful to withdraw my resignation application to permit me to continue my studies in the present post. Duties in the present post.
You have argued that point, yes. That's all.
ಒಂದು ಇವಾಗ at this stage, my lord, to direct him to come and report, my lord, to duty, it will have a serious consequences, my lord.
You are committed.
He has already been working at Jodhpur, my lord. He is very happy there. Now to ask him to come here, my lord, direct him to be posted here, my lord, definitely possible. And he has also not made, my lord, who has been
there. But you are unhappy about my coming back. That is what we
ಅಲ್ಲ, ಅದು ಹಂಗನ್ನಕ್ ಬರೋದಿಲ್ಲ, ಯಾಕಂದ್ರೆ others are working there. In your post,
don't want me to come back.
In your post,
No, Mr. Gowli. His protector is right, Mr. He can resign and go and join there till she got
provided like in other cases, my lord, and like in other case, provided he makes a proper representation. You lordship, 252B nalli the language is very clear.
Yes, you argued on that point.
The language is very clear, my lord, in as much as to say is where part of a service of which without, with the proper permission anta ide. Resignation of an appointment to take up. He has not made an application to take up appointment, my lord, so as to resign. With proper permission anta ide. Proper permission ಅವರು ಇಂಟರ್ವ್ಯೂಗೆ ಅಪಿಯರ್ ಆಗ್ತದೆ ಅಂತ ಹೋಗಿದ್ದು. ಹೋಗ್ಲಿ, ಎಲ್ಲಿ ಬೇಕಾದ್ರೆ ಹೋಗ್ಲಿ. Another appointment, whether permanent or temporary service, in which counts in full or in part, is not a resignation of public service. This is not a case, my lord, it would fall under 252B.
Yes.
No, he is your lordship kindly see, my lord, there is uncertainty, my lord, while seeking up permission to attend the interview.
Yes.
After the interview, my lord, if he is selected, then he must say, I have. Yes.
Gowli.
Yes, my lord.
See that intention beyond that legislation, that is for giving a protection to the employee.
Maybe, my lord, maybe. I am not at it. I am not.
She has a right to apply for other departments.
Definitely, but I am not opposing that.
She till get confirmed, her right has been protected.
ಅಲ್ಲ, ಕರೆಕ್ಟ್. ಅದ್ರ ಬಗ್ಗೆ ನಂದು ಏನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಇಲ್ಲ. ಈ ಕೇಸಲ್ಲಿ ಹ್ಯಾವಿಂಗ್ ಫೈಲ್ಡ್ ದಿಸ್, ಐ ಮೀನ್ representations on the personal grounds, my lord, he cannot go back so as to seek relief by seeking shelter under 252B. That's my submission.
Yes, that's
so
all.
Unlike in the other case, my lord, it is not a case where he is seeking resignation so as to seek appointment in alternative appointment, so as to have protection at 252B. It's only under personal reasons, my lord, he has resigned.
Yes, we'll consider this.
That's all.
Yes.
May I reply for a short 2 minutes?
Yes, wait. What is that? What point is that?
The respondents had earlier filed the reply. This, my lord, one reply was filed on December 2020 itself. In that, no documents, nothing has been produced, my lord. Subsequently, they improved the case, trying to put some documents which are totally irrelevant for this case. Because ultimately, what is relevant for this case was the document which I submitted a resignation and where they accepted and relieved, which I have produced as annexure F and G are the very relevant documents for this.
Yes,
now, they want to bring the facts back, go back to 2010. Referring to certain earlier
2010 refer
declaration of my probation 2012 ಅಲ್ಲಿ ನಾನು probation declare ಆಗಿದೆ, ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಕೊಟ್ಟಿರೋ resignations ಅನ್ನು ರೆಫರ್ ಮಾಡಿ 2000 and as my learned friend rightly pointed out, annexure R4
Yes, madam. It is very nuisance that yes.
All earlier representations given, by means of latest representation, they said earlier.
Wait, Mr. Government advocate is making the submission. Yes, yes. Yes, what is that? The learned single judge considered this position of law and allowed the writ petition passing annexure, directing the respondent hearing to permit the petitioner to join the post of assistant professional and to continue her in service said post with all benefit. In view of the settled position of law, we do not find any reason to interfere with the same. Yes, that has been confirmed. With appeal has been filed. Yes, that has also confirmed. That yes, here. No, I said that you have wrongly construed his case. You reconsider his case in terms of that judgment of this court. Yes. That Rangnath is not aware that division bench has confirmed. Otherwise, he should have. Yes. This writ petition is filed under Article 226 of Constitution of India. Petitioner challenging order dated 7/11/2016 passed by respondent number 2 void annexure L and endorsement dated 22/7/2017 issued by first respondent annexure S, wherein the request of the petitioner to join the duty has been rejected on the ground that she has resigned that post on personal ground. Brief facts of the case are that petitioner joined the service of Mysore Medical College, joined service in second respondent as a assistant professor on 3/4/2010 for probationary period of 2 years. After completion of this probationary period, the probationary period has been declared on 17/10/2012. It has been confirmed from July 30th, 2012. Thereafter, the petitioner wants to take a job in
James Jodhpur, madam. James Jodhpur, All India Institute of Medical Sciences.
Jodhpur, Rajasthan. Thereafter, the petitioner has secured the job in All India Institute of Medical Science, Jodhpur. Hence, he has submitted a resignation letter on 19/8/2016 to third respondent. Void annexure F. Pursuant to that, petitioner's resignation letter dated 19/8/2016. The respondent has passed an order on 24/8/2016 by the annexure G. Her resignation was accepted. From afternoon 19/8/2016. Thereafter, the petitioner has joined All India Institute of Science, Jodhpur,
29/8.
on 2nd
No, that is
September
acceptance
2000.
penal. 29 is acceptance. ಫಸ್ಟ್ ಪೇರದಲ್ಲಿ 29/8/2016 ರಿಪೋರ್ಟ್ ಮಾಡಿದ್ರೆ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೊಂಡು 29.
When Mr. Joyce?
Penal first annexure H para 1 29/8/2016 I reported in Jodhpur. It was accepted on 29 Lord annexure H.
Yes, he has reported on 29th August 2016. And same has been accepted on 2nd September 2016 by the annexure H. Thereafter, petitioner has not satisfied with this job in All India Institute of Medical Science. He wants to rejoin in third respondent. Therefore, he has submitted a representation on 16/9/2016 requesting the respondent permitted to rejoin duty in third respondent. Wide annexure, impugn order annexure L, 7/11/2016. His request has been rejected. Thereafter, he has also submitted a representation to the government to consider his case for reappointment. The government, after considering his representation by the annexure, has rejected his request. Being agreed by the same, the petitioner is before this court. 3. Ranganath Joyce, Learned Counsel appearing for the petitioner, has submitted that petitioner, after obtaining the permission from third respondent, he has participated in interview conducted by All India Institute of Medical Science, Jodhpur. After he has obtained that appointment in AIIMS, Jodhpur, he has submitted his resignation by the annexure F, requesting the respondent to relieve him from the service since he wants to join AIIMS, Jodhpur. His request has been considered and he has been relieved from the service as per annexure G. He contended that as per section, as per rule 252B of KCSR, since he has resigned his job to take up a new job, his lien with third respondent will continue till he got confirmed in new job he has joined. Since he has not satisfied with this new job, Immediately he has submitted a representation requesting the third respondent to rejoin duty under section 252, rule 252B. His right has been protected. Instead of considering his request for rejoining the duty, contrary to the rule 252B, the impugn endorsement has been issued by impugn endorsement annexure L has been issued by third respondent. Even though he has submitted a resignation to obtain a new job, the authority has wrongly construed that he has resigned for personal ground and issued an impugn endorsement. He further contended that even he has further requested the government to consider his case and he can be reappointed as an he can be
that is
appointed
not reappointment. Rejoining a ಕೇಳಿರೋದು. Kindly see page number 33, my lord. Government
Mr. Gowli.
Yes, my lord.
Where is his representation seeking that government for
Annexure M, my lord.
reappointment?
Annexure N, my lord. Annexure N, page number 34, para 2, my lord. Page 1 and 2, I will read the entire thing. Page number 34, ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ನಾನು ನನ್ನ ಹಿಂದಿನ ಹುದ್ದೆಗೆ ಹಾಜರಾಗಲು ಅನುಮತಿ ಕೋರಿ ನಿರ್ದೇಶಕರಿಗೆ ಮನವಿ ಸಲ್ಲಿಸಿದ್ದೆ. ಇದೇ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ 26 ಮನವಿ ಸೂಚನೆ ಸಲ್ಲಿಸಿದ್ದೆ. ನಂತರ ನಿರ್ದೇಶಕರು 7/11 ಹಿಂಬರಲಿದ್ದು ಅದರಲ್ಲಿ ಕಾರಣದ ಮೇಲೆ ರಾಜೀನಾಮೆ ಅಂಗೀಕರಿಸಿದ ಕಾರಣ ನನ್ನನ್ನು ಪುನರ್ ನಿರ್ವಹಿಸಲು ಅವಕಾಶ ಇಲ್ಲ ಎಂದು ಉಲ್ಲೇಖಿಸುತ್ತಾರೆ. ಈ ಸಮಯದಲ್ಲಿ ತಮ್ಮ ಗಮನಕ್ಕೆ ತಂದರೆ MCRI ದಿನಾಂಕ ಹಿಂಬರಹದಲ್ಲಿ ಪ್ರಮುಖವಾಗಿ ನಾನು ಸಲ್ಲಿಸಿರುವ ರಾಜೀನಾಮೆ ಕಲವೆಯನ್ನು ಉಲ್ಲೇಖಿಸುತ್ತಾರೆ. ನಾನು ವೈಯಕ್ತಿಕ ಕಾರಣಗಳಿಂದ ರಾಜೀನಾಮೆ ಸಲ್ಲಿದ್ದೇನೆ ಎಂದು ಹೇಳಲಾಗಿದೆ. ಆದರೆ ವಾಸ್ತವವಾಗಿ 19/8/16 ನನ್ನ ಮನೆಯಲ್ಲಿ ಏಮ್ಸ್ ಜೋಧಾಪುರ್ ಹಾಜರಾಗಲು ಅನುಕೂಲವಂತೆ ಬಿಡುಗಡೆ ಮಾಡಿಕೊಂಡಿದ್ದೇನೆ. ಬಹುಶಃ ಕಣ್ತಪ್ಪಿನಿಂದ ರಿಸಿಗ್ನೇಷನ್ ಕೊಟ್ಟರು ಎಂದು ನಮ್ಮದಾಗಿದ್ದು ಕಂಡುಬಂತು. ನಾನು ಹೊಸ ಜಾಗಕ್ಕೆ ಹೋಗಬೇಕಾದ ಒತ್ತಡ ಸಮಯ ಈ ತಪ್ಪನ್ನು ಗಮನಿಸಿದ್ದು.
Thereafter, he has given a representation to the government requesting to direct the third respondent to permit him to rejoin the duty. His representation has not been properly considered by the government. Government has wrongly construed that he is seeking for a reappointment, and they have issued an impugn endorsement annexure. Yes. Hence, he sought for allowing impugn annexure. Yes. He further, in support of his contention, he is relied on judgment of this court in case of in WP number 8136 of 2020, disposed of on 13th October 2020. It has been confirmed. Even that has been confirmed by division bench of this court in Writ Appeal number 596 of 2020. You are aware that, Mr. Jaish, judgment you have relied has been confirmed by the division bench.
I have myself told him. I have myself referred to that. He is aware of that.
He is not aware. Otherwise, he would have shown that.
No, he should be aware.
On 25/2/2021, government advocate has placed this, Mr. Yes. For contra, Steve Gowli, learned counsel appearing for respondent number 3, has filed detailed objection, has contended that from the day petitioner has joined to the service, he has an habit of submitting a resignation on personal ground. Even though he has taken a permission, even though he has taken a no objection to attend the interview in IIM, after obtaining the job, he has not made any resignation stating that he wants to join the new post. Therefore, he has resigning this post. On the other hand, he has submitted a resignation on the ground of personal reason. Therefore, his representation has been considered. He has been relieved from the service on his request on personal ground. Therefore, there is no lien to the post which petitioner has holding in third respondent. Even section 252B will not applicable to the case of the petitioner, since he has resigned his post on personal reason, not on the basis of to obtain a new post in All India Institute of Medical Science. He cannot take any shelter under section 252B. Therefore, his request for rejoining the service has been rejected, since the employee once resigned from the service on personal ground, and that has been accepted. Later, he cannot be asked for rejoining the service. He further contended that even after his request has been rejected by the third respondent, he has approached the government reconsidering his case for fresh appointment. He is also admitted that
Annexure N.
Annexure N.
N 512 page 34.
He has also admitted in his representation annexure N that he has resigned on the personal ground due to work pressure. Since he has resigned on personal ground, he cannot be seek relief. He cannot be seek a defense under section rule 252 subclass B of KCSR. He further contended that judgment which relied upon by the petitioner is not applicable to his case. In that case, in case of Dr. Arundhati, yes, where when she has sought for a permission, her request for lien has been rejected. She has challenged the very same rejection order. There, the court has considered that since she has obtained a permission for joining that new post, till she has to get confirmed in the new post, or lien will continue with her earlier post. Yes, in hand, petitioner's resignation has been accepted on personal ground. Therefore, he cannot seek any relief on the ground that his lien is continued his post. Hence, he sought for dismissal of the writ petition. Srimati Nagashri government advocate appearing for respondent number 1 and 2 submitted that as per his resignation, on his request for resigning the post, the third respondent has passed an order relieve the petitioner from the post on the ground that on personal reason, on personal ground, he has been relieved from the service. Since he has relieved on personal ground, he cannot seek any defense under 252 subclass B. Under subclass B, if any employee resign the post for the purpose of obtaining new post in other department, he can seek a relief under this case. In the case in hand, the petitioner has sought for, the petitioner has resigned the post on personal ground. Therefore, he is not entitled for reappointment. She further submitted that even his request for reappointment for taking a duty cannot be considered. She further contended that his request for reappointment is also not to be considered, since he has resigned this post on personal ground. Once he has resigned, his lien is not with the post which he was holding. Therefore, the state government has rightly issued an impugned endorsement annexure. Yes, his request has been rejected. There is no illegalities in endorsement issued by the state government by the annexure. Yes, hence he sought for dismissal of the petition. Or the learned counsel for the parties peruse the judgment, peruse that petition papers and annexures. It is not in dispute. Petitioner has appointed as assistant professor in third respondent institute by an appointment order dated 3/4/2010 for a probationary period. Petitioner probationary period has been declared as per annexure B from 30th July 2012. Thereafter, petitioner has filed an application requesting the third respondent to issue no NOC certificate, no objection certificate to attend the interview in All India Institute of Medical Science, Jodhpur. Pursuant his request, the respondent has issued respondent number 3 issued NOC by annexure D dated 11/2/2016. Thereafter, the petitioner has selected and he has been appointed in AIIMS Jodhpur. Pursuant to that, he has reported to the duty when you have reported to the duty, Mr. He has selected in AIIMS Jodhpur. Thereafter, the petitioner has submitted a representation requesting the respondent to relieve from the service as per annexure F. By reading annexure F dated 9/8/2016, even though in first part of that letter, petitioner has said that she wants to withdraw that by reading annexure F, the letter submitted by the petitioner, it is very clear that the earlier letter which she has given on 17/6/2016 for resigning from the post on the ground of personal reason, as she has withdrawn. Thereafter, she has requested that she wants to join the new post of professor, assistant professor in AIIMS Jodhpur. Hence, she sought for relieving from the post. Pursuant to that annexure F, the respondent has issued annexure G dated 24/8/2016, permitted the petitioner to relieve the petitioner from the institution on afternoon 19/8/2016. There is a reference to that petitioner representation 19/8/2016. Immediately, she has joined the service in Jodhpur on 29th August 2016. It has been accepted by annexure H on 2nd September 2016. Within span of 15 days, the petitioner has requested the third respondent to rejoin the duty. Since she has not rejoined the duty, she wants to continue in third respondent institution. The request is made as per annexure J dated 16/9/2016. While annexure L impugn endorsement, the request has been rejected on the ground that she has resigned the post on personal ground. It is very clear from her resignation letter, annexure F, even though in earlier she has sought for, she wants to resign from the post on the personal ground. While annexure F, she has withdrawn all the earlier application. She has request to relieve on the ground that she wants to join for the post of professor at AIIMS Jodhpur. The respondent has wrongly construed that she has resigned for personal ground. While passing impugn order annexure L, the respondent has not applied his mind. Third respondent has not applied his mind. Even as per rule 252 subclass B, reads as under. It is very clear from above provision that if employee, after obtaining the proper permission for another appointment, whether permanent or temporary, any request for relieving or resign from the any permission is granted relief from the service, he is not in a resignation of public service. He will continue to hold his lien in earlier post till he get confirmed in the new post. In case in hand, even short of within 15 days, he has approached the respondent to reappointment. He wants to continue in the third respondent. The respondent, without properly considering his earlier request for relief as per annexure F, and without considering the provisions of Karnataka civil service rules, the impugned endorsement has been issued. The same is issued contrary to the provisions of section 252 subclass B. Hence, the same is unsustainable. Even the petitioner thereafter has requested the government by representation dated 5/12/2016. He has explained that under what reasons he has applied for resignation, and his request is to permit him to join the service in third respondent institution. His representation has not been properly considered by respondent number first respondent. The first respondent has wrongly concluded his representation that he is sought for reappointment in that institution. The impugned endorsement has been issued. The same has been issued without application of mine. The respondent has not considered his request pursuant to that annexure. Not consider his request, keeping in mind that earlier reason for resign from the post, and also has not considered in terms of rule 252 subclass B of ACSR rule. Hence, that impugned communication issued by the government annexure L is unsustainable, liable to be quashed. Accordingly, the impugned order annexure G and annexure S is quashed. The respondent is directed to reconsider the case of the petitioner in accordance with law, keeping in mind the judgment of this court case of Dr. Arundhati S. disposed of on in WP number 8136 of 2020, disposed of on 13th October 2020. Also, in accordance with Karnataka civil service rules, within 3 months from date of receipt of copy of this order. Yes.
Much obliged.
Now you see that tenor of his resignation. Yes, he has used that earlier personal reason I have been withdrawing. That has been considered misconsidered and say that he has resigned for personal reason. He has made a mistake. When his resignation has been accepted, they have said that one word on personal ground that he has not challenged. But anyhow, his intention is not that. He has to obtain that. Then within 6 months, he has come back. Yes, continue. Yes. In view of the disposal of the writ petition, the applications, pending application will not survive for consideration. Yes. Yes. Yes.
Paying for the petition.
Are not in the panel. Yes. Which this is BDM. Yeah, Sachin, you are there in the BDA. Yes, you take note. Yes. See, Rajaram Suribale Learned Council submit that. Now he is not in the panel. The name may be deleted. Appearing for respondent number 2 to 4. Office is directed to delete his name. See, B.S. Sachin. Learned Council is directed to take notice for respondent number 2 to 4. Office is directed to show his name. You give that petition copy number. Yes, Mr. Santosh.
Please, my lords. My lords, I'll serve a copy upon the council, my lords. A date may be fixed, my lords. It's a covered matter, my lords.
What is this? What is
My
that
lords,
matter, Mr.?
it's pertaining to the acquisition relating to the BTM 6th stage, my lords, where similar orders were passed by this honorable court, quashing
The copy, let him.
Please, my lords. A date may be fixed, my lords.
When do you want, huh? Next week. Yes, 25th. 25th, Mr. Santosh.
Please, my lords.
Yes.
47, Somashekara K. for petitioner, Ashwin S. Saveri, Rahul S. Reddy.
Yes.
My lord, I'm appearing for the respondent number 3 and 4, my lords, in this matter.
Yes. Yes.
My lords, I had sought for the time in the morning itself, my lords. There is some inconvenience for senior today.
No, but you are appearing for whom?
For respondent number 3 and 4, my lords.
Respondent number?
3 and 4.
And 4. Ravi V. Who
Rahul
is
S.
he?
Reddy.
He is a private party. Huh? Subsequent allottees. Yes, Mr. Somsekar, they want. Yes, Mr. Have you produced? 2 more weeks to time to grant to comply with the order. No, it is not me. Earlier as directed. I directed to comply that order. You are not complied, Mr. This order has been passed 24/9/2019. No, that is different. Already an order. Have you seen that order? 24/9/2019. No, first you know what is that order. Is what we will going to produce. 24/9.
24/9/2022, my lords.
22. 24/9/2019. Yes, there is an considered order has been passed. It is not short order. You have to go through that 24/9/2019 and comply. 3. Respondent number 2, Learned Council appearing for the respondent number 2. Press some more time to comply. The directions issued by this court dated 24/9/2019. As a last chance, when will you produce, Mr.? On 3rd March. Yes, finally. No, 10 days means it's Friday. Instead of that, I said Monday or Tuesday. Yes, 2nd. Yes. Huh? 2nd is that Wednesday, Alva? Wednesday. Yes, 2nd. Yes. Yes. Yes, sir. Yes. Now we have briefed the facts. Yes. 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 Your copy is there. Yes. Yes. Yes.
It's 123.
Yes. 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 Yes.
division bench agreed with the single date that there were improper inclusions and exclusions amounting to discrimination. The division bench was of the view that though the single date was justified in holding that there was discrimination in applying, that alone cannot be a ground for causing the entire acquisition of 2750 acres.
Yes.
The division bench also noted JV had not balanced allegations regarding discrimination specifically, and even if their division of the map showed 2750 acres not paid, did not form a contiguous area. Is not good. In particular, he referred to the haphazard manner in which acquisition of deletions, all deletions were made in Kepapura and Srinampura villages. Again, there is a separate entity which is there.
Yes. Yours is which village? Kempapura. Yes.
The division bench noticed that even in other villages, small extents of acquired land are completely surrounded by large extents of areas which are either not acquired or deleted from acquisition, making access to such modified land difficult. In the circumstances, instead of setting aside the acquisition in view of a memo and the memo filed with the BDA proposing certain material measures, division bench decided to give it. Then there was a para 126 again they say
yes.
The particulars of each village the Honorable Supreme Court considers.
Yes.
Kempapura, your lordship should get a serial 1 and page 186. 55
Yes.
1 acres was acquired, 26.33. I mean 38 was the what was modified.
Yes.
The deletion was 38.15. Then we got 127. The
Yes.
acquisition was a planned development of the city to avoid haphazard. But when the layout plan is examined with reference to preliminary notification and final declaration, several starting times emerged. We may first refer to pick and choose method adopted with reference to Kempapura and Srinampura villages, to which the division made specific reference.
Yes.
In Kempapura village, large areas, that is nearly 50% of the area of the village, certain numbers 2, 4, 16, 23, 24, 30, 31 had not been included in the preliminary notification, even though the entire surrounding area has been notified. Only 55.28 was notified in the preliminary notification, but the final declaration was only in regard to 26 acres, 38 acres, and the remaining 28 acres, 15 acres, more than 51% of what was notified. The deleted. After deletion of certain numbers 1, 3, 18, and 33, the entire northern portion, north of the road, bisecting the village, is free from acquisition except part of southern county. Even in the southern portion of the village, there are haphazard deletions. This is reference to Kempapura itself.
Yes.
Then towards 128, the lordships refer. We find haphazard and arbitrary exclusions are in several other villages also, though not to the extent as in Kempapura.
Yes.
Then towards 129, not para 129, the lordships refer. What is the object of BDA's development plan?
Yes.
Then towards all that they say that BDA is not like a private developer.
Yes.
But we develop 1 acre of layout.
Yes.
Then towards please come to 133.
Yes.
If authorities like BDA modify your worship,
Yes.
if authorities like BDA modify 3,000 acres of land for development and then delete from the proposed acquisition, several pockets which are moving to about 1,000 to 1,500 acres, then the result is obvious. There will be no integrated development at all. What was intended to be a uniform 30 acres and 20 acres layout of 3,000 acres will get split into small pockets which are not connected with other pockets or will be intersected by both illegal pockets of private colonies, thereby perpetuating what was intended to be prevented. When the development authority starts developing the last 4 lines,
yes.
When the development authority starts developing pockets of land measuring 2 acres to 5 acres, obviously it cannot provide open spaces and free communities and may end up with one pocket having plots, another far away pocket having a playground, and another far away pocket having a park, and there being no uniformity or continuity of roads. As noticed above, a large layout enables formation of long and straight roads for easy movement of traffic. On the other hand, short and disjointed roads affect smooth movement. Then their logics, record all them, no results. Please come to para 137. This is towards again, if the logics reads the entire thing.
Yes.
What do we say about the development?
Yes.
Where with reference to total extent of a village, 1/3 is not notified at all.
Yes.
And more than half is deleted from proposed acquisition of the remaining 2/3. and only the remaining about 20 to 30% area is acquired. That too not continuously, but in different parts of the pocket. What can be done with such acquisition? Can it be used for other development? Can it avoid haphazard and irregular growth? The power of deletion and withdrawal, unless exercised with responsibility and fairly and will play havoc with other development and will act on haphazard and irregular growth and create discontent among the sections of society who are not fortunate to have the grants. Argument I was here. If your lordship sees the statistics,
yes,
it is nothing but statistics for among the towards the end, the lordship's recorded in the other previous paragraphs. But only one third was notified. In that, you delete half of it. This is how they propose acquisition.
no, after this judgment, another half they have deleted.
Deleted.
Now nothing has been left for.
Yes. That's what has happened. But then, the lordship recorded 139. What were the situations described in the division bench?
Yes.
That was BD was directed to consider the applications by landowners for division.
Yes.
Then please come to in 139, the bottom two lines at page 190.
Yes.
The board directed that the BDA was to face it first.
Yes.
If
Yes.
BDA comes to the conclusion that lands of applicants were released as similar to those which have been excluded from acquisition, their land should also be deleted from acquisition. This direction requires clarification. So
This is that division bench direction.
yes, we will clarify further. That's all. 144.
Yes.
And 149 I will not double your losses.
Yes.
In 145 will give illustrations about positive and negative equality.
Yes.
All that works. Please complete that 145 clause 4 minutes. That's where they see the situation. How it should be considered. Clause 4.
Yes. Yes.
If in a village,
Yes.
in a village, all the lands are notified. And subsequently, all lands except 2 or 3 small pockets are deleted, zero getting high ground.
Yes.
The persons whose lands are acquired can also seek deletion.
Yes.
On the ground that all the surrounding lands have been deleted.
Yes.
The court cannot direct deletion merely because surrounding lands are deleted. As these deletions are illegal and not based on any valid policy. But the petitioners can convey that the very purpose of acquisition had been rendered infructuous by deletion of the majority of lands from the proposed acquisition, and the project or the scheme that ceased to exist and cannot be executed only with reference to their lands. In such a case, relief can be granted not on the ground that there has been discrimination, but on the ground that the proposed development scheme became non-existent on account of most of the land being deleted from the acquisition.
Yes.
This is one of the instances given.
Yes.
Then ultimately consider all the facts.
Yes.
And let's please come to para 159. So I will not take your lordship's to all
Yes.
the other things.
Yes.
To salvage the acquisition.
Yes.
And to avoid hardships to BDA and its allotments, and to avoid prolonged further rounds of litigations emanating from the direction of the High Court, where more equitable way would be to uphold the decision of the division bench, but subject BDA's actions to certain corrective measures by requiring them to re-examine certain aspects and provide an option to the landowners to secure some additional benefit as an incentive to accept the acquisition. A direction to provide an option to landowners to seek correspondence of their lordship's view. Then the conclusion 160.1.
Yes.
One is specifically the sense of as
Yes.
you reconsider, pass a resolution, and place it before the High Court. Whether you want to go ahead with you have to also is included, but I am not concerned with that.
Now that after these directions, they have prepared this plan and
But yes, after this, you are concerned to this.
no, that your contention is the plan has been prepared contrary to the directions issued by the Supreme Court.
What happened is after this, you pass a resolution. So far as Karnataka is concerned.
Yes.
Taking note of the observations of the opposition. Whether to proceed ahead with Karnataka, I'm not saying entire Karnataka. Now, let's proceed with they passed a resolution. That was what was challenged in the earlier round election.
Yes, sir. Yes.
Saying we go ahead with Karnataka. That was challenged along with bringing the facts to the notice of this on the court, which they have not done. Please come to an action here. At page 140, 140. In the report.
Yes. Yes.
So far as this, but these are all extracted from their own records. So
Yes.
they can't be
Yes.
Now, if you watch it, see, into 2003, the acquisition, preliminary notification 55 acres, 13%.
Yes. 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 Yes.
Then in 2004, perhaps, the major notification was 26 acres, 38 acres.
Yes.
It's the order Supreme Court has noted.
Yes.
Then perhaps, immediately before the Supreme Court order, BDA itself, government deleted
Yes.
2 acres, so it came to 24 acres, 12 acres.
Yes.
Perhaps on 18/6/2014,
Yes.
after the Honorable Supreme Court order, they issued a revised notification.
For that they
There
have.
it comes, yes, further deletion of 13 acres.
Yes.
11 acres is retained. That's 11 acres retained. In that, about 4.5 or 5 acres is mine.
Yes.
That you have to get the connection. Please turn to 141.
You are the one who is not fitted to the Supreme Court direction. That is the.
The same petitioner was the only person who was contesting so far as Kapapura is concerned. And my faith is this. At Annexure M, my lords,
Yes.
I pointed out the land belonging to me.
Yes.
21/3 yellow in the bottom notes.
Yes.
20/1 and 20/2 again in yellow portions.
Yes.
Then 21/2 again in lords is on top.
Yes.
Yellow color. And on the right side, one more 21/2 in yellow color.
Yes.
These are the only lands belonging to me.
Yes.
The rest of the surrounding lands admittedly are either deleted from acquisition or not acquired.
Given that blue color is also.
Blue color is deleted.
It is not belongs to you. It is not your property. Somebody.
Is not my property.
Yes. No, none of your property has been deleted.
Except none of mine is deleted. You also see
21
orange portion between 21/2 yellows.
Yes.
That was never acquired. That is where I reside. That's my house.
It is not acquired in that earlier first stage itself.
It was never acquired.
Yes.
So that's other lands, my lands are kept, and below this 21/4 is a lake. So there is no access. There is a lake.
Yes.
But pink color you have to get.
Yes.
That is also not acquired. Anyway, below that is the lake.
Yes.
So my lands are like this. Now that's the entire village, if your lordship is there is either continuity, and this sketch colors tallies completely in the map which I got last time pointed out. Billy itself has pointed a file and map.
Yes.
But in these circumstances, because my land will be of no use.
Yes.
I perfectly follow this report.
Yes.
Now that's the other thing is once the resolution came to be passed.
Yes.
Honorable Supreme Court's order in the Koturam's order pass a resolution facing to the High Court. Now that resolution is passed. So the resolution the BDA said we go ahead with the compromise. BDA has not challenged that part of the order. That is happened finally.
No, that is caused by this court.
But in the previous round, in my impression,
Yeah, Justice B.S. Patil.
B.S. Patil's order.
Yes.
Please come to attention.
No, they are caused and send it back to that.
That is why I had challenged it.
Yes.
If your lordship comes, B.S. Patil's order is.
Yes, yes, I got it.
51.
Yes.
That comes to page 69.
Yes.
That's where the resolution is passed.
No, that resolution in respect of your property is passed.
That resolution pertains to Kepapura villages, only Kepapura. That is what.
No, you have challenged only in respect of your. But, no, but court has not specified that.
Resolution.
Yeah.
Resolution is on record last time I read to my lord.
Yes.
That resolution was not to be said. We go ahead from Kepapura. Not necessarily.
Yes, entire.
Now I found fault with that resolution because they should have updated their mind, which they did not do.
Yes.
Now the honorable, the learned civil judge in the previous question found that resolution that the entire findings are it is because the
Yes, yes.
cannot be implemented in Kepapura.
Yes.
But if your lordship says entire findings law.
No, yes, we have para 17.
Yes, I pointed out
Yes.
where the lordship showed that the entire thing is bad. So as there is nothing remaining.
Yes.
That's why the resolution was passed.
Yes.
Whether it is on my land, if it is confined, I don't have any
Yes.
issue.
Yes.
But once the resolution goes, actually they should challenge the resolution on the platform. They have 25 process and they confine that the observations came. The entire thing in the determined universe which I had that wanted out the vision based order of justice.
Yes.
I had challenged the order of the 11th Secretary only insofar as reminding the map to PDF for the
Yes.
on the ground that once findings are in my favor, there was no necessity. But by that time, they had already passed another order.
Yes.
So they reserve liberty before the division may say, we should be allowed to justify our new order. That's the only liberty they have taken.
Yes.
And liberty is given to them, and liberty is given to them to justify that their order is wrong.
Yes.
That is the first week of my argument. Resolution goes, everything goes. Even otherwise, this is not something which is a disputed fact. The extents are not disputed, or not be disputed. It's a matter of record. It does not dispute words. The extent of deletions or
Yes, that is all admitted. There is no, they can, yes.
Annexure here is a colored map which I have produced.
Yes.
If you watch it compares with the map they have produced, it is one and the same. There is no differentiation. The location, situation is not a disputed factor.
Yes.
Subject to his searching. One more thing to know.
Yes.
The BDA now contains this matter as I submitted was referred to the bench because of the review of the bench is separate. Now the one of the contentions being raised by BDA is the coordinate bench that is the bench has dealt with authority matters and a committee is constituted. We also should be relegated. Which words I disagree with the previous. If I find out words, I will affect and pass down the judgment. Except past date is a big but this matter submission is work. So far as Kempo village is concerned,
yes.
Only 2 repetitions.
Yes.
The largest will get yes. Maybe 14,944 of 2015 at page 200. That's the past date only. That's the second page, or rather, third in internal page 200.
Yes.
WP 14,944.
Yes.
The largest will then have to come to internal page 204. That is related to survey numbers and the account of roads.
Petition 17240.
That's 14,944 of 2015.
Yes. 1.
It continues up to page 204.
Yes.
Just above 17,240.
Yes.
That was the matter related to Kempo coverage.
That is the only matter.
One matter. Then Millards 267, the next page.
Yes.
We have cut out all the
yes. Yes.
267 is WP 2397 of 16.
2397 of 16.
That related to Kempo. Yes. So logic now takes the entire judgment
Yes.
Each case is decided on its own facts.
Yes.
Considered our facts. Law has not been laid on this. That is our humble submission.
Yes.
Now, please come to running page, internal page 662.
Yes.
Then your lordship should get the bottom, WB 5978 of 2016.
Yes.
Please see what it was, the facts involved in it. Petitioners or owners of property bearing 721 or 5 of Kakapama during someone's report seeking declaration that 2016 issued the second correspondent where petitioners are called upon to execute certain documents and undertaking for receiving the lands to an extent of 40% and extent in the ratio of 6:40 for each area. But that is all there. Their contention was basically on certain mechanisms.
Yes.
And para 60, you want to get all those.
Yes.
The issue was related to the parcel of land which needs to be given.
Yes.
And after that, there is no other consideration which I find not so far as the village is concerned.
Yes.
Entire development is first and I will be grateful.
Yes.
The consideration is at which 712 of the entire judgment. I think there's 712 internal page. Just what I request to be examined is whether BDA has complied with directions issued by Commission as clarified that further directions issued by expert in both on sites. All these things, there is no reference.
Yes.
Except there is para 89. In fact, the Honorable Court comes down in BDA. I don't want to point out those things. The exercise is coming down on BDA.
Yes.
All those paras.
Yes.
Ultimately, the Honorable Court at page running para 89 and running page 735.
Yes. Yes.
It is constituted. So one more round, which we do not agree to because we do not want limited litigations.
Yes.
It is constituted. Then all matters are left to the committee. Is it running page 737?
Yes. Yes.
Challenge to the notifications stand rejected and acquisition of land from formation of authority. I have no issue. But what is not what is the merits of the judges order?
No, this acquisition for Arkavati Layout is upheld means what is that earlier notification, entire notification is upheld or it is in respect of
the revised, remodified notification.
Which is submitted to that High Court.
No, that's not submitted. Because what was submitted to the High Court was only saying, I'm going to include even Kempapura and Srinagar. That's all.
Now, what is that notification 2000? This thing?
That's 2004. That was the first final notification.
Yes.
Then what happened was, Mundaram Swami's case came in.
Yes.
So we had to reconsider the entire issues so far as deletion,
yes,
all those things.
Yes.
So they made that exercise.
Yes.
And what they did was they issued something known as revised final notification. Dated 18/6/2014.
18/6/2014.
Yes.
It includes your property.
That includes my property. It was there.
Yes.
And revised notification challenge before in this judgment was BDA had no power to issue a second final notification calling it revised notification. The learned civil judge has made that it is nomenclature is wrong.
Yes.
It is a remodified scheme pursuant to Mundaram's directions and has abided to the But what is not brought to the notice of the court is, so far as Kempapura village is concerned,
Yes.
it was always treated separately with the Honorable Supreme Court.
Yes.
Separate directions were issued that pass a resolution, place it in the court. And rightly or wrongly, the learned civil judge, that is justice, had passed that resolution so far as Kempapura village is concerned.
Yes.
And I am not a party in this entire match. The best custodian of documents is BDA. BDA ought to have brought it to the notice of the learned civil judge so Rightly or wrongly, this is the situation. And has never been brought.
No, now the situation is, again, rightly or wrongly, 18/6/2014 notification has been upheld.
Yes.
Your acquisition is upheld.
Yes.
Yes. Now you are also not disputing for acquisition. You say that since in view of the Supreme Court, even though land has been acquired, there is a provision for deletion. Supreme Court has given a guideline, you delete so and so land. Under that, we are fixing, your claim is under that.
Yes, I went.
That is true. I went, they have not considered properly. That is different. That is your case. You are not disputing about the acquisition of land.
So far as other lands are not concerned. So far
Now that, what is any further direction after upholding? If the learned single judge said, all this has to be considered only by the committee, then is it not any direction if I go in contrary to the directions of the single?
With great respect, it will not be because that's why we were said, was always treated separately.
No, but that is not the.
Because that issue never
No, that's, no, maybe they have committed, but the direction is that entire notification has been upheld. All that land which has been acquired has to be only considered by that committee. Can I direct that BDA to do it your case separately?
I am going one step ahead and saying BDA does not even need to do it. Your lordship should have personally most of us many lands are concerned. Because that was a specific direction issued by the bench, issued by the Supreme Court.
No.
I don't need to go to if your lordship sees the prayer in my request.
Yes.
Because my entire exercise was futile.
No. All this you have having a right. The moment this court has passed an order, then I think they have not bifurcated saying that the case which has been decided are pending, but the court has upheld the entire notification.
That is what has happened.
Then, if it upheld, it is like an additional directions given as per the Supreme Court. They said you decide in terms of this only.
Yes,
Can your case has been excluded and decide?
Yes.
Yes.
But if facts, if the court can again authorized,
yes.
So far as this is how it is. Whether there is litigation or not, this is what we have done.
Yes.
There is a resolution stated. But if the court has been not even been apprised of it, as on date, the decision of BDA to go ahead with, as on date of the judgment in the learned single judge, the decision of BDA in terms of this direction to go ahead with acquisition from Karnataka village and it lost. That was not in existence. If that is not in existence, how do they proceed ahead? Because
No, but whatever they have made a mistake, that has been rectified by the judgment of this court. Is it not? Now they have get the benefit of this. Now they are dealing with this. No, this is an attained penalty.
Because it's a
Yes.
Absolutely justified because I have my own view, but my lord sitting there, I'm
Yes,
concerned whether you should create a conflict between them.
Yes. Yes.
That's what I am trying to say. That if this aspect had never been considered, the law had been recognized.
Yes.
This aspect had not been considered. This matter has to be treated separately. Otherwise, this matter could have been back on in that. That has not been done so far. This was always treated.
Now, one thing, court has not restricted only to the case which is pending before the.
Anyone can go there. That judgment, anybody can go to the committee.
No, anyone can go to the committee, or court said that only committee has to decide.
Committee members, you are not to make come there.
Yes.
The committee is again a recommendatory body. That's my problem. Please come to towards the page 737. Around 91.
737. Yes. Yes.
Committee's constitution is at 89.
Yes.
Now, let's in that, please come to 740 minutes. Different directions in the Roman.
Yes.
It starts from Roman 11.
Yes.
The applicant's reputation is
11.
Roman 11.
Yes.
Who are claiming to be based on state transactions which are taking place subsequent to issuance of preliminary notification would not be entitled to any protection of relief. It is also made clear neither the committee nor the BDA will be required to examine and consider the claim that dispute with regard to title is concerned. Then regards please come to Roman 14.
Yes.
all deletions or demodifications recommended by the BDA or made by the BDA or by the government, subject to certification or approval by the committee, to the effect that such deletion of land is in accordance with the law laid down by division bench and the directions, clarifications issued by the effect court to resolve our service case. It's also made clear that in the event applications and representations having not been submitted by the applicants pursuant to the order of the division bench of our service case, there will be a liberty to submit the same to BDA within 1 month from the date of this order and the present of the said representation or applications which shall be placed by the BDA before the committee comes to the hearing above within 10 days after expiry of 1 month. The community sites earmarked in the maps of some sort, if isolated, if as an isolated plot or island, and such plots is not being adjacent or affecting to the sites formed in account of such lands cannot be feasible for acquisition. And committee will examine such claims and based on physical verification and the reports will be forwarded to the committee to BDA, either to detail such lands for acquisition or recommend for deletion as the case may be. Upon receipt of such report, BDA shall take further steps. Towards Roman 17, we are not concerned because that's relating to all the other things, allottees, wanted sites.
Now that, in terms of the Supreme Court, that committee has been constituted to examine instead of court. This court has to be examined. No. What this court has thought, instead of examining that there is no confidence on that BDA, instead of this court has to examine all these things, it has been delegated to that committee.
When will it end is the issue. The Honorable Supreme Court never said we can't have this protracted litigations again and again.
No, but this single judge order is the coordinate bench order is coming to the.
That's why you are pointing out. Crucial aspect is, can the committee decide today whether acquisition can go ahead with the so far as capable? Because if the resolution you are actually trading up to that resolution.
No, what you say about that notification appeared by this court?
That's exactly. So that is the point here, which will call for consideration before my lord, because this is the issue.
Yes.
That's why I said Kempapura and Chekapura villages were treated separately. In terms of Dugaramas on this case, we have passed a resolution.
Yes,
if that resolution is not in existence, what happens to acquisition? If that goes, if the foundation is not there, the question of acquisition notification surviving in so far as Kempapura village is not surviving. Actually, elections will happen.
No, can I give the finding contrary to that coordinate bench decision? That cannot be Supreme.
Elections will have to consider if that aspect is not even brought to the coordinate bench's consideration. But I can understand if that was brought to the notice.
But
still,
since has been.
If this aspect has remained, consider it. I will not say also. But it is a matter which needs consideration. Otherwise, my entire exercise of getting a resolution passed. The question would be when the committee say BDA so far as Kempapura, you are nothing. Because that is not the mandate given to the committee. But the should say mandate is consider all these things. 5 directions, adjacent plan, demodification, all that. Does the committee have the mandate to say acquisition so far as Kempapura, it is not valid?
No, 2 things. Your first attack is pursuant to the directions of the Supreme Court, the resolution which is placed itself is passed, but subsequently the other single judge has upheld that notification. Now there is, that is how that.
Which I am not a party.
Yes.
But that is why the crucial aspect is in which I am not a party. The rightful authority should have brought into the bench. If that is not brought in, that is not considered. That's why the election should take the jurisdiction is my humble submission to differentiate so far as just practice.
No, it cannot be differentiate your case. If I taken that contention, the entire thing has to go there.
No, only for Kempapura. That's why it's only for one village, Kempapura village. That
resolution is only for the Kempapura village.
yes, exclusively first. Please come to 116 Dugaramas on this case.
No, that is true.
Yes.
That means to say that 11 acres they have sent that
Only
notice.
for Kempapura village.
Kempapura.
That is what
No, that resolution which you have marked as an annexure,
Because it is
T, annexure T, is it?
Your Lordship should get along with page 82 along with the rejoinder. The retribution rejoinder.
Yes.
It starts from 82 communication given to the High Court.
Yes. Rejoinder.
These three words, their own wordings, not me.
Page
82 along with the rejoinder. Running page 82. Rejoinder.
Rejoinder, you have given a continuation page.
Yes,
210. Annexure? Yes, 82, that's the old number. Now this annexure T is 280. Yes, 280.
Yes.
Yes. This is
it's a letter of BDA dated 15/9/2010.
Yes.
Addressed to the Registrar General High Court.
Yes.
The Honorable Supreme Court in judgment dated 5/5/2010 by disposing of civil appeals was pleased to direct BDA as under. This is only so far as that clause.
Yes.
In regard to acquisition of lands in Kempa and Shekapura, BDA is directed to reconsider the objections to the acquisitions having regard to the fact that large areas have not also. Expect in compliance to the said direction, BDA has reconsidered objections to the acquisition as directed by the Honorable Court, and it is decided to continue the acquisition of lands at Kempa and Shekapura villages. The file containing the note from BDA meeting held on 26/8/2010. Resolution thereon, along with directions to note and related file for placing before the honorable bench for appropriate orders.
Now that to issue that modified notification, first they have to submit a report to the High Court. That after that only they have to issue a modification that now that report itself is passed.
This is passed.
Then
what happened was this resolution which they passed. After that, they issued the revised notification.
Yes.
I came before this honorable court challenging that in my previous petition, which is decided in Honorable Justice B.S. Patil.
Yes.
That petition was filed in 2015. Because I was under the impression that they will build Kempa. Once I realized they have not done it in a revised notification, they will include it. I challenged the resolution. This honorable court has passed that resolution. How can it proceed? That is the foundation.
Where is that Bandu Ramaswamy's case direction? No, directions of the Supreme Court.
Yes, 160, please come to 160. In that Roman month.
Yes.
In regard to opposition of lands in Kempapura and Shirapura, BDA is directed to reconsider the objections to the acquisitions having regard to the fact that large areas were not initially notified for acquisition, and more than 50% of whatever that was proposed for acquisition was also subsequently deleted from acquisition. BDA has to consider whether in view of deletions to a large extent, whether development with respect to the balance of acquired lands has become illogical and impractical, and if so, whether the balance area also should be deleted from acquisition. If BDA proposes to continue the acquisition,
Yes,
it shall file a report within 4 months before the High Court, so that consequential orders will be passed. Now, this resolution is what I have challenged, and resolution is satisfied. That's exactly the resolution. If they want to continue, pass a resolution. If that resolution goes, how much it continue? India does not answer this part. But rightly or wrongly, they should have placed these facts. Which unfortunately,
that's what
we
that.
are not parties there. As a private party, I cannot include. The custodian of records is PPA.
Now that when one coordinate bench has passed an order, Constitution bench said, now that question of earlier per incurium and all is gone. Now Supreme Court.
I will not even say your Lordship's coordinate bench. Cannot say the other coordinate benches judgment is correct.
Yes.
But if a fact is not considered and the law is not laid, there are two ways. There will still be two ways.
Yes.
One is the Lordship records this crucial fact which is missing there and refer the matter to the bench. Or the Lordships can still say, because there is no law laid, it's a different facts and two items. What is saying, what is remove this facts. I'm not saying I am.
No, that's what.
I cannot say do this. But there are two options. But one theorem is not a theory to which.
No, that's even. Now rolled out that Constitution bench has said only remedy. Either you follow that your coordinate bench or refer to that division bench. No, here. No, ultimately, court has upheld that acquisition. Yes, that is that.
This crucial fact was not placed before me. But I am stressing on that. This crucial fact of the resolution in Karnataka, I mean, if it was placed and it has been passed rightly, wrongly, there is an appeal. The view could have been, there could have been some other observations before the Karnataka is concerned. It could have been, I'm not saying it could have been. But then that crucial document is not placed before the court. And that is what we cannot find fault with the court. If your lordship gets some document or somebody urges this, yes, your lordship should consider and either accept it or negative it. But if that is not kept away from your lordship, then these things are hopeless. And my often is again I will have to go to the committee, again the same thing, and committees once again they recommend it to go. You again rely on the officials of BD who already given findings repeatedly.
No. Now that committee has to see whatever that now you have argued, that has to be seen by the committee. Committee has convinced that in terms of the Supreme Court, your property is that, yes, it's an island. Then committee has to, if committee has recommended for deletion, then BD has no other options. Only thing is not you have to go before the committee.
Because if a committee, because my first link is always that the resolution is not foundation. That mandate is not going to the committee. Now, if I go to the committee, this resolution.
Now that he has to answer without reference to that resolution, can he has a power to issue a modified notification?
They issued it in 2014.
Yes. No, when he has issued 2014, that resolution was there. Their power is passed from that resolution. Supreme Court said you submit that resolution, then
continue.
Yes. Now that without that resolution, if you demonstrate that yes, he can issue a notification, then things should have been different.
It's a different matter. But if you watch it,
how we will.
Please observe the words used.
That's what I asked you to read again.
Yes. You shall file a report within 4 months before the High Court, so that consequential orders could be passed. Who has to pass a consequential order? Not the BDA.
Court has to
the High Court should have permitted that place you pass the resolution for it. That is not done. That's why HR the resolution. The court says, I passed the resolution. If that is the case, what am I doing?
Yes, let us see.
But that is the issue. That's why I know the difficulties.
Yes. 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 Use Wednesday. Yes. Yes, yes.
Sorry, serial 62. Your options heard that pattern.
Wait, we'll call that list. Yes.
Yes, sir, please.
Yes.
I told you in this 7 acres, there has been subsequent deletion to bring it to 7 acres.
No, now that we are not on that point. Now that question of law is there. Now that deletion is concerned, see, either this court has to decide on the basis of the Supreme Court directions whether your property is landlocked. If it is landlocked, the Supreme Court said delete it. Whether court has to pass an order or directed him to delete is second, or you have to be delegated to that committee. Now the question is, you are attacking on that resolution.
Yes.
Once resolution is not there, then they cannot issue that notification. Then upholding of the single. Yes, that let us see what will. Yes.
Number 45, number 50, Maitreyi Krishnan for petitioner.
Now parted in this thing. Let us see. Yes, that land acquisition matter. This court will not treat any parted. If this court is there, we will hear. After that, we will decide. This is the only a controversy, I think. Otherwise, nothing is this thing. Yes.
Number 50, Maitreyi Krishnan for petitioner.
My lord, serial number, Lord.
Yes, Mr. Clifton.
Yes, my lord.
Yes, we are calling that list by serial wise. Wait. Yes.
Please, please, please.
Yes. Serial number 50. Yes, Mr. Oh, you are there. Yes.
ಅದೇ ನಾನೇ ಸ್ವಾಮಿ. ಇದರಲ್ಲಿ interim order has to be extended, my lord, and date may be fixed.
You are respondent. You are respondent. Yes, interim order granted earlier, if any, is extended. Next date of hearing. When do you want, Mr.? I don't think next week and all. Next week, I don't think 2 or 3 matters. Additional Advocate General has fixed the date. First week of March. Yes. Release this matter on 3rd. Yes.
Number 51, Rajaram is for petitioner.
I am appearing for the respondent number 3, my lord.
What is this? What is this? Yes, Mr. Bhimaya, what is this?
My lord, Roscoe was pleased to direct both the sides to file the status report. I have already filed the status report with regard to the development work carried out by the respondent number 3, my lord. They called for the tender and they finalized the tender and the work order has been issued and they are continuing with the work to avoid the prevent the seepage, my lord.
24th.
My lord, 24th Madison, instead of 24th, any other date. 25th.
24th. Other 24th. 24th. This 23rd. 23rd. Yes. 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 So who is? Yes. Who has to answer? Government. Yes. 20. Yes. 22nd. Yes. 26.
My lord, in this case, sir, I am for the petitioner, my lord, day before yesterday, matter appointment on compensate ground.
Yes, Mr. No, whenever your matter is posted,
yes, my lord, yes,
in hearing some matters, therefore, yes, Mr. Why you are harassing that person?
No, he is admitting my claim, my lord. It may be reserved, my lord.
Only thing is, in compassionate appointment,
struck ಆಯ್ತು. ಸ್ಟ್ರಕ್ ಆಗಿದೆ.
you forget how that brother has a right. You just taking that brothers as a defense, denying. Wife brother, how will come when wife is there?
Already repeatedly discussed by this court for annexer R. The brother is.
That is the. No, rival crime, brother or sisters wala claim ಮಾಡಿದಾಗ when wife is there, that is not a rival claim. That is for denying the right. How can you say whether you are giving a preference to that wife or a brother? I will decide. Why do you worry? You have to give to that one person. Then I will decide. Wife is that first. Yes, day after tomorrow, 2:30.
Yes.
21. Monday, 2:30. Yes, Thursday, 2:30. Thursday, 2:30.
Great.
55 urgent, cell number 56, Javed S for petitioner.
Grateful.
What is this? Huh? No, madam. It is not treated as an apartheid. This court never will treat any matter as a apartheid. He might have said, let him argue that. What is that? I am not passing any order. Yes, what is that, Mr.? Yes. Who is that respondent? Which authority? No, which authority? KPTCL. Yes. Is it his promotion has been denied? Have you filed an objection? Yes. Yes. At the request of counsel for respondent 1 and 2 as a last chance to file an objection, 1 week's time is granted. Now there is a criminal case, Mr. Let him file an objection. Yes. 3rd March. Yes. 2nd. Yes.
57, Srinivasa for petitioner.
Yes, what is this? Huh? No. Oh, it is a fresh matter. No. Yes. Yes. Yes, Mr. Now, see, parents' presence is necessary, Mr. When that is. Yes. You have to kept in abeyance for 2 months, then you will report that instead of. Yes. When, why, Mr. When you have been transferred, order of transfer. 29, 21. Then you see requested for what purpose you have requested earlier? Oh. No, you are taking treatment for what purpose? Yes. Yes. Yes, Mr. Nothing will happen. What is that officer? What is that officer? Who is that officer? What is his duty? Huh? Constable. Nothing will happen for 3 months, Mr. 3 years you have extended. Where is that? He said 3 months. No. You have been given an extension for 3 years. That is what we say. That is, nobody is disputing, Mr. He is not saying that I cannot be transferred. He is saying that please give me another extension for 3 months. You kept in abeyance for 3 months. Then he will go and report the duty. That is what that, Mr. Then within 3 months again. Not mandamus is sought. He has challenging. No, he has challenged your endorsement, Mr. That I have to decide. You can't say infructuous. Alre first prayer nodri. What is that first prayer? Annexure G. Where is that annexure G? Yes. Now, where is that endorsement issued for after consideration? Annexure J. Annexure R3. For transport so and so, personal audience client so and so requested to retain JRC Bangalore looking after his wife who is treatment is risk of pregnancy. After hearing his grievance, he has been permitted to retain JRC for a period of 3 months on extreme medical ground. Mr. On when it has granted? 2011, 12, 1, 2. Then Mr. You could have that time only asked for 5 months. Now yes. Now, when is that date of the delivery date? We can direct them to consider till April 15. Another 10-15 days you can stay with the family. Yes, you yes, you consider that application for this thing. Yes, yes. That's what I am saying. That let him give. Yes. You give that further representation. Yes. Where is that your rejection, Mr.? Rejected. They have extended only 3 months. Yes. In this repetition, petitioner start following relief. Petitioner has been transferred pursuant to that impugn order annexure G. Later he has annexure G dated 20th-9/2021. Later he has submitted a representation to the respondent requesting, where is his representation? Yes, requested to retain the petitioner in GC Bangalore up to June 2022. The respondent has produced that. The respondent has filed a statement of objection and produced that letter dated 29 September 2021 by annexure R1, wherein his request has been considered and he has been permitted to continue in the Bangalore 3 months on the annexure R3 as per on 17/11/2021. He has been permitted to retain in GC Bangalore for a period of 3 months on extreme medical ground. Learned counsel for the petitioner has submitted that. Where have you stated that your wife is pregnant and date has been, what is that material you have been produced? Annexure? Have you produced that document? Earlier, this court has approached that has directed. Earlier. Yes. Learned counsel for the petitioner has submitted that. He has produced the certificate issued by the doctor, wherein she has stated that petitioner wife. What is her name? Savitri. 32 years old with 19.5 weeks. He is under our care for a high risk of pregnancy. Yes. Since he further submitted that, now the doctor has, which is the date, has given 2nd April as a due date for his submission. Wait, mister, when you are deciding, you calculate all these things, month and all. Wait, mister, wait. Yes. Has given a due date on 4th April, 2nd April. Therefore, he submitted that. The respondent may be directed to extend his permission to live in JC Bangalore till end of April. Learned counsel for the respondent has submitted that the petitioner has already availed the benefit on the health ground. He has been granted permission to retain in the Bangalore till permission has been granted to due date has been given in the month of April. Under these circumstances, the petitioner is reserving liberty to submit the first representation to the respondent. The respondent is directed to consider the request of the petitioner sympathetically. You need not tell anything, Mr. You make your submission. Don't tell me that what's the order has to be passed through the court. Yes. Consider that representation sympathetically within 1 week from within 2 weeks from the date of petitioner submitting the representation. Petitioner is directed to submit that representation within 1 week from today. Yes, that is for you to decide. Now you calculate date and all. Yes, till that respondent taken a decision not to implement the transfer order. Yes. Annexure, transfer order. Annexure G. Yes. 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 Yes, Mr. Pradeep, you will dispose of in terms of the.
Please, it can be disposed of. No.
Yes. Only same preliminary notification.
Yes, Mr.
Yes. Is there any land survey number has to be changed? Yes, it is mentioned in the prayer. Yes, in terms of. Yes.
Number 59 Arkan, final year in matter. Number 60, engineer of petitioner.
Yes, release this matter after 2 weeks. Huh? 2 weeks. 2 weeks. Yes. Siddharaju, release this matter after 2 weeks.
My lord, it's a very short matter. 61. 61 is a very short matter covered by judgment. Regarding JP Nagar 9th stage, my lord.
Oh, yes, somebody else. Who is appearing for Ashwin?
Ashwin. Yes, my lord.
Next week, Venkatesh.
Yes,
Let
my
us
lord.
see.
One date may be given.
On 24th.
Yes, my lord. Much obliged.
Number 62.
Malad, 62, Malad, I appear for the connected matters, Malad.
Yes.
Malad, in all these matters, your lordships heard this matter, Malad. Final declaration is not made within 1 year. Award is not passed within 2 years. And Malad is fairly covered by judgment of the Honorable Supreme Court, Malad, in Devendra Kumar Tyagi's case, 2011.
Yes. Chidananda, I heard you last time.
Please, Malad.
Now that
May I pay your lordship to have it on Tuesday, Malad, at 2:30. It will not take more than half an hour, Malad. At 2:30 is at Tuesday, Malad, because all of them can be disposed of.
28th. Additional Advocate General is appearing. Yes, on 28th.
28th, Malad. Yes.
28th.
Please.
63 articles, number 64, B.S. Naik for petitioner connected matter.
64, my lords, appear for petitioner in the connected matter, my lords.
Yes.
Lord, since 18 months I have not paid salary. My lords, the challenge was to the order of suspension. My lords, the authority held in my favor. Against that, the management is, my lords, in writ petition before this honorable court. My lords, I was reverted, my lords, such, my lords, my writ petition is also connected with that. My lords, without, my lords, as an interim measure, I am deputed to another institution working as principal. My lords, I was earlier on deputation. My lords, since 18 months, I have not paid the salary. My lords, after I was deputed for second time. My lord, and I am retiring in 2 months. My lords, that's the urgency. My lords, lordship, my lords, I have at 2:30. My lords, any day I am ready. My lords.
Who has to answer this? Government or
My lords, management is represented by my lords Nayak.
Yes, next 25th we'll see. Release this matter on 25th. Yes.
My lords, at 2:30, my lords, if lordships can
cannot be fixed, Mr. Let us see. Yes.
Please. Or can I make one request, my lords, in hearing on IA, if your lordships can consider, my lords, so that it can be taken up.
No, you filed an application.
My lord, 2 applications are pending, my lords. That's all.
Let us see on Friday. Yes.
Please.
Court officer. Court officer. Sir, serial number 52. Date.
ಯಾವುದು serial number?
52.
52.
ಹಾ.
22.
4673 sir. WP 4673 of 21.
ಹೌದಮ್ಮ 22ನೇ ತಾರೀಕಿಗೆ.
Sir, serial number 63.
63. ಅದು ಬೆಳಗಿನ ಅರ್ಜನ್ ಆಗಿದೆ ಸರ್ 2 weeks ಅಂತ.
Okay, sir. Thank you.